Here we're going to get started. I'm going to walk these doors so people have to come through the back so that we don't have to worry about people trying to work and stuff.
What's that?
I'm going to walk these doors.
Yeah.
I've got signs on them that say this commission meeting is in progress. You have to turn in the back, which is why I have an easel to direct people so that they can't say I was a reminder.
Okay.
So can you let everybody know your mics are fine? Yep. Can we turn them off?
I don't. What's that?
How are you?
They have to, from what I understand, you have to hold that button down.
So my parents are
My understanding is if you playing around with it, you just hold down that button and it'll unmute.
I'm nervous. I'm trying to tell and I like what I know. I like so that nobody gets looked at. I like that. I'm sharing what I know. Share experience. If you want to be quiet, stand up on it. Conversation. You can listen down and turn it off. Once you come in, you let go. It's back on the Yeah, I'm just trying to tell everybody. Yes, matching notes. They're the same color. It's fine. Oh, good. Did you park? Maybe the garage. All right. Thank you. Validate your heartbeat. I like that a lot. Well, it is, and that's it. I was good in that.
Say it again.
Thank you.
Hey, how are you, Richard? I'm all right. So, Mike and Susanna, you're going to have to share a book. That's okay. Yeah. Okay.
Oh, no, it's fine. Oh, okay. All right. I was going to go out some more chairs.
I appreciate it.
Oh, that's all right.
Yeah, but believe me, the folks around the radio house, they didn't have to take things to the words.
Oh, well,
So, yeah,
sure.
yeah, this is a nice turning spot.
Oh, no, that's fine. I was going to discuss.
Just wanted to make sure I'm going to say you bet. Making sure you all know I am here.
Okay, well,
I'm going to look about 18.
right, yeah. Now, you'll have to remind me because this has been changing all morning.
Let me get you. Great. Thank you.
You're welcome.
This is so nice. I'm just organized. He's just like, I'll help you out set up the
There's paid professionals who do this.
I like that. It keeps things in perspective.
It does. Whatever else. When I said you, yeah. Sorry.
Yeah, one of the channels.
Interesting.
Well, I mean, I suppose it's not. You got to keep some control over it. Yeah, I'm just relating. I remember this is mahogany. No, Paul says he's parked. Might be 5 minutes in.
Oh, yes.
Hi, how are you?
How are you?
Good. Good to see you.
Good to see you. Just want to let you know that Paul said he is
Yesterday he get
yeah, he mentioned, yeah, he's got a lot of feelings. So,
What was that on that window?
they'll probably come flying in a moment.
Yeah. And he told me we should all just be ready to go when he gets here.
Yep.
Bring your own pens. I forgot. Yes. They want my perfect.
I put it upstage today, but I tried this. I didn't put this place in any place. They want to
It's like you should have agreed to sit down.
very snatched. I really felt like something.
Susanna, let's do the show. do that. Jen called me, he's like, do I cancel emerging leaders? He's like, are we getting one of them? Good. Happy New Year. Happy 2022. Right? So when I had my start in politics, I worked for you just want to yell, don't you? Get it out. Get it out. Okay. I actually did. That's good. Yeah. Listen. We went up to. And I said, oh, actually, I'm going to stay there one time. And I've never been to Michigan. People cross it. And Jake said, yeah, sure, let's go. I navigated the challenge. So we've been looking for it. Well, but then we were probably 5 minutes old. And that's what got it. The guys are here.
That's, I think,
Didn't ask you. You write that. I've already got mine. No, that was fair. If her answer made I just didn't know. Yeah. I was like,
All right.
This one did. It did. Thank you, Tim.
No, because so
We call a meeting of the Indiana Election Commission to order Friday, February 18th, 2022, 1:30. Here in conference rooms A and B here at Government Center South. I'd like to recognize that myself, Chairman Paul Okeson, is present, along with Vice Chair Susanna Wilson Overholt. We also have Michael Claytor present, who will be a proxy for one of the hearings. Member Karen Celestino Horseman and Member Litany Pyle. We have Indiana Election Division co-staff, Co-Director Brad King, Co-Director Angie Nussmeyer, Co-Counsels Matthew Kochever and Valerie Warchett to my right. We have our court reporter Maria Collier from Stuart Richardson. And before we continue, if you are planning on speaking today, we will ask you to come forward. Please identify yourself and spell your name for the court reporter. As a quick note, I believe initially we had on the agenda voting systems technical oversight. That is not on the agenda today. So if you are here for voting systems, that has been moved to the 24th. So next week is that meeting. So apologies if you didn't get that notice, but we will not be dealing with that subject in today's agenda. Moving on, I'd like to get compliance of the open door law. I request the co-directors please confirm.
Mr. Chairman, on behalf of myself and Co-Director Nussmeyer, we certify that notice was given in compliance with the Indiana open door law, and the agenda for this meeting has been posted.
Thank you. Moving on, we have approval of December 10th, 2021, December 17th, 2021 Lake County Redistricting Commission, and January 3rd and January 4th, 2022 Commission minutes. I recognize the co-directors to present the minutes.
Mr. Chairman, on behalf of myself and Co-Director Nussmeyer, we have reviewed the minutes and recommend them to you for your approval.
Is there a motion?
So moved.
Is there a second?
Second.
Any discussion on the minutes? Any questions? Hearing none. All those in favor signify by saying aye.
Aye.
The ayes have it. The minutes are approved. At this point, I'd like to make sure that we do the administration of the oath. Any person planning on testifying or speaking to the commission today must stand, and please follow the oath issued by Co-Counsel Kochever.
If you plan to testify before the Indiana Election Commission today, please raise your right hand and please I do have a recitation of the oath. Do you solemnly swear under the penalties of perjury that the testimony you are about to give to the Indiana Election Commission is the truth, the whole truth, and nothing but the truth? Please say, I do.
Thank you. Thank you, Mr. Kochever. Okay, today we will be dealing with some candidate challenge hearing procedures. In the past, the commission has followed certain procedures for conducting candidate challenge hearings, and I move that the commission use the following procedures today. When each candidate challenge is called, the hearing will begin by recognizing the election division staff to provide information about the documents provided to commission members, including candidate challenge forms and the notice given to the candidate and challenger. Unless there is objection, the documents provided to the commission by the election division will be entered into the record of this meeting. After the election division staff completes its presentation, the challenger will be recognized first. The challenger or challenger's authorized representative may present their case for no more than 7 minutes, unless the commission votes to allow additional time to the presenter. Commission members may ask questions during the presentation, but the time spent answering those questions will not be counted against the presenter's time. The election division may signal the chair when the presenter's time is up. If the presenter offers additional documents or other evidence not previously received by the commission, then the original must be provided to the election division. I will direct you to Valerie Warcher to our right. The candidate or the candidate's authorized representative will be recognized following the last presentation by the challenger. The candidate may present their case for no more than 7 minutes, unless the commission also votes to allow for additional time. Following the presentation by a challenger, the candidate may cross-examine the challenger. Following the presentation by a candidate, a challenger may cross-examine the candidate. Cross-examination times will be limited to 2 minutes for each, unless the commission votes to add additional time. The cross-examination must be limited to questions regarding statements made by the presenter. Following presentation by a candidate, the challenger may present a rebuttal of no more than 2 minutes. The commission may dismiss the cause of any challenger who has failed to appear or testify before the commission. If more than one challenge has been filed against an individual candidate, the commission may consolidate the challenges but will provide the same amount of time for each individual challenger and equal time to that candidate. Is there a second to my motion for the commission to adopt these procedures for today's candidate challenge hearings?
Second.
Any discussion? Questions? Hearing none. All those in favor signify by saying aye.
Aye.
The ayes have it unanimously. The motion carries. Those are the procedures. We will begin with the Colette challenges, 2022-02 and 2022-04. In the matter of the challenge, John Collette, candidate for Republican Party nomination for State Representative District 43. 2 challenges to this candidate were filed with the election division. Is there consent to consolidate these 2 challenges in consideration for the commission?
Consent.
Karen?
Consent.
Consent. The election division has provided copies of each candidate filing challenge form, attachment copy, notice given the matter in your binders. The election division provided a copy of the withdrawal of the declaration of candidacy filed by Mr. Collette for this office. I therefore move the commission dismiss these 2 causes due to lack of jurisdiction over the matter as a result of the candidate's withdrawal. Is there a second?
Second.
Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
The ayes have it, the matter is dismissed. Next, we have cause 2022-01 in the matter of the challenge to Sabrina R. Bell, candidate for Republican Party nomination for Crawford County Circuit Court Judge. I will note for the record that Mr. Michael Claytor has been appointed to serve as proxy to Vice Chair Susanna Wilson Overholt in this matter. Sir? The election division has provided copies of the candidate filing challenge form and attachments and copy given notice of this matter in your binders. Commission has received a motion for continuance of this matter from the candidate and an objection to granting the continuance from the challenger. For purposes of this consideration discussion, I move that the commission deny the motion for continuance. Is there a second?
Second.
Having a second, any discussion?
What would be the basis for denying the motion for continuance?
Well, we have the challenger here and we'd like to hear.
Oh, the challenger's there?
Yes.
Okay.
Any other questions? All those in favor signify by saying aye.
Aye.
The ayes have it. The motion to deny the continuance is granted. I will now recognize Ms. Atkins, an opportunity to present her case subject to the same limitations as set out in the procedures. You have 7 minutes. Please state your name and spell it for the record.
My name is Rebecca Atkins. It's REBEKAAH, and Atkins is ATKINS.
Please have a seat. Co-counsel Warcho will begin on clock here for 7 minutes. When you're ready.
Okay. Ms. Bell, she is I understand that she is stealing my identity. She's doing false court records. She's forging the court records. She's refusing to recuse herself and allow other judges to officiate the causes. She's obtaining false guardianship cases against me. She will not allow me any access to public court records. When I walk in the county clerk's office, they said the judge says that Ms. Atkins is not allowed any court records. And the law enforcement tells me these are public. And she has the clerk's office shut down Odyssey's public access terminal and those offline systems, so I cannot access these records. That not only are these court records public, I am the named party. She says in her asking for continuance, she said that she's not the judge of my cases. I signed into Odyssey e-file in all 4 cases. She is the assigned judge of the case, according to official Odyssey e-file. She is maintaining my mother on a forged identity. My mother's identity was stolen to her. She was placed on a forged identity.
I'm sorry, say that again, I couldn't.
My mother was placed on a forged identity when she was a young child. There's foster care records. Everybody says those records are public in Crawford County Circuit Court Division. She withholds my mom's legal identity, so my mom cannot legally vote. She filed a habeas corpus. She would not allow me to the court. In July 2019, the law enforcement was having me go to the clerk's office to try to get these records from the clerk. Judge Bell filed a no trespass order with no due process. She did it as a party, and she bring action in court as a party. As a judge, she would have to recuse herself. She did not. She's still the assigned judge of the case. She keeps trying to bar me from the whole courthouse, from public premises, because according to the clerks, those are the judge's records. But she is doing false prosecution. She is participating in false police reports, take my identity and writing up anyone that tries to help me. She writes them up in false police reports, claiming they did horrible things to me, and then she goes in the prosecutor's office, does false prosecution against these people, and I am never served. And when I step in there to get the records, the clerk says, no, I can't have no records. Because Judge Bell says I can't have no records. And if I dare to step foot in an open court to try to ask Judge Bell, she told the sheriff's deputies to order me off the premises or throw me in. And then now she's done this for over 5 years. I mean, she announced her candidacy to run here. That's telling me she intends to do this for another 7 years to me. That's not acceptable. I mean, she is not. She's stealing my identity. She's trying to forge the court cases to make it look like another judge is officiating. But these orders are not served on me. She don't serve those orders on me. She just puts them in the public CCS. I have Odyssey e-file. I can go there, and the case says assigned to Judge Bell. And I filed a judicial complaint just the 1st of February because Heather Fox of the Indiana Supreme Court, who's also investigating this, she said Judge Bell is not allowed. She told me to file another judicial complaint because Judge Bell is refusing to allow any of the judges to officiate. So I do not believe that an individual who is using the judicial office for personal financial gain, who is stealing my identity, making false court records, false lawsuits for monetary gain. And she will not give me those records. Those are Judge Bell's records, not Rebecca Atkins' records. But she's using my name. That's identity theft. I don't believe somebody that's doing that should be allowed to be on the ballot for judicial candidacy.
Is that the
And
summation?
I do not believe that she had training. I believe that she is, and I expressed that to the commission, that she has no intention of ever meeting me in any kind of official meeting where she has to be held accountable. So,
To complete your opening remarks?
yes, if you have any questions, I will answer.
I have a question. Is everything that's been afforded the commission on this case located in this binder in the tab?
Yes.
So I don't,
I have some printouts from Odyssey file showing that she's a signed judge if you need them. I have also a letter from attorney that said there is a well-established guardianship there. But they don't help dissolve guardianship.
let's start with, your first assertion is that you're the victim of identity theft at the hands of Judge Bell, correct?
Yes.
What evidence, was there a police report? What evidence do you have that would support that statement? It's a particularly damning statement.
I have failed in Access to Public Records Act, which I had given them the cause number of that. And to this, I filed that on October 26, 2020. The Access to Public Records Act requires an expedited, which is emergency hearing.
Did you file a police report?
They will not allow me to take a police report until I can get these cases. Because they say I have to have the evidence.
Right. You have to have
But they
evidence. You
did
accuse
say-
someone of identity theft. Do you have any evidence of that?
I did file a forgery
But
police report.
do you have any evidence that Judge Bell has stolen, to use your terms, your identity?
Okay, actually, I do. But I don't have the case. I have an answer from an attorney.
While she's waiting, does anybody else have any questions?
Yeah.
Sure, go ahead.
Ms.
I have 2 copies. And that attorney says it's a guardianship case, which I have no access to.
Ms. Atkins, you said you filed complaints with the Judicial Qualifications Commission?
Yes.
And did they return any kind of finding that the judge was guilty of the things that you're claiming?
They have kept telling me that I didn't have enough evidence. Now, the last one I
Okay,
have.
so let me finish. So, because I see what you're saying, I think I see where you're going. So they did not make any finding because of lack of evidence. They did not prosecute your complaint, correct?
Correct.
So there is no injury or finding of any of the judge's ruling saying that this judge has not followed the law and done these things, correct?
Not that I have in my hands, no, except for they did have, and you filed latest one,
Mhm.
which they have not prosecuted or dismissed at this point.
Okay, so do you realize that should they find that what you're saying is true and that she is not qualified to sit on the bench, even if she gets elected to the position of judge again, she will be removed? I appreciate your passion and everything about this, but Indiana law makes it very clear as to things we can consider. And she hasn't been convicted of a felony. She hasn't been declared to be unqualified to sit as a judge by the Judicial Qualifications Commission. I mean, there is just nothing here that gives us authority under law, I don't believe anyway, that gives us the authority under law to grant your challenge. I'm sorry.
If there's no evidence to support your assertions.
Well, she says she's not a signed judge, and I have these documents that says she is.
She's not here to attest to what you claim she said or didn't say. I'm saying that your claims are not based on any evidence.
And answer her question, she asked. The Judicial Commission and the Indiana Supreme Court says they are very reluctant to try to remove an elected judge.
But they haven't done it.
They have, but they do not wish to do that. And so at this point, before she even gets on the ballot, before she even runs, this is the point that she needs to be removed from the ballot. She should not be allowed to continue to do this behavior to me and run for election.
Well, barring something else that you may have with you, I see nothing that would warrant that request. And with that in mind, I move the commission deny the challenge in this case and direct the election division to include the name of Sabrina R. Bell in the certified list of candidates to be printed on a ballot. Is there any discussion? Or a second?
Second.
Thank you. Any discussion? Any questions? All those in favor signify by saying aye.
Aye.
The ayes have it. Motion carries. Thank you for coming today.
Ms. Atkins.
Will the board turn the microphones on so we can hear better?
The microphones are on. Moving on.
The volume up then?
Yes, this needs to go into evidence.
Can't hear you back.
Yeah, they're not on.
I'm doing the best I can, folks. I don't know. I think they're for recording purposes only. We will now hear case, cause number 2000. You can hear me now, huh? I will try to keep. Hey, everybody's doing their best. Let's keep our comments positive, please. I recognize that we've been rejoined by Vice Chair Susanna Wilson Overholt. We're now here, cause number 2022-09. In the matter of the check. I can't sing like this. And I will apologize in advance. I hope I get the name right. The challenge to Hanifa Khalik, candidate for Democratic Party nomination for United States Senator. Election divisions provided copies of the candidate filing challenge form with attachments and a copy of notice given this matter in your binders. I now recognize, is it Yanni?
Yeah.
Scott Yanni.
Yanni works though.
Well, we'll get it right. Challenge for your presentation. Will you
Take my name.
please and spell it for the court?
Certainly. I'm Scott, last name Yahne.
I apologize. I get the same thing with my last name, so we're good. 7 minutes. Please proceed.
Can I be seated?
Sure.
Yeah, of course, that
Please.
perfect. Thank you very much for entertaining my challenge here today. I am Scott Yahne. I filed the challenge as a registered voter of precinct 35, Center Township in Valparaiso. Specifically, I filed a candidate filing challenge, CAN1, kind of referred to it by the short names, if I may.
Yes.
And I filed that challenge on February 9 of this year to challenge the eligibility of Hanifa Khalik. And the challenge is whether Hanifa Khalik should appear on the May primary ballot as a candidate for the office of U.S. Senate. In the challenge and an attachment, I explained that I had reason to believe that Hanifa Khalik is ineligible to be a candidate because she had not filed a sufficient number of signatures to appear on the ballot, on the primary ballot. Specifically, a candidate for Senate is required to file petitions for primary ballot placement as a candidate for U.S. Senator, and that's a CAN4 petition. So from here on out, I'll refer to those as CAN4s, if I may.
Sure.
The requirement to file petitions comes from Indiana Code 3-8-2-8, and it requires, one, that petitions be signed by 4,500 voters in the state. It further requires that at least 500 voters from each congressional district, each of the 9 districts, must also file or sign their names to support the candidacy on the CAN4. Now, in prior years, I'm aware that by reviewing minutes, that this commission has had cause to consider and act upon challenges arising under 3-8-2-8. In the interest of time, and given that you folks know these issues,
Yes.
I won't go into the detail, but it is my understanding that with good cause, this commission has upheld 3-8-2-8. And that is consistent with the findings of courts, United States Supreme Court, other courts, federal courts throughout the country, that states have an inherent interest, a legitimate interest, to limit the number of candidates that might appear on the ballot. And petition requirements are those kinds of requirements that can be imposed. And then, so, there's some question as to whether Indiana's rule is too restrictive. That's a matter not for Scott to decide, respectfully, not for you folks to decide, but for our Indiana General Assembly. And unless that law is changed, I believe we're all obliged to follow it. And if we change the rules in the middle of a campaign, an election cycle, we wouldn't be adhering to the rule of law, which is a cornerstone of our democracy, and I believe one that should be upheld and honored at all times. So specifically,
Can you move the mic a little closer to you?
oh, certainly, I'm sorry, Ryan can get closer to you.
Thank you.
Thank you. Specifically, in the case of Ms. Kalikan, first of all, let me say it's a tremendous challenge. I mean, it is a difficult undertaking for any candidate to come forward. So, by all measures, it seems like she came rather close. I don't know that she got the 4,500 close, but what I do know from reviewing the petitions, and rather than look at each district, because we have 7 minutes here and I want to move us along.
Sure.
I looked at one district, Congressional District 5. And if I'm not sure the appropriate mechanism, but I do have exhibits to tender to you all, and I had sought to file them last week, but I understand the preference is to bring them here. So I have one original and then 5 copies of the same affidavit. And that affidavit, signed, notarized by me under the penalties for perjury. And I explained in this affidavit how I went about reviewing the CAN 4s that were filed. First of all, I requested CAN 4s filed by the candidate from the division and the commission, the Indiana Election Division and Commission. And I received copies of electronic files that I then reviewed, and there were a couple thousand pages of those. I looked through each and every page. As I described in the affidavit, I described the process that I went through it was important to me to get this count correct. I had seen the county's registration SBRS form that suggested that the counts were low, but I didn't go by that. In fact, that report had a lesser number of signatures than I found when I did the review of the CAN 4s. When I did my search of Congressional District 5 for candidate Kelly, I found that the county official, and there's 3 types of county officials that can certify those signatures, certified 349 signatures within Congressional District 5. And to be counted, pursuant to Indiana Code 38-2-9, the signatures have to be certified by the county representative. And so that you all would have, some ability to kind of check behind and make sure I'm doing this right.
Yep.
I included those in the affidavit that I just sent to you as an attachment. I included images of each signature I located. And as I went through.
Is that the time?
7 minutes.
Okay.
Is there a motion to grant Mr. Gainey any additional time?
So moved. I moved to
Second.
grab him some additional time.
Is there a second?
Second.
But I would ask that you keep it.
Less than a minute. How about that?
Can we have a motion for 2 minutes, 3 minutes?
All right, I'm making a motion for 2 minutes.
We're still like 2 minutes. We have a second.
Second.
All those in favor signify by saying aye.
Aye.
You have 2 more minutes, Mr. Gainey.
Thank you. I determined that there were 349 of those signatures certified. And to make sure that I was counting everything that I saw and had to add, and so when I went back later, I would know if I included it in the tabulation. In my computer system, I marked completed on a digital completed stamp on each certified page that I counted. I also have this, I have a zip file here. And this zip file contains the files that I received in response to my request. And it has denominated page, I added page numbers for the footer on those documents, but the completed stamps also appear in the original files that I was granted with that modification, so that I could confirm the number of signatures that I counted. And so that if anybody wanted to go behind and say, hey, Scott, you missed this signature or that signature, you all can see exactly what I counted. But I determined that there was 349 of those signatures for candidate Cuddy. And that falls beneath the threshold of 500. As such, I would ask the commission, I think, to determine that candidate Cuddy did not obtain the requisite 500 signatures from voters in Congressional District 5. And based on that determination, I respectfully request that the commission determine and find that candidate Cuddy is ineligible to appear on the May 2022 primary ballot. Thank you.
Well timed.
I'm sorry, can I present this?
Mr. Chair,
Sure.
could I move that we grant the Ms. Kalik an additional 2 minutes as well?
Sure, but prior to doing that, she's also offered any 2-minute cross-examination based on anything that he has just said, if you'd like to do that.
Oh, thank you very
And
much.
as you speak, will you please pronounce your name and spell it for the court reporter?
Yes, absolutely. Hanifa Khalik, I'm running for United States Senate, and that's Hanee, F as in Frank, AH, KHAALIQ.
So we'll give you 2 minutes of cross-examination should you want it before doing your 7 minutes of presentation, if you'd like to start.
Yes, thank you.
Please go ahead.
Mr. Scott Yaney, when you filed your challenge against this campaign, were you asked to provide proof of your voter registration? Have you done that at any time? If so, or if not, I would ask you to do that first because you have to be a registered voter, and I would assume that you need to provide some form of proof of that.
Mr. Chair, could I clarify something?
This will not count against your time. Please go ahead.
Okay. It says you're not required to show proof. You can attest it on this form, and I think this form has penalties of perjury. So if you do not believe he is a registered voter, you can bring forth that proof, and then he can be found guilty of committing perjury. But he is not obligated at this point to bring that forward unless he has it and he wants to show it. I mean.
Okay, thank you for clarifying that.
Please continue.
The next question that I have is in your challenge, Mr. Yanni, you
I'm
claim.
sorry, I didn't want to leave a question unanswered. Should I respond to the question, or was the question
I
withdrawn?
think she's withdrawn. Is that correct?
Yes,
Okay.
that's fine. Mr. Yanni, you claim to understand the difficulty of gathering signatures. Did you yourself help collect any signatures
I did not.
for anyone?
No.
Okay. And when you filed your challenge against me, I'm also aware that you filed your challenge against the other Democratic candidate as well?
Dr. McCray? Yes.
Correct. Did you also challenge the individual on the Republican side, according to the report?
No, I did not.
What was your reason for just challenging us two?
Well, first threshold question was whether, and to even ask, whether you would obtain these signatures. I have personally known, I was not asked to do this, but I became aware that it was an issue. I have personally known Tom McDermott for nearly 20 years, so that was my interest in doing this.
Thank you very much.
Does that conclude your cross-examination?
Yes.
You're now afforded 7 minutes. Well,
Move for
9
term
minutes.
to be granted two, yes.
by
Thank you.
consent, 9 minutes. Please go ahead.
Thank you. Well, I'll start by saying good afternoon to everyone, members of the commission, members of the public. I am Hanifa Khalid, running for United States Senate here in Indiana. And it is a pleasure to be before all of you today, perhaps not under the circumstances, but that's all right, we're here. So I'll start off by addressing the statute of limitations as I understand it, followed by concerns with the report Mr. Yaney mentions, and I'll also address the jurisdiction and precedent. I'll conclude with my final opinion. First, I begin with the statute of limitations, and I am open to enlightenment. This is, a new process to me, as well as I'm sure it is to many of us. Mr. Scott Yaney of Valparaiso filed his petition to be a challenger on February the 9th. According to the Indiana Code I read, the commission must hold and conclude a hearing within 3 business days after the challenger's statement is filed. By my calculation, that would have been this past Monday. Today is Friday, February 18th. Therefore, I would ask for clarification with the code, its applicability to my situation. This challenge can be entirely dismissed based on that.
Would you care to, please?
Yeah. Hang on, just.
Is this against my time or?
No, I paused it.
Thank you.
Mr. Chairman, I believe, yes, I believe that the code reference where a 3-day deadline for the commission to act can be found in Indiana Code 3-8-8, which is a challenge procedure. But if you look at 3-8-8-1, which if you have the red code book here, you can find on page 285, that section 1 provides for the application of this chapter. And it provides in subsection A, this chapter applies only to a candidate for election to any of the following. 1, a legislative office. 2, a state office other than a judicial office. Both legislative office and state office are defined in the election code under 352. You'll have to give me a moment to look those up to tell you what those are, unless one of the other members of the staff of the election division can provide that.
May I go on? Next, I will address the fact that Mr. Scott Yaney of Valparaiso bases his challenge on an unofficial report, subject to a high probability rate of human error. Indiana Code 3828 states in part a declaration of candidacy for the office of United States Senator must be accompanied by a petition signed by at least 4,500 voters. Although I believe the campaign made this month, the report fails to establish this for a number of reasons, which I now wish to express. First, the unofficial report is repeatedly noted as such by the Indiana Elections Commission in all of its communications. It is well known by the candidates that the unofficial report, and I'm just guessing it's called that for a number of reasons. Again, correct me if I'm wrong, I'm open to enlightenment, but to my knowledge, no county clerk's office was required to use the system in the first place. Second, on average, it took at least 2 to 3 days for county clerk's offices to enter the data, depending on how many signatures they had to enter. This window of time was often extended by various things, technical issues, COVID-19, inclement weather, people calling out sick. The county clerk's office also stopped entering data after February the 1st noon, although they received petitions up until noon that same day. We know this because on February 2nd through the 3rd, our numbers stagnated. We know we had several hundred signatures come in on February the 1st that met the deadline. Despite this, again, our numbers froze at 4,473, and the same count was rendered to us on February 2nd and February 3rd. Now, while I appreciate the clerks and all their hard work, to my knowledge, there was very little oversight throughout this entire process. I often found myself questioning the process as I went about it, asking myself questions like, how could we know if someone who had access to the voter rolls wasn't just forging names? How could we verify all candidates started the process at the same time when there's no special timestamp or marking to tell us otherwise, and that the signatures are fresh and not taken from a previous run for office? I also question, what about protecting candidates from county office staffers who may prefer one candidate over another? How could we honestly confirm the integrity of the system? The process was not uniform. For example, some clerks had us fill out information to come back and pick up the certified petitions, some didn't even know who to call, some allowed us to mail petitions in, some did not. Finally, no official report was ever provided to me or any other candidate at any time, and I received no instructions on how to request one, if available. I have certified and sealed petitions with me right now that the Indiana Elections Commission returned because they allege they received them after February 4th. That's fine, okay? But if the petitions have supposedly already been added to the unofficial report, why wouldn't the commission want the actual evidence of that? I don't know. Therefore, all things considered, I humbly ask again the Indiana Elections Commission to dismiss this challenge based on the overwhelming number of challenges and imperfections the process itself faces and the number of circumstances that may be out of one's control. Next, I will address jurisdiction. I turn your attention to the language written in the 2022 Indiana Election Administrator's Manual concerning challenges. On page 37, it reads in part, the challenger must be a registered voter of the election district that the candidate seeks to represent or a county chairman in which any part of the election district is located. I presume mentioning the district is important. Mr. Scott Lee of Valpo, I'm going to skip that part. Even if he has proof of his registration, which I asked for earlier, does Mr. Scott Lee have a right to bring a challenge on behalf of all the other districts which he is not a registered voter in? Even according to the unofficial report, which I remain skeptical of, I brought in well over the amount of signatures required in the first district which he is from. Therefore, I would ask the Indiana Elections Commission again to consider dismissal until Mr. Scott Lee or the commission can provide that he can in fact bring a challenge on behalf of other districts he does not live in. Finally, I will use my final moment to affirm my belief in the Constitution of the United States. Now, like the others, I could have raised a challenge too against any of the candidates. I did not, because I believe the three requirements outlined by our United States Constitution to run for the United States Senate is sufficient. That you be 30 years old, that you live in the state you want to represent, and that you be a United States citizen. Even if I supposedly made the numbers according to the unofficial report, I will still have unanswered questions about this process. If you combine all the signatures from all the candidates in the Senate race, even according to the unofficial report, together we collected nearly 17,000 signatures. That's 3 times the amount of the incumbent. Additionally, we raised nearly $250,000. The evidence is overwhelming that Hoosiers want to see competition on both sides of the aisle. Most Senate candidates across the country right now are squaring off. Here, as we sit here, giving the incumbent what I believe is a head start. Therefore, I call upon the IED to consider all these things I've just stated, including precedent and how it was possible that Senator Todd Long survived his challenge, and to recognize a document long held as the bedrock of American democracy and allow my name to remain on the ballot. Thank you.
Thank you. Would you like your 2 minutes of rebuttal? Cross-examination. Yes. 2 minutes.
Thank you. Did you file, I'm sorry, Ms. Coley, did you file a declaration of candidacy at CAN 2 form?
I did.
And you must file that form to declare your candidacy for U.S. Senate.
That's correct, yes.
And that form indicates that you need to submit the CAN 4 form, correct, with signatures?
Well, you're just stating the process, I don't know what this is for, just get to the question.
I asked you, did you file that?
Well, you know that I filed all the documents.
And did you certify?
Go ahead, this does not eat into your time.
Right, I would just ask that, so far this has been civil. I
Sure.
would ask that that continue. He's
Well-
just asking a question, if you could just.
No, that's fine, I thank you.
Proceed.
And as was the information in your declaration of candidacy true and correct?
Yes, it was.
And there's a statement in there that you met the specific requirements for this particular office.
I absolutely did, yes.
And one of those requirements is 500 signatures within each congressional district, correct?
We all know that. Thank you.
Did you secure 500 signatures?
I absolutely did. I
Can I finish
absolutely
my
did.
question?
Well, I thought you were done.
Did you secure
I did.
500 signatures?
I did.
in Congressional District
I
5?
absolutely did.
Did you file those?
Well, I just explained that a number of signatures, in fact, several hundred signatures were turned in on February the 1st, prior to the deadline. Now, I also explained that it took on average 2 to 3 days for those signatures to be entered into the system. I don't have any control over that, and it seems here that nobody does. And there was no official report ever given. So again, I'm answering your questions. I really don't know why we keep circling back around. That's all I have for you.
Good job.
My question was, did you file with the commission or the division 500 certified signatures certified by the county?
I absolutely did. I absolutely did. And I can't help but report the unofficial report that you're getting.
That concludes your cross-examination.
Thank you.
I'm sorry.
You also have the opportunity for a rebuttal to this cross-examination.
I don't have any rebuttal.
Do I have the 2 minutes rebuttals?
No, you had your cross-examination. She's afforded rebuttal. You brought the challenge. She's responding to your challenge. You're not afforded that same.
All right, I'll be quiet, but I was reading just so for further clarification.
You've already established the rules and procedures that have been adopted by motion and voted on. So those are the procedures for these hearings.
I was reading those procedures, and it does provide a challenger has 2 minutes of rebuttal, but I'll wait it. I mean, I'm not going to stand on it right now.
I believe we afforded a challenge. The challenger brings the case. We did not in the procedures afford the challenge a 2-minute rebuttal. Did we?
I can give you specific reference to the minutes, but if not, I can let it go. I think you better.
We'll make sure we're doing it.
Check what we adopted today.
That's what I'm doing. You're correct. I stand corrected. I'm sorry. You are afforded 2 minutes of rebuttal. Although I'm not sure you would be rebutting, but go ahead.
Just one aspect. I think it was clear to the commission that my report to you in the affidavit that I filed was not based on an unofficial report. Rather, it was based on the very canned-for declarations filed by candidate with the division and the commission. Those certified signatures that are referenced and the images contained in the, as appended to the affidavit, those are the official designations. That's not an unofficial record.
What I hear you saying is what was filed by the campaign confirms to you that there were not 500 in Congressional District 5 filed, correct? That was that.
I believe she said that.
I'm just clarifying, sorry.
She said I based my determination on an unofficial report, the SVRS report. My report, I found more signatures in the official filings than I did in the reports, the unofficial report she's referencing.
Neither of which came to 500 in Congressional District 5,
No,
which is
not even
yours.
close.
Okay, thank you. Anything else?
Nothing.
I have a question.
Well, I'll close the public portion of the hearing, so go ahead.
So Ms. Kalik, did you bring the copies of the petitions with you today?
That were sent back to me because of the deadline, February the 4th, or the ones before that?
All of them?
Oh, they were all turned in.
No, did you bring those? I guess what I'm asking, do you have those with you today?
No, because they were turned into the Indiana Elections Division already.
Okay. Do you have copies of them at your campaign headquarters or anything?
Well, I can ask for them back.
Okay, well, then my next question would be, did you personally count the signatures for each of the districts?
All the ones that we turned in, yes, and the ones that we also received after that, the Indiana Elections Division would not receive because of February 4th. And again, I don't understand that process, because if you have an unofficial report that all the county clerks don't even use, why wouldn't you want the evidence of
And I
that.
appreciate, that's not what I'm
Yeah.
asking, I'm just
Oh.
asking whether you individually counted these signatures.
Yes, we did, yes. And we know that they came to the correct amount. So again, the discrepancy is in the report and the same report that he stated that he's basing his challenge off of. And, you know, like I said.
I want to
Oh, I'm
keep you
sorry.
to the questions I'm asking, but I mean, but he has testified that he's not, what he testified to, and what he just argued is that he wasn't relying on the report. He actually went through and counted all the signatures.
From where though?
For District
Where did
5.
he get them from?
It says in his affidavit, he says that he received digital copies of the petitions.
That's of my petitions? Absolutely not. Absolutely
Well, you
not.
don't need to.
Well, I'm sorry, absolutely not. He could not have, because my campaign is the only campaign that has digital copies of our own petitions. So I don't know why he's saying that. I have no idea. I don't know how he would have gotten additional.
No question.
Okay.
Okay, my turn.
Please go ahead.
Thank you. So you went and got copies of the digital copies of the petitions. Where did you get those from?
I made a request to both the Indiana Election Commission and the Indiana Election Division for any CAN 4 forms filed by the candidate.
And do you recall the date when you received those?
Yes. It was soon after the filing, I believe. I made the request, I know it was on a Monday, maybe a Sunday, actually.
So you received them after the 4th, the deadline for
Yes,
filing?
after I made the request on the 6th. I think I received digital copies on the 7th or 8th.
So, Ms. Khalid, how many, for the 5th congressional district only, how many certified signatures did you have on your petition? That
Okay,
you filed with the election division by the deadline
Right.
January 4th.
okay. So on January the 31st, there was a number that was given to us from Indiana official report. Now,
Indiana official report.
the unofficial report that we received from the Indiana Elections Division staff nearly every day,
Telling you what, the status of the,
telling us the number
okay.
of signatures that supposedly came in. But again, there were so many different variables, and some of those signatures weren't even counted on the same day that we turned them in. As I stated earlier, there was an average of maybe 2 or 3 days turnaround time for those numbers to be entered.
Okay,
Now,
but go back to my question.
I am,
How many signatures had you turned in that you know of that were certified by the deadline date of the 4th?
so on January the 31st, we had a number of signatures given to us. Wait a minute, if you let me finish.
Excuse me, we are here. You do not cut in on us and everything else. So,
I'm trying to answer
no,
the
I
question.
understand that. Go ahead and give your answer. I mean, I just need a number. Go ahead.
I'm trying to answer the question. So on January the 31st, there was a number of signatures that came in from the unofficial report. You have January 31st, you have February 1st, you have February 2nd, 3rd, and the 4th. On February the 1st, we had hundreds of signatures come in now, hundreds of them. They were not counted and included in the unofficial report. Now, on January the 1st, I still needed 154 signatures. I knew that I had 200 signatures coming in from that district on February the 1st. They were not counted. We received the same numbers, the same count on February the 2nd, the 3rd, and the final report we received was on the 4th. Now, Saturday, Sunday, Monday, Mr. Scott Yanni just stated that he got the report on Monday. Do you realize that there were many county clerk's offices that were closed up until the 7th of Monday? So I do not know whatever information he got, I do not know that it included those petitions. Now, I handed in a number of additional petitions on the 3rd of February.
Okay, what I'm trying to ask you is this. Number one, for the 5th district, which you knew was an issue here, you do not know which clerk's offices were closed on Friday due to bad weather. Isn't that right?
That is correct.
So they could have all been open. Number two, as far as the number of petitions submitted, you said, you acknowledged that in a few days before the 4th, you knew you were under. But you said there were supposed to be 200 signatures
There were,
voting in.
yes.
So who was submitting those? If you did, were you submitting those personally?
Well, there were petition carriers.
Okay, so you relied on your petition carriers. Have you got a verified statement or anything from them that shows that they submitted those petitions?
Yes, we
Okay,
have all
what is that?
records. I don't have it with me today, but I do have records of the number of petitions that they handed in and the number of signatures.
Do you know what counties they handed those into?
I don't have that information in front of me, but I can prepare it.
Okay, so you see, you see our problem. This gentleman got the petitions from the election division and went through and hand counted each one and came up with a number that gave you credit for 6 more, however many more than the election staff gave you. Now you knew you were coming to this challenge today on this. And so if you had brought us the people who said, I went over there and turned them in, or they refused them, or if you had brought us the copies of those petitions showing that what happened, evidence that could somehow contradict this, that would be another matter. But we don't have that here in front of us. So I'm sorry, without that kind of evidence, and by the way, I do want you to know, I've heard wonderful things about you, and I think we need more women, strong women to do this. But as an officer of the court and a member of this body, I've taken an oath that I have to uphold the law. And the law clearly states that you have to have 500 signatures per congressional district that are certified by the court.
And ma'am, I understand that. I certainly do. And I appreciate your kind words. But I must reemphasize the fact that the report that was obtained by Mr. Scott Yaney on Monday, February the 7th, or whenever it was an unofficial report.
He's not relying on that report.
But he just stated that he was.
No, he didn't. He said, go ahead.
Have you looked at the affidavit that he provided?
I was not provided with it until today.
Well, we were too, but I think the reason I'm asking you that is because if you look at this, you'll see.
On page.
Well, they're just flipped it, just open it halfway through, and you'll see.
Can you just tell me the page number?
It's on the petitions.
It's page, it says 86 of 243, I don't know what page, that's the
Yeah.
actual page. If you just flip through, they're all kind of the same, but he's not relying, you can see from this that this is looking at the actual petitions that were filed, not looking at the unofficial.
Right, I understand, but he still got this scan from someone. And I'm almost sure that he got it from someone who was, again, they had received these petitions on the date or up to the date that they got them. This does not include the petitions and signatures that were turned in up until noon on February the 1st. We had hundreds of signatures come in on February the 1st by noon. And they were not included in this because, as I stated before, on average, it took about 2 to 3 days for the correct information to be entered in, and that would have included the petitions. So again, I am trying to make the point that you had closures, you had county clerk's offices that were closed up until the 7th, some of them, of February due to the inclement weather. You had people who were out sick. You had individuals who, the system was so imperfect. And then you even had county clerk's offices who did not participate in this process entirely.
I think the difference is that you're making assertions through your own statements here without bringing any evidence.
They're actually not assertions, so because we know that these,
Proof
we
of who is
know that these
sick,
county
not in
clerks,
attendance.
we know that these county clerks' offices were closed due to inclement weather. Marion County was closed, Tippecanoe, Morgan County, Johnson County didn't even know who to send the petitions to.
Ms. Kalik, I would just, so the significant factor here is that Mr. Yaney has focused on a single district, which is District 5. I mean, he gave, I mean, and what he filed with the commission before today, you know, he listed his the counts for all of the districts. He's focused on 5, which shows a shortfall. There are other districts here in his counts that show a shortfall. And our questions to you today, because he has focused on District 5, our questions are focused on District 5, because it is true. I mean, you could have gotten, as it looks like you did, you know, you get more than the 500 in some districts, but that, well, unfortunately, our system doesn't work where you get to carry over. It's not just a total of 4,500. It's got to be the 500 from each congressional district. And that, in this body, we don't have the authority to change that. You know, it is that 500 signatures per district. And I know, I mean, I've helped collect signatures in the past for these petitions, and I have signed petitions in the past knowing that it's a big deal and difficult to collect all these signatures. But today, what is important is for you to provide us with concrete evidence that with respect to District 5, that there are another 154 signatures.
There absolutely are.
Well, no, but we need to see them, or we need.
They were handed in to you already.
Okay, may I,
Please.
okay, the candidate was responsible to getting 500 certified signatures to the election division by noon on Monday. Are you saying?
On Friday.
Friday, sorry. Are you saying that you delivered 500 signatures and the election division did not process that?
I handed in all the petitions that I had by February the 4th, that noon deadline. In fact, I turned those in on February the 3rd.
That wasn't my question, Ms. Cleek. My question was, are you saying that you turned in 500 signatures on that date and the election division staff did not process those or did not include those?
I am absolutely positive.
For District 5?
That is correct.
Okay, so there's now been a question raised, Mr. Chair, about the election division staff. Maybe we should ask them to speak on this.
Well, I'd absolutely entertain that. Co-Director Nussmeier, would you like to?
Oh, certainly, Mr. Chairman, members of the commission. My name is Angie Nussmeier. I'm the co-director at the Indiana Election Division. I met with Ms. Kalik when she came in to file at the office. I believe it was on Thursday during the inclement weather, and received her CAN 2 and her CAN 4 petitions that had been certified by the county voter registration officials and were required to be filed in our office before noon, Friday, February 4th. Our office was open, and so we had that deadline until noon, Friday, February 4th, to receive those petitions. My counterpart and I and our teams have allowed candidates to amend their filings up until the deadline of noon, Friday, February 4th, and I don't recall receiving any additional petitions from Ms. Kalik directly, but I'm certain that we had some that were mailed in or delivered from other folks to our office. Our team
Received after the deadline, you're saying?
No, received before noon on Friday, February 4th. We received petitions after Friday, February 4th at noon, which under state law, we are required to reject because state law says you must reject a filing if it is after the deadline. We have no discretion about whether or not we accept or reject a filing that is received after a deadline. My team file stamped every single petition that was filed by Ms. Kalik and by mail and received by the office. We scanned in every petition. It is public information. Any person could request a copy of the CAN 4s that were certified by county voter registration officials and filed by the candidate or candidate's representative or by mail by noon Friday, February 4th. The Commissioner Overholt and Commissioner Celestino Horseman did direct our staff to review the petition signature counts because that was a challenge brought forward today for a couple Democratic candidates, and my staff serves the Democratic commissioners, and we found actually a lesser number, 338 signatures that were certified by county voter registration officials and filed with the Indiana Election Division on or before the Friday noon deadline
For Congressional District 5.
for Congressional District 5. Correct.
For Hanifa Khalil's candidate.
Correct.
So less than the number established in Mr. Yaney's 346.
Correct. It was a review of all the certified petitions that were filed and received by our office by noon Friday, February 4th. So that was our staff's count of those petitions at the request of our commissioners, given that
May I
was the
say
count we got
something,
forward
please?
today.
Just one moment. Co-director, do you have anything to add?
Mr. Chairman, members of the commission, I have very little to add other than to say, to my knowledge, the statements made by Co-Director Nussmeier are entirely correct and accurate. The Republican staff did not conduct the signature count review that was referenced, but it is a common practice in our office to do so in candidates running for statewide primary nominations to do so. And so I have no reason to think that there's anything inaccurate in what Ms. Nussmeier has said.
I'm sorry, if I may
Please,
just add to
please,
my
please.
comments
Go
and to
ahead.
what Mr. King raised as well. Under state law, we don't have authority to reject a can-do from a U.S. Senate candidate or a statewide candidate like governor who are required to collect these petition signatures to run in the Democratic or Republican Party primary, as long as that can-do is accompanied by the certified can-for petitions from the county voter registration office. We do not perform a count unless there is typically a challenge brought forward. That is the mechanism under state law. There is no mandate for the staff to count those signatures. But when there is a challenge that is brought forward, we often do the review for our commissioners to ensure that they have the best available information as they go through this process and to inform their decision making.
Knowing how thorough both you and Mr. King's operations are, what I hear you saying is the official count that you have is 338 for Congressional District 5, filed by the deadline.
Based on the certified petitions filed in our office by noon February 4th, as certified by county voter registration officials on their attestation found on the back of the can-for petitions.
May I say something, please?
I'll give you 30 seconds.
Okay, again, the IED received these scam petitions from somewhere, and they received them from the county clerk's offices, am I correct? So, okay, but you received them, okay,
We got them from you.
right, and
Is it- So you've already made statements to that effect. If there's anything new to add, sounds like we're going to the same.
I would just say that the IED depends on this unofficial report collected with what I turned in, am I correct? On before February the 4th. So then why send the unofficial reports to us all?
Okay.
Why use that as a mechanism
Mr.
for
Chairman.
information?
Ms. Kalik, you asked me to send you a copy of the report because you understood that it was a public information and an unofficial report. So you personally reached out to me for a copy of the report as I send out to my state central committee and others who request that public information and explain in every email that it is an unofficial report and that what matters are the certified numbers found on the back of each of the can-for petitions. So you received that report because you made a public records request of me personally.
And again,
Thank you.
okay,
And I just want to clarify once and for all what, Ms. Nussmeier, when you and your staff counted the what you counted at the request of myself and Ms. Celestina Horseman were the actual certified petition numbers, what you just described. You did not rely, this number that you came up with is not relying on the unofficial report, it's relying on your review of the actual certified petitions.
That is correct.
So we have closed the hearing on case number 2022-09. We've had some discussion and some questions. Any further comments? Would anyone like to offer a motion?
I
To uphold or deny the challenge?
right, that's what, thank you for reminding me how we phrased this.
may I ask another question?
I'm sorry, we've closed the hearing.
Okay, thank you.
I'm not affording him any additional time yet, just equity and fairness.
And I move that we uphold the challenge due to the fact that at least with one congressional district, that the 500 signatures were not contained as required by law.
There's a motion. Is there a second?
Second.
Any further discussion? Any questions? Hearing none. All those in favor signify by saying aye. Aye. The ayes have it. The motion to uphold the challenge carries. I direct the election division to not include Hanifa Khalik on the certified list of primary candidates sent to the county election boards and indicate the name of this candidate is not to be printed on the ballot. Thank you. Next case, we have, remain there, Mr. Yaney. Yaney versus McCray, 2022-8. The challenge to Valerie McCray, candidate for the Democratic Party nomination, also for United States Senator. Again, the election divisions provide copies of the information in your binders. Is Valerie McCray present?
Yes.
Thank you. Do you understand the procedures we went through on how we'll conduct this hearing?
Yes.
Yes. I'll first recognize Scott Yaney, the challenger again, for 7 minutes.
May I have a question?
Can you get closer to the mic?
Yes.
Sorry.
Will my prior testimony be part of this record as well, so that I don't need to repeat certain elements? Or shall I start as though I am not?
Why don't you tell us, just as you go along, yeah, incorporate my remarks.
You're certainly welcome to an executive summary.
Okay, very well, thank you. Very well, I am Scott Yaney. I am a registered voter. I vote every election that I'm able. That's precinct 35, Center Township, and Valparaiso. I am in Congressional District 1. I did also file a Can 1 concerning Dr. McCray's candidacy. Likewise, I went through the summary requirements that a candidate must file Can 4s to be placed on the primary ballot. Same threshold applies, 4,500 voters in the state, 500 voters from each congressional district. And this law is binding on all of us. It wouldn't be fair to afford one candidate one set of rules and another candidate another set of rules. As we've heard, it's not an easy process, and it requires devotion of considerable time and resources to obtaining these signatures, as opposed to going out and perhaps speaking to folks or doing the other things that are part of campaigns. In this specific instance, for Dr. McCray.
Can I, just one kind of question, are you again also identifying a single congressional district that failed?
I am,
Okay.
yes, Congressional District 2.
Okay, thanks.
Again, I looked at the official records, and it was noted, I did come to the same number you did. There were a couple of instances where either the number wasn't drawn clearly, it wasn't entirely certain whether a voter was rejected. In a couple of instances, I voted to increase what perhaps the number was cited, just so I gave the candidate every benefit of that. And that was my goal throughout, to make sure that I was as comprehensive and as absolutely as fair as I could possibly be to the candidates when doing this count. I do have an affidavit that I'd like to present, if I may.
Is this additional evidence not already offered?
Correct. This is for candidate McCray.
Thank you. Thanks, Valerie. Let the record reflect that we've accepted additional information.
And I might ask that my prior remarks be incorporated in the record so I can speak somewhat more quickly succinctly regarding this affidavit. But this affidavit is similar to the last affidavit that I presented to you, and that I included images from the specific Can 4 forms filed by the candidates. And in this circumstance, I focused on Congressional District 2. And I determined, as is set forth in my report, and there's a worksheet that I prepared in Excel and to which I affixed each image of each signature that I found that candidate McRae obtained 62 signatures to support her candidacy in Congressional District 2. The information, try to be very comprehensive and try to understand all the information. I can ultimately only look to records that are filed with the commission as a division.
In the interest of time, though, what you've done essentially is follow the same procedure that you did
Precisely.
for Ms. Kalik.
Yes.
You've provided us that here. And what you're asserting is in Congressional District 2, an insufficient number of signatures were met by the deadline.
Correct.
Does that summarize your?
That's exactly right. And that, as such, candidates, by the.
Please don't take me as disrespectful, but I mean, if that summarizes it,
It does. Thank you.
we've got a full docket.
Clarification. So on your page 1 of your exhibits, it's saying that Congressional District 2 has 115. I understand that's still less, but I think you said 62.
I'm sorry, page 1 of.
Of your affidavit that you gave us here.
Right here.
That's the report, that's what she's referring to.
Oh, that's the county unofficial report?
Okay.
That's not my count.
Okay, thank you.
So 62,
I searched for additional.
62 is your,
That's correct.
Okay.
Yes.
Thank you.
Yes, thank you.
Ms. McRae, would you like 2 minutes of cross-examination to Mr. Yanni's opening remarks?
Well, the main thing is I'm a little bit confused because on the campaign trail with Mr. McDermott, he said he wanted all 3 candidates to be on the ballot for it to be a democracy, for it to be a challenge. Are you going against his wishes? Because I've heard him say it multiple times to bring a challenge. I'm just a
Sorry,
question.
I'll be happy to answer unless you. I'm reading the state law. I've not, I've heard some comments from Mayor McDermott. I'm not familiar with that comment.
Well, it's just, he said it multiple times. So the other question I have is, you said you're just his friend, but how many cases have you been on with Mr. McDermott? You're his attorney quite often, is that correct?
I may have forgotten something in 20 years, but I don't recall.
And just
representing Thomas Dermott.
procedurally, I believe in the rules that we adopted for this, the cross-examination in the 2-minute period is to be limited to the remarks that he made during his opening statement.
Okay.
Thank you.
We never answered the question of the statutes of limitations as well. That goes to you guys as well, that Mrs. Khalif asked.
Oh, Mr. Chair, can we have, since that's been raised before, and for future people who may want to raise it, can we have staff discuss that right here and now?
I'm certainly open to that.
Okay.
Co-counsel, Coach Eva, would you like to?
I think she referenced 3884, right?
Yes, okay. So we're turning back to the 388 statute. There are 2 things to be in consideration of here. 1, 388 does not apply to federal candidates. A candidate for United States Senator is running for a federal office under our state election code. That law only applies to state offices, those being governor, lieutenant governor, secretary of state, etc., and legislative office, meaning those running for the Indiana General Assembly, a state representative, state senator. In addition, for number 2 is that 388 has been used to challenge those particular candidates after the primary. I can cite to you into the commission's record a challenge against Indiana Secretary of State Connie Lawson when she was a candidate in 2018. 388 was used, as well as against now State Representative Earl Harris, who represents the State House District Number 2 up in Lake County, when he ran for office in I do not remember the year, but he was also challenged under that statute after the primary. So those, for those two reasons, they don't apply here.
It's not applicable.
Does not apply. Yes, 3A.
I agree with Matthew.
Thank you.
Mr. Chairman, if I might.
Please.
The statute that you would want to review is 3-8-2-18. Right?
Yes. I'm sorry, yes.
That would apply for federal office.
Correct. That is the deadline for which the commission has to consider a challenge that was properly and timely filed, not later than noon. And Mr. King or Mr. Kochiva will remember the date, 68 days before
That's
the primary
correct.
election.
Yes.
Valerie? Yeah. Which is next Thursday, the 24th by noon.
So the filing is timely.
Correct.
And I would just add on for the record, we must also include 3-8-2-14, which establishes the deadline for a party who can file a challenge against a candidate running in the primary for that deadline as well. So we must
So
include
what I'm
two.
hearing in this is that the challenger has met the requirements set out in Indiana statute determined by the Indiana Election Division to take this challenge.
Based upon the record that you have before you, the answer is yes.
Agreed.
Co-Director King, you have anything to add?
No, nothing to add to council's remarks.
Okay, you're still about halfway through your 2-minute rebuttal.
Oh, I'm fine with the rebuttal. Do I get a chance to
So
just
now
talk?
you have 7 minutes.
Oh, 7 minutes, okay. I want to reiterate something that Mrs. Khalif was saying about the haphazardness of the signatures. And I just received, for example, I had someone in Elkhart, District 2, which he's referring to. I had someone in Elkhart to go to the county to pick up our petitions and overnight them to me, which that person did. However, not all of them, they didn't hand him all of those signatures. So in the mail, I just received another pack of signatures from Elkhart that have been certified, but was never handed back to the person who was supposed to mail them to me. So we handed in some for Elkhart, but I was thinking we handed in all of them from Elkhart, but we're just now getting stuff in the mail. I was getting stuff from all over the state, from strange little counties, Whitney, these counties, after the fact that have been certified, but not because of the snow, because of the closings, we're just getting some of those signatures. So it was not a smooth transition by any stretch of the matter. District 2, District 1, I drove in snow, sleet, rain to get some of these signatures. And people don't look, that day when things were due, the weather conditions were so horrible. So I think that needs to be factored in. And I can enter into evidence that these have been certified, but just got to me 2 days ago. So this is just one of many examples that I just happened to grab on my way out the door. And this is for District 2. It's still probably not enough.
Oh, that's what I was going to ask you. How many are there?
I haven't even counted them. But it's just sort of some of the things that went on. I don't know what happened to South Bend, for example. Those were supposed to have been handed in. That was well over 200 signatures. I don't know what happened with those. So just to reiterate, there are so many issues with my campaign collection. And one of the issues that I've had, and I just wanted to be on record, I am not going to have those numbers. I know that. But what I also wanted to go on record was that I entered this on December 12th. It was my understanding that I had 3,500 signatures. Only to find out that someone faked all of that, and we basically had to start all over, hit the ground running December 12th. So all the signatures we've collected are between December 12th to this December, to when the date was. So we did a phenomenal job, but we only had, 3 or 4 weeks to work with. it was clearly a sabotage on our campaign. Clearly from someone who did not want us to be on the ballot, me to be on the ballot. It was very intricate, it was very well planned, and the whole goal seemed to have been to run out our clock until I wouldn't be able to collect the rest of those signatures. We did a phenomenal job of getting as many signatures as we could. We went around and we pulled together alliances that I would love to be able to participate with. And what I have entered, what I'd like to enter is what I was able to do was capture, wasn't able to capture all the conversations, but I was able to capture the text messages that I was getting from Donnell Duncan, who was part of my volunteer staff. He must have been turned or paid because he did not turn in any of the 3,500 signatures, 3,554 signatures that we thought we had going into December 12th. Part of these signatures we handed to Donnell Duncan to chart, to verify. Those were never turned in as well. So I just wanted this board to understand that our campaign, we thought we've collected not only 5,000 signatures, but we thought we were heading into 7,000 signatures. Only to find out that our campaign was severely sabotaged. So with that being said, here are the text messages that I like to enter into the record. I would love an investigation to figure out who did this. But we tried our best. We actually were collecting signatures all during the year, and we were handing them to Mr. Duncan. And none of those signatures have appeared, none of them. So what you have are the signatures we collected between December 12th and January, the deadline.
What I hear you saying is you recognize that those signatures do not meet the requisite number.
Absolutely, absolutely. I just wanted to go on the record that we were not lazy campaign. We were out there doing the very best that we could do. And I just wanted to be on the record that these things happen, that people strategically sabotage our campaign. And these things happen, and I just wanted to go on the record, it happened to me. I'm really sad that Mr. McDermott challenged both African-American female people on this campaign. We had an opportunity here to do something different in Indiana, and Mr. McDermott has destroyed that.
The record shows that Mr. Scott Yaney has challenged you, not Mr. McDermott.
Oh, come on now. McDermott said, for the record, McDermott was in the Indy Star saying that he knew someone that was going to challenge. He knew the person that was going to challenge and he was going to support that challenger. That was an Indy Star. This was this is their deal going on. Come on now. So, I mean, it's pretty obvious. So I'm just disappointed. I'm disappointed, Mr. McDermott, that he would actually do this.
Okay, so that's the 7 minutes.
Okay, thank you.
Is there an offer to extend? Hearing none, moving on. Mr. Yaney, if you would like, you have cross-examination.
I'm simply disappointed at those last comments.
Oh, come on.
Yes, do I know Tom McDermott? Yes, it's my interest because I know Tom McDermott and why. Yes, absolutely. The balance, I take exception.
Appreciate that. Do you have a rebuttal, Ms. McRae?
I don't know why he takes, it's pretty obvious. If no one challenges these signatures, we're on the ballot. Mr. McDermott on the campaign trail was constantly saying he wanted all three candidates to be on the ballot. And then he suddenly changes his mind. I think that him wanting to be the only candidate on the ballot is just sad. It's the saddest thing that could happen to this campaign, and it's going to be, it's going to have a negative effect on the voters because the voters know they don't have a clear choice. So we missed an opportunity to help the Democratic Party.
Can we say something else?
Well, hold on. Does that conclude your?
Yes.
Okay, thank you. So I'm going to bring the public portion of the hearing, 2022-8, to a closed discussion.
Thank you,
Questions?
thank you. Ms. McCray, I have to say, like I told
Yes.
Ms. Khalid, as a woman who's been involved in politics for a very long time, as someone whose family is Mexican, as a daughter of a mother who was served out of back doors of restaurants, I totally understand. And I want to see strong women, women of color, in these offices. However, to get there, you have to learn and educate yourself regarding the laws and rules. You can't sit there and say to anyone that these rules don't apply to us because we are people of color.
No, I did not say that.
I have been challenged in everything else myself along the way. So I know the frustration.
I don't think that was ever said, I don't think that ever came from my mouth.
Well, you said.
That I thought that we should.
You said,
No.
no, let me finish.
Go ahead.
You said you didn't think Mr. McDermott should have challenged. That's why, and that denied 2 women of color on the ballot. So, having said that, I do appreciate the fact that you were honest and said that there were not enough signatures for the 2nd congressional district, which would then mean that you are not qualified to run for office. I'm a little disappointed that again, first Ms. Khalid claimed it was our election staff who had some plot, and now you're saying someone planted someone in your campaign.
Absolutely. Absolutely.
And as a candidate though, ma'am, that's the other thing you learn from all this. Take these lessons and learn.
Oh, absolutely. I just wanted it to go on record. I'm not challenging the challenge at all. I just wanted to go on record that someone did this, that someone who was very committed to not having us on the ballot did this.
Well, that's, as a candidate, that's your job. I mean, the buck stops with you.
Absolutely,
and
absolutely.
You go through and monitor it, and you should have been asking to see these reports and see.
And if you go through the affidavit that I gave you, we were constantly asking for those. I have 147 pages. I just pulled out those that actually had the signatures counts on there. There was me asking for proof, asking for copies, asking for these things, and what I got was a runaround.
I think this.
Right, it's just, it was just an unfortunate thing.
And I think what I've heard you say is that you wanted to get this on the record.
I just wanted to get that on the record.
What you say is you don't deny the challenge.
No, I do not deny the
With that in
challenge.
mind, is there a motion?
Yeah.
Move to uphold the challenge.
Second.
Any further discussion or questions? Hearing none, all those in favor to uphold the challenge, please signify by saying aye.
Aye.
The ayes have it, the motion carries. Challenge is upheld. The elected division is directed not to include Valerie McCray on the certified list of primary candidates sent to county election boards and indicate that the name of this candidate is not permitted on the ballot. Thank you. Cause number 2022-16 in the matter of the challenge to Thomas McDermott Jr., candidate for Democratic Party nomination for the United States Senate. Again, the election division has provided copies of the filing and all relevant material in your binder. Please.
Oh, no.
Oh, I'm sorry, you weren't sworn in?
He's being challenged.
You're the challenger.
So you need, this is
You
your.
sit over here. Valerie McCray,
Yeah,
you are the one bringing the challenge, correct?
I'm sorry,
You are the one bringing the challenge?
to Mr. McDermott?
Yes,
Oh, yes.
please.
Oh, okay, yeah, I didn't know.
With that in mind, I'm sorry, please administer the oath.
Please say I do have a recitation of the oath. Do you solemnly swear under the penalties of perjury that the testimony you're about to give to the Indiana Election Commission is the truth, the whole truth, and nothing but the truth?
I do. Do you understand the procedures we've adopted for the purposes of this hearing?
Yes, sir.
I'm sorry. Say your name again.
Yes, sir. My name is Thomas Matthew McDermott Jr. I'm the mayor of Hammond, Indiana. I was elected mayor of Hammond, Indiana, January 1st. Well, I took office January 1st, 2004. So I've been elected 5 times since then. MC capital DERMOTT Jr.
Thank you, sir.
Yes, sir.
With that, I'll recognize Valerie McCray, the challenger, for a 7-minute presentation.
I'll be brief. My challenge is based on two things. One, someone informed me that they knew of some copying that was going on with his campaign. I'm not at privilege to tell who that was. Also, Mr. McDermott has been in previous campaigns where there's some concern that he has used previous forms to present, has changed the dates, the names. He's had access to other forms. I think that I need to hear that he didn't forge these signatures.
Do you have any evidence, Ms. McCray?
No, just hearsay. I'm sorry. Just hearsay, and I just know that he ran for office before. The only evidence, when I looked into Mr. McDermott, there has been just some judicial issues that he has had to pay fines for. And so the issue for me is he honest in this particular procedure? And I just want proof that he's actually turned in signatures that are legitimate.
Does that conclude your opening?
Yes.
Can I say something here before we go on? You know, as a challenger, you have to give us evidence. You can't come in and say, I have a feeling about this, or someone who I can't tell you who it was.
Yeah,
said this,
I know.
And all of that. So, and being the first one up, you have a certain burden you have to meet.
Right.
So I don't think that burden has been met here.
Well, if Mr. McDermott would like to yield his cross-examination, opening statements, and subsequent rebuttals for a motion.
Would you, Mr.
I'm sorry, my attorney was talking to me, sir.
They tend to be.
I'm obnoxious though.
I was like, I had 3 people talking to me at once, you're up next, sir.
Valerie McCray has acknowledged that she does not have sufficient evidence, if any, to support her claim. But just wanted to hear you make a comment, which you're not required to do.
And
Member Celestina Horseman has noted that, and it's been suggested that maybe you yield your time,
sir,
for any opening remarks or any cross-examination, and we simply hear a motion.
It's very embarrassing to hear what Ms. McCray is saying about me right now. It's challenging my integrity in front of the State Election Commission.
So this is part of your 7 minutes opening statement.
My attorney advises me not to say anything, but I feel my honor is at stake, Your Honor.
Thank you. Anything further?
The signatures we collected during this campaign were 100% hard work, grit, effort, thousands of miles driven, hundreds of volunteers. We worked tirelessly. And it was just as snowy and just as icy and just as cold for our team, and we still made the deadline because it's a deadline. We worked so hard, and it was such a major accomplishment for my campaign to hear the things that I'm hearing right now, insinuations, defamatory statements, hurts my heart, sir. I worked super hard with my team to collect every one of those signatures, and every one of those signatures is 100% valid, sir. And it's insulting to hear otherwise. It really makes you wonder why people run for public office, sir. It really makes you wonder, because I did everything the way you're supposed to, sir.
Just a rebuttal on that.
Well, just hold on a second.
Go ahead.
Does that conclude your comments?
Sure, do we have any cross-exam?
Please state your name.
I'm sorry, Kevin Smith. I let the commission know yesterday that I'd be here as Mr. McDermott's representative as well, an attorney.
Smith, SM.
I'm sorry, Kevin Sorry, it's okay. I didn't know if there was a need for a rebuttal based on the commissioner's request for us to waive. Or for
Certainly up to you.
cross-examination.
I would, Mrs. Celestina Horseman's comments.
I'm fine with her comments. I mean, we close with Mayor McDermott's statement.
My position is that since there's no evidence to support the challenge, that we should just go ahead and dismiss it right now because we have no grounds to hear it.
Can I say one more thing? I was just informed that Mr. Yanni, we're going backwards now, is not a registered voter.
That
They've
case,
checked.
ma'am, that case.
I don't know, but it was closed on negative
It has
information.
been voted on, that case is closed. You can't drag that into another hearing?
Well,
I'm sorry. Ms.
anyway.
McRae, I'm sorry.
I just found this out. I'm
Okay,
sorry. I just
well-
want to, for the record, that Mr. Yanni, who pulled these
It is
things,
not-
is not a registered voter.
That is not germane to this particular cause number. With that in mind, is there a motion?
I move that the challenge be dismissed, denied. Thank you.
Is there a
Okay.
second?
Second.
Having a motion and a second to deny the challenge, is there any further questions or commentary? Hearing none, all those in favor signify by saying aye.
Aye.
The ayes have it. The challenge is denied. The election division is directed to include the name of Thomas M. McDermott, Jr. in the certified list of candidates to be printed on the ballot. Thank you.
Thank you, Your Honor.
We just recess.
If you recess, you have to give a time and state that you're returning to this location.
I apologize. Do I have to get my motion and vote? Can we go into recess until 3:30 by consent? It's done. Return to this location at 3:30, sorry. Thank you. We're in recess. Please quiet down, we're gonna resume. Thank you. Back in session. Back in session. Moving on. We have two cause numbers. Norris, the Niederberger cause number 2022-19. And Bartlett versus Niederberger cause 2022-20. In the matter of challenge to Danny Niederberger for Republican Party nomination for United States Senator. Given these two challenges appear to be substantially identical, and their objection is consent to consolidate these two challenges given for consideration by the commission. Consent. We will consolidate them. I will recognize, per your request, Evan Norris and Alexander Bartlett to make their opening remarks in combination. If you need a little bit more, we'll consider it. Please proceed with your 7 minutes.
Thank you, Mr. Chairman. We will try to keep this to 7 minutes, to keep this moving along as fast as we can. Evan Norris, Norris. I bring this matter against Mr. Niederberger as a resident of Boone County, Indiana, specifically Eagle Township, precinct number 5, along as.
Yes, hi, I'm Alexandra Alley Bartlett. I bring the challenge as a registered voter in Marion County. Bartlett.
Thanks. So this is something that this commission has already heard here today in dealing with the Ms. Kalik and Ms. McCray matters under cause numbers 08 and 09. This is an issue of signature deficiencies. It's the same basic premise and the same basic arguments that have already been presented to this commission today. Ms. Bartlett and our argument is this: that Mr. Niederberger does not have the requisite number of signatures as required under Indiana law. We argue he's ineligible to be placed on the primary ballot for U.S. Senator, and therefore Ms. Bartlett and I respectfully request that this commission uphold this challenge and rule Mr. Niederberger ineligible for the May primary. I'll let Ms. Bartlett go into it.
Please, thank you.
Yes, as Evan mentioned, we've already heard this challenge today, so we will be brief in our remarks. But pursuant to state law, a declaration of candidacy for the office of U.S. Senator must be accompanied by a petition signed by at least 4,500 voters in the state and 500 voters in each congressional district. And the due date for those submissions was Friday, February 4th, 2022 at noon. The Indiana law also says that the election division cannot accept a filing after that deadline. On February 9th, 2022, I submitted an access to public records request to the division and received a prompt response. Thank you for that. With copies of all of the petition signatures submitted by Mr. Niederberger, which were deficient in at least 4 congressional districts under the 500 signature mark. And yes, we did submit all of that information along with our challenge documents.
Sorry to interrupt you.
No problem. After our review of those records, it's pretty clear that there are at least, like I mentioned, 4 congressional districts that are deficient of the 500 signature mark, and this is all being viewed in the light most favorable to Mr. Niederberger as we reviewed these. Just as a brief recap, by our count, he is deficient by at least 117 signatures under the statewide 4,500 vote requirement. In the 1st congressional district, he is deficient by at least 23 signatures. In the 3rd congressional district, he is deficient by at least 30 signatures. In the 7th congressional district, he is deficient by at least 146 signatures. And in the 8th congressional district, he is deficient by at least 74 signatures. Just to clarify a bit, I mentioned that we are viewing this in our review in the light most favorable to Mr. Niederberger, and that's because for purposes of the 7th congressional district, if we were to look at the official record of petition signatures that were submitted, timely submitted to the division, that actually reflects that 0 were submitted. But again, we are viewing this in the light most favorable to Mr. Niederberger using the unofficial count. That's how we did that calculation, just for clarity.
So if you were giving him a break, he'd have more than he really does.
Exactly. So I'm going to turn it over to Evan just to speak on a few additional topics.
Yeah, I just want to bring up something very quickly to preempt any argument that may be made by Mr. Niederberger when it comes to the 2016 challenge against now Senator Todd Young. The issue pertaining to Senator Young back in 2016 is apples to oranges compared to what we're bringing here today. In 2016, Senator Young submitted evidence of at least 500 signatures in the 1st congressional district. The challenger in the 2016 matter alleged that the evidence was insufficient, and those arguments centered around whether certain signatures or evidence should have been even considered. That's not the case that we have here. In this challenge, we are essentially saying that Mr. Niederberger hasn't submitted even 500 in 4 congressional districts, along with the 4,500 requirement. He simply did not meet the signature requirements on those on multiple grounds. However, I believe that the applicable precedence has been set in the 2020 challenge brought by Mr. Brian Roth, or that was brought against Mr. Brian Roth for governor. In that matter, Mr. Roth also did not meet the signature requirement, the same issue that we have here with Mr. Niederberger. Roth also raised a 2016 issue involving Senator Young. Again, I recall the commission distinguishing the 2016 matter and the Roth matter because Mr. Roth, like Mr. Niederberger, did not submit evidence of even meeting that minimum threshold of 500 signatures in each congressional district. In this matter, we do not need to get to verification of signatures because there's no evidence that Mr. Niederberger obtained 500 signatures in 4 different congressional districts. Our challenge today here is rooted in simple math. Mr. Niederberger does not have the requisite signatures on his petition as required under Indian law. If Mr. Niederberger believes that the signature statute is somehow unfair, there are other avenues such as arguing before the General Assembly or bringing it in a proper court of law. And at this time, we'd like to, reserve any additional time for questions and things to help keep the process moving.
Perfect, thank you. Mr. Niederberger, would you like 2 minutes of cross-examination?
Danny Niederberger, Niederberger. I just have a couple questions. When you reviewed the signatures, did you review the SVRS system or did you review the signatures that were turned into the Secretary of State's office?
We were requested and reviewed both.
Can you enlighten me on which one you are challenging, please?
We would be challenging the official petition signature count,
Which would be which one?
which would be the count that was submitted to the division.
Okay, thank you.
Any further cross-examination?
No, sir.
You're afforded 7 minutes of remarks if you'd like to.
Thank you. Danny Niederberger already spelled my name. Well, I didn't want to be here today. In all honesty, I really didn't. But I'd like to motion to dismiss all arguments related to the SVRS system. Number one, as pointed out in both Mr. Norris and
The SVRS system is not on trial today.
I understand. That's what they said partially.
You're not really permitted to offer a motion to that effect.
Okay.
So go ahead with your remarks.
Speak.
Excuse me.
I understand I can't make motions, just how I speak. I'm not a lawyer, just how I speak.
I'm not either.
But the SVRS system is not in the Indiana code. It is completely unofficial. Not all counties subscribe to the SVRS system, which is partially what their argument is. So please take that into consideration. As outlined in the challenges, the Indiana code stipulates that only the physical ballot signatures that are turned in to the Secretary of State's office as of February 4th by noon deadline will be counted towards a candidacy. And those are the only ones that are challenged. Now, I can tell you that this campaign submitted over 600 signatures to each congressional district between January 5th and February 1st at noon, submitted all of them to 85 different counties across the state. 85 of the 92 counties we had signatures in. I personally delivered to 75 of those counties. Delivered and picked up. Now, I can tell you that timing is everything in this. I am, to coin a phrase, running this on an 8-cent budget. I don't have the money to pay people to go out and get signatures. I don't have the money to pay people to pick up signatures, drop them off at these various different counties. Simply, I put in a hard work, and I'm proud of what I've accomplished. Now, as I said, over 600 signatures.
This won't count against your time. I have a quick
Yes.
question. Is that to suggest you recognize you did not meet the signature requirement?
No, sir. So I turned in over 600 signatures to each county to be verified. Now, between picking up signatures, dropping them off by the February 4th requirement, I believe that I have enough signatures in each congressional district outside of District Number 7, as was alluded previously. There are 0. Why? That's from Marion County. And here's what I want to tell you guys, because this is what happened to me. This has happened in the past and it will happen in the future. And as was stated in a previous hearing, there is no control, there is nothing in Indiana code to prevent this from happening. As this will attest, I turned in a whole bunch of signatures stamped right here, January 13th, to Marion County Election Office. Now, I went in Monday, January 31st in the morning, went in to drop off more signatures as well as pick these up. I was told they were not ready. Okay, fine, still have time before the deadline. I had more signatures to drop off and pick off the next couple of days. So I had a whole bunch of people dropping off signatures in Marion County specifically up until the February 1st noon deadline. February 2nd, Wednesday morning, I go back into the Marion County election office. I asked them if they have my signatures ready. They say, no, we don't. I said, what about the ones that I dropped off a few weeks ago? I said, no, we don't have them ready yet. Okay, perfectly fine. I still have time before the deadline. Now, if you recall, as was brought up in previous hearings, Thursday was the winter storm. Most county offices were closed. Friday morning, February 4th, deadline at noon to get these signatures in. I go into the Marion County Election Board. What do I get told? They're closed. Closed. After refusing to give me my signatures twice, they were closed. Now, I went to the election division right after, just walked down the street, went to the election division, turned in the rest of my signatures for the other 8 congressional districts. I was told then the deadline stayed at noon because the Indiana election division remained open. Perfectly fine. I applaud the staff. The staff was very helpful in answering my questions. My problem is not with the IED. However, February 7th, the next Monday, after the deadline, I go back into Marion County. And I asked for my signatures, and they said, well, did you receive a call? Because as with most counties, you give them your contact information, your name, your number, and they'll call you when they're ready to be picked up. I said, no, ma'am, I did not receive a call, but the deadline was last Friday to get these into the state, so I would like them back, please. They were reluctant in giving me my signatures. They stalled me for 20 minutes before I got my signatures. Obviously, I can't turn them into the state. I recognize the deadline. So I'm not asking for these to be admitted. But I will show you this right here, submitted February 1st, time-stamped. Not verified. There is no county seal on that. No county seal. Signatures were not verified. I turned them in on time. Whether or not I could get them into the state, I accept that. Okay, I accept that. These are the rules. They were hard rules to play by. I played by the rules. I accept that. What Marion County did to me is completely ridiculous, and I want it on record. Because this, please, because this is ridiculous. I played by the rules. These signatures, it's a hard task. Anybody can tell you to get these signatures is a hard task. Anybody can tell you that. But regardless of whether you attest that I didn't get the signatures in the other districts or not, Marion County was never going to come into question because they were never going to give me my signatures. And that is ridiculous. Okay, so I want that on record. Now, you do have precedents here. U.S. term limits versus Thornton. The U.S. Supreme Court ruled that ballot access laws are okay if they are reasonable. My argument here is that this is not reasonable because number one, there is no jurisdiction, there's nothing in Indiana code that tells the counties they have to get these signatures back to you at any point in time. May I have one more minute, please? Just to close it out.
For another minute.
Consent.
Thank you. It is completely unreasonable. I understand the time limits. I played by the rules, but it is completely unreasonable that the counties have full discretion on whether or not to get these signature forms back to you. So what I'm asking you to do is to, as set in 2016, when Todd Young got on the ballot, you are allowed to bypass this rule. I am asking you to do that for me.
Mr. Norris, Ms. Bartlett, would you like 2 minutes of cross-examination?
Very quickly.
Sure.
Do you dispute the fact that you are short of the 4,500 signatures as required statewide?
I have no reason to believe that I'm short those signatures.
What evidence do you have to show this commission that you obtained those 4,500 signatures?
With me today, no.
Do you dispute the fact that you are short of the 500 signatures in 4 of the 9 congressional districts in the state of Indiana?
Yes.
Okay, what evidence do you have to show this commission that you
With
obtained?
none.
I have to ask my question. Are you able to show this commission here today that you had 500 signatures in the 1st congressional district?
Only by what I turned into the Secretary of State's office on February 4th.
Are you able to show this commission, as you sit here today, that you obtained 500 signatures in the 3rd congressional district?
Only by what I turned into the Secretary of State's office on February 4th.
Are you able to show this commission, as you sit here today, that you obtained 500 signatures in the 7th congressional district?
Only by what is brought right here because 0 were turned in on February 4th.
Are you able to show this commission, as you sit here today, that you obtained 500 signatures in the 8th congressional district?
Only by what I turned into the Secretary of State's office on February 4th.
Nothing further.
Do you have a rebuttal? You have 2 minutes.
Yes, like I said, it is my understanding that the burden of proof has to be on them. So unless they have the signatures with them to turn in to prove that I didn't meet the signature requirements, I have no reason to believe that I did not meet this requirement outside of the 7th district, which I've outlined in my
They
case.
provided proof that you did not meet the threshold of signatures required. You provided no proof that you have.
Where's the proof other than what they've outlined? Do they have copies of the forms with
We
them?
do have them
Okay.
here today.
Fair enough, thank you.
It's a very large file.
Fair enough, thank you.
And to know your records, you brought no proof to contradict that proof,
I
correct?
understand, thank you.
With that in mind, the hearing is closed on
May I
that.
request something real quick, please?
Make it brief.
Yes, can I request a hand vote?
No.
Okay.
Cause numbers 2022-19 and 2022-20 are now closed in public hearing. Is there any further discussion or questions from the commission? Sure.
Just a brief comment. Mr. Niederberger,
Yes, ma'am.
I would agree with you regarding that the statute should say that the clerks should get you this information back by a certain date. I agree with you on that. Unfortunately, we're not the legislature, so we can't make a change in the law. Now, as for the Todd Young case that you referred to, that was a case where he had 400, well, they were claiming he only had 498 signatures.
Yes, ma'am.
But the basis of that challenge was the fact that he had turned in more than 498, but they were saying it was only 498 because they were challenging whether someone was a registered voter and whether they had eligible to sign that petition. It wasn't a case that they could say in their discretion, you know what, we're going to waive the 500 signature. No, that was not it at all. What they finally ultimately said was that, okay, the challenge that, 3 of these people are not eligible to sign this petition, that's not good, so they didn't go anywhere. That's why. So it's a different thing. It's
Ma'am,
not discretion.
Are you saying that he did not have the 500 signatures?
No, I'm not.
Are you saying that those?
No,
okay,
no, no,
thank you.
no.
The
No,
matter at hand,
Well,
the Young case, I believe, was voted on by this commission and rendered 4-0 in this decision. And we're about to get to that point right now. Can I have a motion to uphold or deny the challenge?
I would move to uphold the challenge.
All right, there's a motion. Is there a second? I'll second it. Any further comment, questions? All those in favor for the motion to uphold the challenge, please signify by saying aye.
Aye.
The ayes have it. The challenge is upheld. The election division is directed not to include Danny Niederberger on the certified list. Boo.
Thank you.
I did not hear the last.
I'm sorry. Yes. Where did you lose?
Challenges that health commission is instructed to.
Not include Danny Niederberger on the certified list of primary candidates sent to the county election boards and to indicate that the name of this candidate not be printed on the ballot.
Thank you.
Thank you, sir. Appreciate it.
Thanks, Danny.
Thank you, Danny.
Danny.
Next case. Freedom. We will now hear cause number 2022-24 in the matter of the challenge to Stephen, am I correct? Correct. Correct, sorry. Candidate for Democratic Party nomination for United States Representative District 2. The election division has information in your binder. Recognizing Laura O'Sullivan, that you please recognize Laura O'Sullivan, the challenger, for presentation. You have 7 minutes. Please say your name and spell it for the court reporter.
Thank you. Good afternoon. Laura O'Sullivan, Laura O'Sullivan, O''Sullivan.
And before you go on, is Mr. Crane here? Well, I have no notice of any request for continuation.
No.
No, we did not receive one.
We've not received any notice. All right, and it's Courant?
We understand it's correct.
Stephen Courant, are you here? Does somebody want to yell out in the hallway for Stephen Courant real quick? Going once, twice. Stephen Courant, are you here? Let the record reflect that Mr. Courant has not appeared.
I'm not sure.
Oh, he is? Why don't you go ahead with your 7 minutes of opening comments? We'll play them back if Mr. Courant shows up, if he needs to hear any of it.
Thank you
In the
very
interest
much.
of time.
Absolutely. I'll be brief. So Mr. Courant fails to provide his Indiana voter registration.
Sorry, just a second.
Could you ask the room to be quiet?
Yeah, please, cut the chatter. The court reporter's having difficulty hearing. We want to make sure we get an accurate public record. Thank you. Go ahead.
Mr. Courant fails to provide his Indiana voter registration info on his Can-2 declaration form. He also, upon searching the Indiana statewide voter registration system, it shows that Mr. Courant is not a registered to vote in Indiana. Mr. Courant fails to claim affiliation with the Democratic Party on his Can-2 form. Upon researching the Indiana statewide voter registration system, it shows that Mr. Courant has not voted in the last 2 Democratic primaries in Indiana. Mr. Courant has listed his residence in Livingston, Texas, and his mailing address as a P.O. box located at the Ireland Road Staples store in South Bend, Indiana, located in St. Joseph County. Upon discovering that he had filed with St. Joseph County, I contacted St. Joseph County Chairwoman Diana Hess, and she has confirmed that she has not communicated with nor certified Mr. Courant as a member of the Democratic Party in St. Joseph County. I provided to the committee some documents as evidence, including Mr. Courant's Can-2 form, which is missing crucial information in the general information under sections 1 and 3 and fails to include county chair. I also have included a letter from St. Joseph County Chair Diana Hess confirming that she has not met with or spoken to nor certified him as a Democratic candidate. Various searches, both statewide and St. Joseph County, for Mr. Courant's voting record are also provided, yielding no results for his name. I've also provided a Google map search of 1143 East Ironwood, his stated mailing address, showing that it is the Staples store in South Bend. That concludes my remarks.
Thank you. Has anyone heard from Mr. Courant? Anyone would like to make a motion or have any?
I would just note that, I mean, I think one thing that is worth pointing out is that federal candidates, who's like this individual's, Mr. Courant is requested to be placed on the ballot as a candidate for U.S. representative for the 2nd district in the Democratic primary. And the residency, I would just point out that the residency requirement is not a qualification for federal candidates, as they just have to be an inhabitant when elected, which is an issue we can all discuss at some other time. But anyway, don't need it. But I think, but there is the element. So I think for this particular challenge, that living at the Staples in South Bend, I guess we don't need to get into that. But, or I guess he gives his Texas address, but I think the issue is that he still is required to satisfy either the, voting in the 2 primaries or having the chair of the party, and he, of the local party, provide the certification. He hasn't done that. So in light of that, I would move to uphold the challenge.
Second.
There's a second. To uphold the challenge. Any further conversations? Hearing none, all those in favor of upholding the challenge signify by saying aye.
Aye.
The ayes have it. The motion is carried. The challenge is upheld. The election division is directed to not include Stephen Grant on the certified list of primary candidates sent to the county election boards and to indicate that the name of this candidate not be printed on the ballot.
Thank you very much.
This will control the level of the audio. I need it. They asked that when they go to, when they take a break, just turn it over to minimum, turn it all the way off. And then you can pick it back up when they start. Are you good? Yeah, I'm good. Ever.
The next cause is 2022-15, Bone versus Schrader, Democratic Party nomination for United States Representative District 3. Schrader. Thomas Schrader, Tom Schrader. Has anyone seen him today, here? Let the record indicate that Mr. Schrader is not present. Would you like to make some opening comments?
I'm Christine Bone, CHRISTINE. Last name is Bone, BOHM. I'm the 3rd District Congressional Chair of the Indiana Democratic Party. I have provided the commission with a large stack of evidence to back up my statements. Basically, my biggest contention is that Mr. Schrader apparently is unaware of his own name. He fills out his forms as Tom or Tommy, but yet he signs and notarizes them as Thomas. On line 1 of your filing, it requires per state statute that your name be your legal given or certificate name, and he has put in his alias at that point. On that same form, he has provided an incomplete address. His address is actually a hotel in Fort Wayne. And finally, the most egregious portion of his filing is on page 2, question number 12. It states that I filed all reports required for all previous candidacies. Mr. Schrader has run 9 times. He runs in every election. 7 of those have been for federal office, 2 of those have been for municipals. I have printed out, trying to prove the negative, that he has never filed a financial report. He has never opened a campaign committee. I am afraid that Mr. Schrader may be taking below the threshold and doing things, although I don't know that to be true. On line 12, on his petition, the check mark is yes, that he has filed. But on the no box, it was originally checked and scribbled out. Was that done prior to notarization or after notarization?
It's here. Hang on.
Sorry.
That is okay. Basically, that is my whole case. Mr. Schrader is not a viable candidate. He's not a serious candidate. He's not a candidate who upholds the law.
So seeing that Mr. Schrader is not present, is there a motion?
Actually,
Sure.
no.
Well, we can close the public hearing in case you can ask questions.
Yeah.
Okay. Hearing on the matter is closed. Go ahead.
Well, I guess I would, I know he's not here, but what we're doing is ultimately comparing the forms, the legal requirements, what was provided. And I just want to point out that in terms of the legal requirements, in terms of the name issue, I don't see an issue with the way that he filled out his name. He does list it in multiple ways on the form, but the statutes actually say that it's, they can use the legal name, which is the one shown on the birth certificate. They can use a nickname. So and they can use names that appear to be kind of derivatives of those. I mean, Tommy and Thomas A would appear to be derivatives of a similar name. So I'm not sure that, I'm not influenced by the name challenge. The address, he does give a street address. The fact that it's a hotel and should not
It's
be.
incomplete. There is no
I'm
1020 Coliseum
speaking.
Boulevard. According to the USPS, it's 1020
Well, I guess you didn't testify. Well, I asked you that question. So what's incomplete about the address?
His actual mailing address is 1020 North Coliseum Boulevard, number 42.
Is there, and are there addresses that are on South Coliseum Boulevard? Okay, let's see. I guess we have to figure that out. That's something you discussed during the commission, I guess. So that's, okay, so that, I guess, so the name issue is something that I think is, so the address issue is maybe something that figure out, and he's not in here to answer that. Those are my comments, I'll stop at that.
Okay, so he ran for mayor one time, correct? And as mayor, he was required to hire a campaign finance report because the salary that the mayor draws, we set up a campaign committee because the salary that the mayor draws is above a certain law requirement. And your research shows, the evidence you've submitted shows that he never filed, never opened a committee, never filed any reports, correct? And you are supposed to do that, right? If you're gonna run for office, so. Yeah, and clarification. Yeah, the FEC, because our law does not say anything about the FEC files, so none of that is relevant. But it is relevant regarding his failure to file when he ran for mayor.
But the statement doesn't, if I can clarify that, educational, the statement on the form says, did you file all necessary financial paperwork? It doesn't clarify state or
If you
federal.
look at the statute,
Okay.
the statute says that.
Okay.
Okay. Mr. Schrader's not here. So at this point,
Yeah, I would move to uphold the challenge.
Second.
having a second, any questions for the conversation? Hearing none, all those in favor of holding the challenge, signify by saying aye.
Aye.
The ayes have it. The election division is directed not to include the name of Tommy Schrader on the certified list of primary candidates sent to the county election boards. Names cannot be printed on the ballot. Thank you.
Thank you so much.
Next case, 2022-10, Calkins versus Banks. Republican Party nomination for United States Representative. The election division has provided relevant information to binders.
We have three, as our chairman.
Please note for the record, Paul Mullen has entered an appearance for the candidate, James Banks, in the matter. Am I pronouncing it, is it Calkins?
Calkins, yes. My name is Aaron Calkins, or AJ Calkins. I am a registered voter in the Perry precinct up in Allen County, and I'm also a candidate for this position, 3rd Congressional District of Indiana. I am contesting the qualification for Jim Banks to be on the ballot based on the amendment number 14, section 3, 1.1, the disqualification clause. And it states about any former or any current person could not be a House of Representative or Senator if they participate or support an insurrection. An insurrection is, the definition is an organized or usually violent act of revolt or rebellion against an established government or governing authority of state and other political entity. The January 6th event, okay, I am a student of history.
This won't count as your time, I just want to. You're accusing James Banks of being an
Of
insurrectionist.
violating the 12th Amendment of the electoral law.
Go ahead, it doesn't count against your time. Go ahead, I'm sorry.
Okay, I'm kind of a student of history. I grew up, Mr. Banks is younger than me, I grew up with Watergate. I'm sorry, I didn't see any shows probably from about the time I was 6 to 8, because I saw a green table every day, every afternoon. I knew all the actors. Then as I grew up, then I saw the Clinton impeachments. Okay, now as an adult, I've seen the Trump impeachments, and I've seen for the first time an insurrection, people invading the U.S. Capitol. My first time that I went into the U.S. Capitol, there wasn't a single guard. It was before 9/11, and I could literally walk through the door, walk through the metal detector, there wasn't even a guard, and I walked to the Senate gallery and watched a couple senators talk. That was how it was. A couple of years later, 9/11, oh my gosh, you would think that the tanks were rolling down Pennsylvania Avenue. There was concrete everywhere, and today, you've got to stand in line for about a day before you can walk into the Capitol. When I saw that happen, I thought this was horrible. This is as bad as burning it down in 1812. Earlier last year, for some reason, because it was close, I went to something called Spiegel Grove. That is the home of Rutherford B. Hayes, and I picked up a book about Hayes. The election law of 1887 was created after the 14th Amendment. It took Congress almost 12 years to pass a law, and then another couple more years to codify it in a regulation. And that was to ensure that the minority did not steal the election like what happened with Rutherford B. Hayes in 1876. The Republicans did not win the election, and he was determined to be president 4 days before inauguration. Trump lost the election. It was completely gone through the courts time and time again about whether or not they were legal electors. And in 1876, it was an issue. They came to the Capitol with 2 sets of electors because they had 2 sets of governors in the southern states. Louisiana had 2 governors. They had 2 sets of electors. Several of the other states did the same thing. It was in total disarray. We didn't have that in 2020. We had 1 set of electors that were approved by the state election committees, and that was approved. Representative Banks stated that this was his personal decision, that he didn't believe the electoral system was correct. He was part of a lawsuit in December 8th. He co-signed into a lawsuit, and it was sent by the state of Texas against 5 states that were going to try to disqualify the electors of over 30 million voters. He wanted to basically disenfranchise 30 million voters from 5 states to say their votes didn't count. If the electoral count doesn't count, take it to the House of Representatives. That didn't work. Then it came January 6th. His counterpart in the Senate, he said that this was an insurrection. He said he took a vote by God, and somewhere that still means something in this country.
Who said that?
Todd Young said that. This is the same oath that Representative Banks took as a congressman. He also took it as a member of the military, that he would uphold the Constitution. Okay? Now, on top of all that, one of the states that he voted against was Pennsylvania, because he said he didn't believe the electoral count at all. So the issue is, I went back and looked at all the cases in Pennsylvania. There were over 30 cases that were decided against it or dismissed it. It went through the courts. It was validated. But if it was just one person that was part of this, I could say, okay, he may have had that right. But under an insurrection, it's a group of people. And our good friend, Peter Navarra, if any of you have seen him, so I have physically witnessed him saying this. He said in public office, he was put together a group of 100 senators and congressmen to contest the law so it could go back to the states and it would overturn the electoral count. That was their direction. So he wanted to create havoc and eliminate the electoral vote by contesting the electoral count. David, one of the commentators, it was a coup. well, it wasn't really a coup, but it was an insurrection. There was a violent insurrection with these people that invaded the Capitol, and then there was a political insurrection, people that were going to try to take it down, just like they did in 1776. There wasn't an alternative set of electors that came to the Capitol. One set of elections were turned in, and our congressman decided that he had the rights to vote against it. I believe that he was part of an insurrection, and because he supported that, I believe that under the clause, that he should not be on the ballot.
So to,
Is that complete your remarks?
Yes, yes it does.
well, then we'll
Follow.
sorry.
Would you like 2 minutes for cross-examination?
Yes.
Go ahead. Oh, yeah, sorry.
My name is Paul Mullen. I'm here on behalf of Jim Banks. With me today is Emily Stewart Fair, who's also with my office, and then also Christopher Crabtree, who is on the Banks campaign.
Could you spell your name for?
And my name is spelled Paul, P-A-U-L, Mullen, M-U-L-L-I-N. Just a few cross-examination questions. Just to be clear, you're a candidate for Congress, correct?
Yes, I am, sir.
And you're on the Democratic side of the ledger.
Yes, I am.
Are you employed, sir?
No, I'm not.
Am I accurate? You have no legal training?
That's correct.
So
Statement.
the cross-examination is to be related to only the statements that he's.
But he was giving,
You can use your 7 minutes to make those points.
okay, I guess I'll abide by the rule, but, he was.
We established these procedures at the beginning.
Okay.
We're gonna follow them.
And sir, you discussed your training, am I accurate? You have, no case law today on how the Supreme Court's interpreted the 14th Amendment in terms of Section 3?
That is correct.
That's all.
You'd like 7 minutes?
Please. So I introduced myself. My name is Paul Mullen, and I'm here on behalf of Jim Banks. He's Indiana's third district congressman, and he sits on the House Armed Services Committee. He couldn't be here today. He's previously scheduled to be at an overseas event. He's participating in a bipartisan legislative delegation at the Munich Security Conference. And it's noteworthy that Vice President Harris is also participating in the American delegation at that conference as a speaker. Today, we asked this candidate challenge be rejected and denied by the panel. I would move, in the interest of time, if we may bifurcate 2 questions. One is the authority or jurisdiction for this panel to make a decision based on a federal candidate that's been brought on the grounds of violating the 14th Amendment and supporting an insurrection. I would posit that this commission has the authority over state election laws, and the authority is well defined in Indiana code. And what this challenger has brought is essentially a U.S. constitutional challenge seeking an interpretation of a U.S. constitutional amendment. And this state of Indiana commission does not have the statutory authority to hear such an allegation. And we would respectfully request that this challenge be dismissed based on lack of jurisdiction and lack of authority on this claim. This claim should be heard by federal courts or the Congress itself.
Should we address that question so we can keep moving on?
Well, why don't we read? Co-counsel.
Yes, I'm looking for statute right now, that I believe allows.
It's 3812 H.
There you go. Is that the one that allows us to have jurisdiction over federal candidates?
Yes.
Thank you.
Okay.
And thank you. And it was more jurisdiction over the interpretation of a U.S. constitutional challenge. But I'll move on to the merits. This challenge still fails, and we ask this challenge be denied. It's a baseless allegation that Congressman Jim Banks participated in an insurrection or rebellion in the 14th Amendment. No facts were presented that I heard that he participated in a insurrection or rebellion. What I heard was some very creative linguistics on twisting around some words that him carrying out his constitutional duties, in Mr. Culkin's opinion, does not comport with the 14th Amendment. So the 14th Amendment, when we think of the 14th Amendment, that's what gives us the Equal Protection Clause. And the 14th Amendment came into existence very quickly, very shortly after the Civil War. And that's the context that it's examined in. It contains, beyond the Equal Protection Clause, which allows for equal protection of the law, it also includes Section 3, which is a reference that a person who has engaged in insurrection or rebellion against the United States cannot hold a federal office. And he referenced January 6th. Of course, there was no facts presented that Mr. Banks was a participant in what we've all seen as the ugly pictures of what occurred that day at Capitol Building. And the reason we didn't see that is because no such facts exist. In reference to that tumultuous conduct exhibited on January 6th, Congressman Banks has publicly commented that he did not support that conduct, and nor did he engage in it. And he has also called for the prosecution of unlawful conduct that occurred that day. He actually was on a cable news show that evening, and perhaps the first member of Congress to speak publicly to the country after those events occurred on January 6th. He took that opportunity to denounce the rioting, the trespassing, and the violence that we saw that day. I'd like to read a portion of the transcript from him appearing on January 6, 2021 on the Tucker Carlson Tonight Show. The transcript, as Congressman Banks stated, he stated this, referring to the January 6th riot. Well, Tucker, this was absolutely heart-wrenching, gut-wrenching day on Capitol Hill. As someone who's worn the uniform and served our country abroad in Afghanistan and now serving my country on Capitol Hill, I couldn't believe what was unfolding right before my eyes in our nation's capital. That being said, I had busloads of constituents who drove to Washington, D.C. today. They drove through the night, with thousands of people from all over the state of Indiana, the Midwest, tens of thousands of people nationwide who came to our nation's capital to make their voices heard. And that was interrupted by thugs who stormed the Capitol. I hope we do everything we possibly can to prosecute those who brought violence to the Capitol and disrupted the democratic process in a very important debate that was occurring on the House floor. First and foremost, I hope that we prosecute these people seen in the photos that did what they did today, that cost the life of one individual and that brought violence to the Capitol building in many ways. And I'm happy to share this transcript with anybody who'd like it in its entirety.
I'll take it though, I mean, you didn't say that under oath or anything, right? That's just a transcript of it.
Correct.
Interview.
Correct.
And I don't know that I call Tucker Carlson necessarily a reliable source to go to this body, but.
But that was an exact.
All right, let's keep it.
That was an exact.
Right.
That was an exact quote by Congressman Banks on January 6, 2021.
I'm not saying at all that he was involved.
Your time is gone now.
I'd also like to make 3 additional points and stay within my time limit of 7 minutes. Congressman Banks himself has First Amendment rights to run for office. Additionally, this challenge seeks to deprive the 3rd District voters a choice and a voice in their own representation. Third, this challenge itself is an attempt to undermine democracy. We respectfully request this commission to deny the challenge and allow the voters of the 3rd District to be allowed to choose their representative and allow them to, Jim Banks to stay on the ballot. Thank you.
Yeah, I'm not at all saying that Jim Banks was part of the people that were rioting in front of the Capitol. What I am saying is he was part of what,
This was up here, 2-minute cross-examination, which is to be directed.
okay, was Jim Banks part of the Green Bay suite? Was he part of Peter
That was
Navarro?
not part of Mr. Mullins'
Green Bay suite?
remarks. Your questions, as we have for everybody else, have to be limited to the remarks and testimony provided by Mr. Mullins. I don't recall him saying anything about the Green Berets.
The Green Bay
I
Suite.
know. Do you have anything directed at Mr. Mullins over the comments? Do you have a rebuttal of any sort?
No, no, thank you.
Anything further? Rebuttal on your part?
Yes, that's where I'm going to bring this up if I can. I'm not talking about participation in the actual riot in the Capitol, people on outside busting the windows. I'm talking about what happened behind the scenes with 100 congressmen and senators in our country. They wanted to overturn, and this is a quote from Peter Navarra, and this was on national news everywhere. This is his quote. We wanted the scheme of the Green Bay sweep, and they swear that they were close to executing it, and it worked for the gosh darn violent insurrection attempt carried out by the Trump supporters. But that's what we plan on running with, and the ultimate goal of sending the election results of the 6 states back to the state houses where Republican legislatures would expect the overturn of the results. They wanted to steal the election. They wanted to turn over the results and make Trump president.
Those statements were also not made under oath, correct?
What's that?
The statements were also not made under oath.
These were statements that I actually heard him say in public on the television. I heard him say that myself.
They were not under oath.
What's that?
He was not under oath.
He was not under oath.
Any further?
No, that's it.
I'm going to close the public hearing on cause number 2022-10. Any discussion?
All right, as an attorney who practices constitutional law, I gotta tell you, I thought in reading this, that it was really interesting to think about, because there's very little law on insurrection. If I understand your theory, is what you're saying that the equivalent of an insurrection was trying to not certify President Biden's election, and the equivalent of taking the election from the duly elected candidate, is that right?
That's correct.
Do you know of any case law or anything that says that insurrection, that's what insurrection means? Because typically, when you think of insurrection, you're thinking.
There is no case law, ma'am, that I have found.
Okay.
All that I have found is that what the legal definition of, and that's what I started with. That is what the legal definition of an insurrection is. It doesn't say that it has to be a violent insurrection. It's just a support of a change of government.
Has Jim Banks been found guilty of insurrection in any court of law in the country or anywhere else that you're aware of?
No, he has not been charged with insurrection. There have been people who have been charged with insurrection.
Do you have any other evidence other than what you've already told?
No.
Do you have, the other thing I found though intriguing was that, do you have any case law where it's been interpreted that, because the constitutional provision also says if you give aid or comfort,
Correct.
and aid's a pretty broad word. Do you have any case law or anything that says that, that the refusal and the fight against certification inflame the people and encourage them to commit an insurrection?
I think that's being
Like
reviewed
that?
right now in the courts in North Carolina.
And my view is that, from what you're talking about, people, whether you agree or not, or I agree or not, people trying to kind of use the legal process, the legal system to challenge the election, which is very different from
Absolutely.
the normal, again.
When I heard,
I'm
when I
not,
heard-
sorry, I'm not, I think we're,
That's-
we
it
discussed
was-
this.
it was
I'm
at a
not-
time.
Yeah, I'm not, yeah, it's just, I think that this, is very different, from, in my mind, what happened on January 6th at the Capitol itself. And what I would perceive the definition of insurrection.
Well, I'm prepared to make a motion without respect to the regrettable mark in history that date will hold for us as Americans. I find no sufficient evidence of any kind to suggest that James Banks is guilty of insurrection and therefore should be removed. I would make a motion the challenge is denied. Is there a second?
I would second.
Any further discussion, questions? Motion to deny the challenge. All those in favor, signify by saying aye.
Aye.
The ayes have it.
Mr. Chair, I want to explain my vote. I'm voting to dismiss the challenge because there's lack of evidence. I have no opinion as to whether Congressman Banks participated in the insurrection or not. Oh, yeah, well, no, you dismiss it.
Dismiss the challenge.
Yeah, sorry.
I think you're voting
What's the opposite?
I think you're voting
The challenge is denied. The election division is directed to include the name of James Banks on the certified list of candidates to be printed on the ballot. Thank you.
And I'd like like to, before I thank the commission for your services.
Julio, sorry, I was moving next to you. Thank you. Yes, thank you, sir. Thank you. We wait till we hear cause number.
Well, that's not his.
Yeah. Should be like. We're now here, cause numbers 2022-5. In the matter of the challenge, Thomas Oakwalter, candidate for Republican Party nomination for United States Representative District 4. Quiet, please. A cause number 2022-13. In the matter of the challenge, Thomas Oakwalter, candidate for Republican Party nomination for United States. Representative District 4. I understand that Mr. Eckert has yielded his time to Mr. Ernie, the challenger. Since these two cases appear again to be substantially identical, can I get consent to consolidate? Consent given. Matters are consolidated. Opening remarks, Mr. Ernie, please state your name and spell it for the court reporter.
My name is Gregory Irby, IRBY, and I'm a resident of the 4th Congressional District. I'll try to keep your time short and simple today. Indiana Code 3827 requires that a candidate in the primary either meet one of the requirements to previous elections in the primary or get a waiver from the party chair. It's my understanding that submitted evidence that neither has happened, so I would respectfully request that.
Thank you. You have 2 minutes of cross-examination. So Mr. Irby, Mr. Irby's opening comments, would you like that? No, it's not necessary. Okay, would you like your 7 minutes? Yes, please. State your name and spell it.
And I need to give you these?
Yes.
My name is Charles Bookwalter, last name Bookwalter.
You have some.
Yes, yep. I thought the panel was small, I have 6.
That's okay. Would you just, for the record, state the nature of this information?
That's an affidavit that was given to the county chair and supporting documents for my argument today.
Okay.
Go ahead. Including DD 214 and other documents showing my affiliation and support of the Republican Party. So I prepared a statement, I'll just read to keep under 7 minutes. I'm here because I did not vote in the 2020 GOP primary. I did not vote in the 2020 primary because I did not have anyone to vote for. And by that I mean my congressional rep and President Trump ran unopposed. In addition, the GOP chair for Boone County, where I reside, refused to certify that I'm a party member. Despite my having provided her with an affidavit detailing my lifelong support for the party and of living its professed core values. Please see the attached letter and affidavit, and I'd like to highlight some of those points.
And for the record, I'm going to read this more kind of get your time. This is your own affidavit.
Yes.
Yes, okay. Signed by you.
It was emailed and delivered, notarized, emailed, and hand delivered to the party chair before the decision was made. I voted Republican in nearly every general election since 2000. I worked on Republican Party candidate campaigns while attending Indiana University. I've been a sustaining member of the party since 2002. You can see the documents on there that support that. I served in the Army Special Forces as a Green Beret, due to a request from President Bush. I completed 2 combat rotations and earned a Bronze Star for distinguished service in combat. I homeschool my 3 daughters and serve at our church. I invested in my community, building commercial real estate and a restaurant franchise, and provide jobs in my district. There's no question that I'm a Republican. The GOP chair acknowledged my conservative bona fides, encouraged me to seek a different office, and suggested that I wait until 2024. She said she would not provide the certifications because I had not voted in 2 primaries. She also stated her support for the incumbent and questioned why I would want to primary him. I filed the Can 2, notwithstanding I cannot check either of the boxes indicating compliance with IC 3827. I received 2 challenges from 2 GOP officials from my district. Neither alleges that I am not a Republican. And they did not challenge my candidacy for Republican Party delegate, only my candidacy for U.S. Congress. Please see the attached Can 37. The committee can and should construe this as an implied certification of my party membership because that is the only way you can enforce IC 3827 in a constitutional manner. The only basis they allege is that I did not strictly comply with IC 3827. The Wyatt case says that you must construe the election laws to promote franchisement and enfranchisement, and that strict compliance to the statute is not required unless the statute says that compliance is essential to a free and fair election, which IC 3827 is not. IC 3827 also has to be interpreted consistent with federal constitutional law. Anderson v. Celebres is the seminal case on ballot access restriction. Anderson v. Celebres says, where you impair ballot access, you impair voting rights. Ballot access and voting rights are at the core of the First Amendment. That is because voters can assert their preferences only through candidates or parties they vote for. The right to vote is heavily burdened. If that vote may be cast only for major party candidates at a time when other parties or candidates are, quote, clamoring for a place on the ballot. The exclusion of candidates also burdens voters' freedom of association because an election campaign is an effective platform for the expression of views on issues of the day, and a candidate serves as a rallying point for like-minded citizens. Substantial infringements on ballot access are subject to strict scrutiny. Anderson v. Celebres also says it is essential to a democracy that candidates be able to run on relatively short notice to respond to important issues. These important issues are exactly why I'm running. The last 2 years have seen the greatest loss of freedom in our lifetime, and our Republican leadership has been silent. You can't enforce this law in an unconstitutional way any more than a service member could follow an unlawful order. We all know that you would not enforce this law if it said that women or minorities couldn't vote. If you interpret 3827 strictly so as to bar my candidacy, you're implementing a 4+ year waiting period for candidates that aren't primary voters. You don't have to be a constitutional scholar to know that's a substantial burden on ballot access and voting rights.
Come on.
In the 2020 challenge hearing, this committee disqualified James Peters based on the one primary rule. In that hearing, Mr. Klutz told Mr. Peters, no harm done, you could just run in the next election. Well, that didn't happen because the legislator made one primary rule the 2 primary rule.
Yeah.
This is creating democracy where only professional politicians can get on the ballot. Who is to say that by 2024, the legislator won't go back and write 3827 into a 3 primary rule?
Yeah.
Anderson v. Celebres says that it's unconstitutional and it's an unconstitutional system. Voters can only express their preferences through candidates. On average, only 20% of Hoosiers vote for the primary. When you have a system where sometimes only 12% of voters vote in the primary, and the system excludes viable candidates from the primary because they are not 2-time primary voters, you are creating a cycle of disenfranchisement.
Yeah.
When professional politicians run unopposed, there's no reason to vote in the primary. Then, when the professional politicians create a crisis, which they always do, citizens have no recourse. Justice delayed is justice denied.
Yeah.
Yep.
Yeah.
Amen.
Regarding equality under the law, the Indiana GOP chair for Madison County apparently provided certification of party membership for Evan McMullen, who will challenge the incumbent Republican Mike Gaskell for nomination in Indiana Senate District 25. I'm almost done. Finally, there's an issue of notice. The 2 primary rule was passed in 2021 and are effective in 2022. I was qualified to run in 2018 and 2020 by virtue of voting in the 2016 primary. I have had no opportunity to vote in a primary since the 2 primary rule was passed and signed into law.
Good point.
In the 2020 hearing, Mr. Kochever stated that IC 3827 does not imply an obligation of good faith on the county party chairs. Well, of course it does. The legislature can't get around the Constitution by delegating an unconstitutional act.
Yeah.
I'm here today to ask you to.
That's the bulk of your time.
I have 1 sentence. I have one sentence, if I can say. Go ahead. Sorry, just trying to follow. Yes, sir. I'm here today to ask you to not violate the Constitution. There's no question that I'm a Republican, and the county chair should have signed my certification. Again, no one has filed any objection to my candidacy as a GOP delegate, and I will be on the ballot this primary as a delegate to the Republican Party.
Thank you. For the record,
I have no questions.
no cross-examination. Do you have any rebuttal? Nope. All right, I'm going to close the public hearing on the causes 2022-5 and 2022-14. Any discussion or questions by the commission?
Oh, one question. I just have to say, I found it in like I said, Mr. Brown, we have to follow along, and also as you have to vote in past two primaries, in two primaries, or you get 11. And you had opportunities to vote in those primaries in 2016, 2020. But anyway.
But, George, I'll let you finish, but I want to correct the record. That as of 2016, I was eligible to run for office.
So I'll change, and if you had voted, I'm saying.
You've already, that's already part of the record of your statement. Close the public hearing.
So, but I just have to say, I was kind of surprised when I looked at the evidence that was submitted by the changer, and it's from the GOP database, and it lists him as a Republican, a weak Republican, but it calls him a Republican. So I just wanted you to know that that's in there. I don't know whether that got in there by accident. It was in both challenges, so whoops. I just wanted to know that was interesting.
Just to respond to that briefly, I also have access to that database, and how it labels people isn't always right. If people haven't voted for a long time, it goes based off of their age and their gender, and it says typically that person, me as a 30-year-old female, it calls me a swing voter, even though I have a voting record. But if I didn't have a voting record, I would be swing. It doesn't take everything into account here. So just want to make that clarification.
Sure, no, and I agree with you. It's not an official record. What you submitted as evidence is not an official record. And so I agree with that. But to submit a piece of paper that says he's a Republican, I just thought it was interesting, you know?
Well, the evidence, as I understand, has been submitted is you've only, and you've agreed to it, you've only voted in one primary.
Yeah.
So what I hear you saying is that you disagree with the state statute.
Well, yes, of course, I do, and I think it's unconstitutional. But what I'm asking the committee right now, and based on what you said, is that you can't change the law. I'm not necessarily asking you to change the law right here, right now. I'm asking you to see that I am being withheld from.
You're asking us to vote against the law and put you on
It's
the
not,
ballot.
I'm asking you to hold the county chairs accountable, to not hold hold candidates off the ballot.
Exactly.
Because they're not determined.
That's not in our purview.
Yes. Yeah. There's an applied certification that I'm a Republican, and based on conversations, based on the affidavit, she made it clear that she did not want me to be on the ballot because she did not want me to primary Jim Barrett.
Let me, number one, and probably most important, let me thank you for your service to the country. I should not go without saying, so thank you. Number two, whether I agree or disagree with the rightness or wrongness of what the General Assembly over across the street, the State House has decided is not for me to say. Now, agree or disagree, that's the threshold, you didn't need it. Your fight is over there maybe?
But if they passed a law, if they passed a law that said minorities or women couldn't vote, I guarantee you would make the decision right here, right now.
If they applied that law, I probably wouldn't serve on this commission.
Exactly, so why would you do it for this case like this?
Right.
Now's the opportunity.
Hold on, hey.
Now's the opportunity.
I appreciate the argument that you're making. Unfortunately, I don't have a foundation by which to agree with you. In that, I'm ready to provide a motion to uphold the challenge. Is there a second?
I would second.
Having a second, any further conversation or questions? Hearing none, all those in favor of upholding the challenge signify by saying aye.
Aye.
The ayes have it. The challenge is held. The election commission is directed not to include Thomas Walter on the certified list of primary candidates sent to the county election boards and indicate the name of this candidate not to be printed on the ballot. Thank you for your time. Reach this board. Shame on you. Shame.
Shame on all. Now, moving to the next case. You will now hear cause number 2022-6. Sorry, 06, in the matter of the challenge to Mark Powell, candidate for Democratic Party nomination for the United States Representative District 6. The election commission has provided copies of the candidate filing challenge and may include accompanying forms and materials in your binder.
Okay, over here.
Please, over here.
And I apologize for.
Recognize the challenger, and this being some homes. Is that correct?
That is correct.
Could you spell that for the court?
Amanda, Amanda, Stevenson, Stevenson, dash Holmes, Holmes.
Okay, you have 7 minutes.
Thank you. I am the chair of the Johnson County Democratic Party, and I am challenging Reverend Mark Powell, the candidate, because he defies Indiana Code 3827, which I provided additional files. Under the 2022 Indiana Election Administrator's Manual, it states, further candidates seeking to run as a Democratic or Republican candidate must have either 1, selected the ballot of the political party they claim affiliation with the last 2 Indiana primary elections the candidate voted, or be certified as a member of the party by the county chair of the county where the candidate resides. In your previous packet, my filing, in 2020, Reverend Powell pulled a Democratic ballot, and in 2018, he pulled a Republican ballot. And of course, I defer to this election board, but I thought it worth noting that in yesterday's Johnson County Election Board meeting, they did vote unanimously to invalidate the candidacies of 2 other roles for Reverend Powell in the county on the county ballot yesterday. And I did receive that confirmation letter that I do have copies of for you.
Valerie.
Was that due to party not having to vote the same basis?
It was based on Rule 8 of the Indiana Democratic Party Rules subsection A, which states that the candidate supports the purposes of the party. That concludes my argument, my statements. Thank you very much for listening.
Thank you. Mr. Powell, would you like 2 minutes of cross-examination relative only to the statements that she's made?
Yes, Reverend Thompson.
Please spell that.
Reverend R-E-V, period, Mark, M-A-R-K, J, period, Powell, P-O-W-E-L-L. I do have a question for the chairwoman, and she cites the Democratic Party in disqualifying me to run for the most glorious office of precinct commander. And my question is, why does she make that case, and what sin have I committed?
She raised that, I guess, the issue of precinct commitment isn't even something before us today. I mean, if we could, and both of you, I mean, you attended this information, but I mean, we ought to really be sticking to the issue of your candidacy for the U.S. representative for the 6th district.
And I agree.
Sure.
And before I even mention that, I just want to thank you, Mr. Chairman, and members of the committee and commission for your service to our state and to its citizens. Question I bring that up is that it's the same issue that she brings forward today for this office, the office of the U.S. Representative of Congress.
Got your time here. So You have no further cross-examination?
I didn't. Yeah. And that is what is the sin that I committed against the Democratic Party?
The candidate, Reverend Powell, defies Indiana Code Law 3827. I did not describe it as a sin, I describe it as a law.
You've already established your challenge.
Thank you.
What's the law?
Sir, did you see the challenge before you came today?
I'm just asking her now.
No, I'm asking you. Did you see the challenge before you came today?
I had a little peek at it.
Okay. I think the challenge states it on it, doesn't it?
It references Indiana Code 3827, which references the Indiana primary elections. The candidate voted in, be certified as a member of the party county chair, or ballot, they must have voted, selected a ballot of the political party they claim affiliation with in the last 2 Indiana primary elections. And our candidate has only done so once.
Yeah, yes, I voted for myself for Congress, along with 10,000 other Democrats. And my question is, to the chairwoman, is that is the current law that is under question today, of how you can fulfill that law. And isn't it true, Madam Chairwoman?
Excuse me, will you two take your conversation further back in the room so that I can hear, please? Just be quiet, thank you. Oh, sorry.
Isn't it true, Madam Chairman, that
I'll afford you another 2 seconds.
I tried to pursue a conversation with you on multiple occasions, starting in November 2021. Is that correct?
That is correct.
Okay, so that's the end of your 2 minutes for cross-examination. Do you now like your 7 minutes for your remarks to state your case?
Of course. Because it looks like I might be having more time to watch Netflix than run for Congress coming up here. And that's fine and good. Because that's the way the law is written. And if we're going to follow the law by the letter of the law, then we have to do what you're going to have to do today. And I understand that. And I appreciate your effort being here, listening. My point is, having worked in the Michigan House of Representatives earlier in my life, as Chief of Staff to the Associate House Speaker and Health Policy Committee Chairman, I know how laws are written. Now, you're here to execute them. But again, I think Mr. Bookwalter makes a good point. What allows the legislature to carry on like it did last year, where in the dark of night, on a whimsical note, added this type of hardship to a number of candidates, myself included, who ran in 2020 as a Democrat and received nearly 10,000 Democratic votes. And now I'm not a Democrat. I'd like to put a number of items into the record. This item is the county chairman of Johnson County who said, let me just read this, that Mark J. Powell is a member of the above named party, Democrat, in good standing. That's Exhibit A. Exhibit B is my contribution to an up-and-coming woman candidate. Andrea Hunley is running for the state senate this year, $100 donation. This is Exhibit C. These are 4 receipts that I have, because I like to see a woman president, to Amy Klobuchar's campaign for president of the United States in 2020. That was distributed in 4 $25 donations. It was $100. They probably had equity to do that so that they could have more contributions. And finally, Exhibit D, which is my exhibit to, of a cash donation to the Stonewall Democrats of South Central Indiana, which they write to me, thank you for helping to advance the LGBTQI plus equity and representation in South Central Indiana. I don't agree with everything that everybody I gave money to. not everything. I just might not like the way somebody comes in here, or the policy of how that they might have. But I still contribute to it because I'm a Democrat. And I've tried to make this case, but you know what? There's a political opposition to my policies. I'm a more conservative Democrat. I'm a more libertarian Democrat. And I believe that we should have that type of debate within the party. And again, 2 years ago, I was on the ballot and received nearly 10,000 Democrat votes. If I was not a Democrat, those people would not have voted for me. If I was not a Democrat, I might have gotten a handful because of the way I part my hair. However, 10,000 Democrats voted for me. And this opportunity is disfranchising those and many more Democrats in the 6th congressional district, which is even more conservative than the 9th, because I have to deal with some of the folks in Bloomington, and let me tell you, when you deal with that blue bubble, you got a lot on your hands. So let me just say this, and I appreciate your time. And I know where this is going, so I appreciate your effort and your work. And I would like to get this off on the record, because 24 is just around the corner. My 2022 Democratic congressional campaign is dedicated to the memory of Jessica Doty Whitaker. Jessica, a 24-year-old mother and elder care assistant, was assassinated on July 4th weekend, 2020. Why was she murdered in cold blood in Indianapolis? She was white and said to a BLM supporter, "All lives matter." You see, Jessica has, with her fiance, who is Hispanic, his friend who is Hispanic, and his girlfriend, who was like the 44th president, both black and white. The assassin waited on a bridge overlooking the canal as Jessica's group passed, shots rang out, and she was mortally wounded by a shot to the head. As a pastor, I comforted the family. The family wanted action in finding the killer, and they asked me to help. They knew of my experience in government, and they knew of my empathy for what occurred. I personally called Senator Young's and Congressman Pence's office. And the senator did call Jessica's mother, Lee, to offer condolences. But asking to assist us deal with the FBI, as this was, in our view, a hate crime, fell on deaf ears. For far too long, Washington has ruled by big money and powerful interests. And these elected folks of both parties forget who they are supposed to work for, and that is the citizen. If I'm nominated by the Democratic Party May 3rd and elected on November 8th, I will continue to bulldog this assassination investigation until the killer is found. Before Almighty God, I swear to help find her assassin. Her parents deserve that. Her 4-year-old son deserves that. I also pledge to make sure that American middle class is cared for in my Our Fair Share program. So please pray for Jessica Doty Whitaker's family and friends, and for my candidacy as we remember Jessica and the millions of Americans affected by mindless violence. I am a Christian Democrat within the Democratic Party. I am pro-faith, pro-freedom, pro-gun rights, pro-life, and pro-America. I am against communists, socialists, racists, globalists, and all of those other kind of folks.
I have a few more minutes. I can start.
Anyone want to spend for 1 minute, I can say? Sorry.
No, I understand.
No, thank you.
Yes, I wish that there was more of a rebuttal. Because what this is here is a annual report. I appreciate your service on the annual report. I mean, you make it look like you're doing it, just like they did yesterday in Franklin. Well, I appreciate your replies, and I just want to state, for the record, as a hospice chaplain, I would always say to folks, before I left them, because I never knew if I was going to see them again, God loves you very much. He sent me here today to tell you that. And he sent you here today to hear that. So please pray for me. I'll pray for you. And we'll both be better off. God love you. God bless America. And hopefully in 24, I'll make the two. So, thank you.
Amen. With that, I'm going to close the public hearing on cause number 2022-6, 0666. Any questions or discussion? Go ahead.
I move that the challenge be upheld.
Okay, is there a second? Second. I have a motion to uphold the challenge with a second. Any further questions? Conversation or discussion, hearing none, all those in favor to uphold the challenge, signify by saying aye. Aye. The ayes have it, the challenge is upheld. The election is directed not to include Mark J. Powell on the certified list of primary candidates sent to the county election boards. To indicate the name of this candidate is not to be printed on the ballot.
Thank you.
Okay. Next cause, 2022-11, in the matter of the challenges to Zach Smith, candidate for Republican Party nomination for United States Representative District 6.
Oh, thank you.
The information is in your tab provided by the election division. I recognize Beth Boyce, the challenger, for her Southern presentation.
Good afternoon. Thank you all.
Please state your name and spell it for the board, please.
Yes. My name is Beth Boyce. It's B-E-T-H, last name B-O-Y-C-E. My name is Beth Boyce, and I am a registered voter in Johnson County and also the chairman of the Johnson County Republican Party. The challenge filed against Mr. Smith is very simple. Mr. Smith doesn't meet either requirement in Indiana Code 3-8-2-7, which sets forth the standard for determining a political party affiliation for a Democrat or Republican candidate who files a declaration of candidacy for primary election. Mr. Smith doesn't meet either requirement. He has no primary vote history in Indiana and never received a certification from the Republican county chair in his county of residence. Thank you.
Mr. Smith, would you like 2 minutes of cross-examination? May I have your opinion?
What's that?
Would you like to make some remarks? Sure.
My name is Zach Smith. It's Z-A-C-H-S-M-I-T-H. I do not dispute that I do not have either one of these requirements. One of the main reasons is I lived in the state of Ohio up until the beginning of last year. I grew up in Indiana, grew up in the town that I live in now. I moved back with my wife. Thank you. Glad to be back. I attempted to get the certification. I contacted the county chairperson, and she told me that I would not be certified unless I had voted in 2 previous primaries. So I would like to point out that there is a flaw in this statute that if I voted in the 2 primaries, there's no need to get the certification in the first place. So it's got to be either or. That I was asked for a meeting, wasn't granted a meeting, wasn't granted any way to plead my case to her that I'm a member of the party and that I should be certified. So that's all I have to say about that, and reiterate what other people have said before. I feel like this law is unconstitutional, and if this is a government board of invited people, people should decide, not the committee.
We're not, right? So we're following the law that was established across the street by 2 elected representatives. 6 voters. So up to you. I'm going to close the public hearing on cause number 2022-11. Any questions? I mean, I'm glad you come back to Indiana. And I welcome your interest in running for office. I didn't make the laws. So,
As long as I don't keep making it, the 3 primary rule, I'll be back.
don't forget about going over there. With that, I'll consider a motion.
I would move to uphold the challenge.
I'll second it. There's a motion to uphold and a second. Any conversation, discussion? Hearing none, all those in favor signify by saying aye.
Aye.
The ayes have it. The challenge is upheld. The election division is directed not to include Zach Smith on the certified list of primary candidates sent to the county election board and indicate that the name of this candidate not to be printed on the ballot. Let's see. Okay, next cause number 2022-26, Marcilli versus Tahir. Am I pronouncing that right?
Yeah.
In the matter of the challenge for Adnan.H. Tahir, the Democratic Party nomination for U.S. State Representative District 8. For your binder for the Information and Production Division, I now recognize Thomasina Marcilli, the challenger for presentation of these statements.
My name is Thomasina Marcilli, Thomasina, last name Marcilli, M-A-R-S as in Sam, I-L-I. I have these papers for you. I would like to, in full disclosure, I am an elected precinct committee person in Montgomery Precinct in Owen County. I am the elected Owen County Chair, and I am the elected 8th District Congressional Chair for the Democratic Central Committee. What is being brought before you today is not necessarily the voting record of Mr. DeGeer. The last 2 primaries of which he has voted in is 2006 and 2008, both of which he voted in a Democratic primary. What is in question currently is why Mr. DeGeer decided to be on the Democratic ballot whatsoever. He has stated, even as of this morning, which is in these papers, come all Republicans for this challenge. Mr. DeGeer is being asked to be placed on a Democratic ballot. I hold dear and sacred to that. We have a process in this election. In this election process, we have multiple ballots that he could be on. The Republican, which he could reach out to the Martin County chair and ask to be placed on that ballot, which he did not. He could also, after our primary process is over, go as an independent. Because in Indiana, we have a lot of people that like to ride the middle. However, during this election process, what he's saying is, I want to run as a Democrat because it's easier. Because I voted as a Democrat. Not because my values align with that party. And in this process, we need to question ourselves. Are we going to allow that? Are we going to allow the fact that someone has filed as a Democrat and is vocally and in public admitting that he is a Republican be on a Democratic ballot? To that I yield. Thank you for your time.
Thank you. Would you like to cross-examine?
No. My name is Adnan Dahir. It's ADNAMDHAHIR. I was born in Indianapolis, raised in United Methodist, and the only Middle Eastern thing about me is my name. I mean, I sound like a country hillbilly, and I realize it. The facts are simply these. By statute, my last 2 primaries voting has to be the same party as I'm declaring. And I've only voted in 2 primaries, and I voted Democrat in both. I have taken the stance to choose pro-life because my district in the majority chooses pro-life.
just as Frank McCloskey did when he won this district as a Democrat years ago. So to have anyone define my platform is just outrageous. The statute is simply this. And my Facebook post or anything, or my ideology, platform-wise, should not dictate my eligibility. Plain and simple, and that's all I have to say. Thank you.
So this morning, whenever you called on Republicans to come support you, can you tell me more about that?
Well, I'll tell you what, okay, last night, I haven't even been, I didn't even receive a letter. Mr. Peter Price, who is going to come up next, thank God he called me, okay? I haven't got 1 ounce sleep because I'm piping that. And I've also heard that there's somebody fitting her description going around Owen County saying that a Middle Eastern guy shouldn't be in Washington, D.C.
If you'd like me to show you my tattoo.
I don't need to see anything. So I'm not going to answer any more questions. Plain and simple. It's the statute, and here's the facts. Plain, I have nothing else to say.
So in closing, what stands is this. The gentleman has admitted that he is running as a Republican on social media. He is using Republicanism as a tactic and running on the Democratic ballot. I have no issues, fighting my Republican counterparts in the general election. We shouldn't have to do it in the primary. Because I pose to you this. What happens when the Trump Democrats that have voted in the Republican primary go on the ballot and get on a Republican primary, and then as soon as they win as Republicans in these small towns, what happens when they switch back over to Democrats immediately?
What does it matter?
I want to rebuttal to this. One thing, she is the district chair. She has taken it upon herself to go down and,
Excuse me, hey, let's keep the background chatter so that we get this on record.
and to have a meeting, okay? And to fully endorse Ray McCormick, who's not here. There's only 3 candidates in here. She's intending to give Democrats not one choice in the primary. That is your intention by challenging this, plain and simple. And it's hard for me, I'm gonna be honest with you. It is very hard for me to accept someone that's supposed to be in charge of our district not to get 1 ounce of support. Her vice president told me this morning that he suggested that Peter and I get introduced to their group before they made a vote. They didn't even offer to invite us. By siding with her, you are not only giving her the only choice on the Democrat ticket, but you're not allowing the American people to speak the will. And the simple fact of my position is I'm a representative of the people. And I can assure you, if elected, that I will not let any party dictate my voting. And if I should happen to vote with the Republicans on an issue, it's because the will of my people dictated my vote. Thank you.
With that, I'm going to close the public hearing on cause number 2022-26.
Thank you.
Any questions?
No, I don't have any questions, because I think the record's pretty clear. I mean, there's no dispute that he's met the statutory requirement. I mean, the thing is that I can understand the frustration, but I think that's where the electoral process comes in. But Yeah, that's, and the state has set forth this requirement that everyone knows by now, because we've been talking about it for a long time, but it's the, yeah, either you vote in the, the past two primaries of the party that you're seeking to affiliate with, or you've got the certification of the party chair. I think the legislature built that in so that if there's a dispute like this, that it's the voting record and not the certification, it's one or the other. You don't have to have both. And the statutory requirements.
Well, like the gentleman who moved here from out of state, he doesn't have the prior record,
Right.
the county chair would say.
Exactly, he could have run it, this county chair would have said, okay.
What's,
Yeah, first of all, I do want to tell you that, the records for the election division show your address is 6555 US 50?
Yes.
Okay, UPS says they left it at your front.
I did not receive it.
I just didn't want you to think
Okay.
that had not been done.
Yeah, I was literally alerted to this meeting at about 8 PM last night by Luke.
Okay, so secondly, just because someone calls themselves a member of a party doesn't mean they believe in the party ideals or commitments or platforms or whatever. So, when you say that Democrats have to have a choice, they have a choice. What I think this lady is saying is that you don't share those same ideals that make somebody a Democrat. Now, I don't know whether it's true or not, but I think that's what she's saying. So, ma'am, I would just refer to, I agree with Suzanne here, it's not a basis of how we can do anything.
We have gone through, and just to set the record straight, since
No,
this is
so,
a,
yeah, we're done with the public
Yeah.
matter, so you can't enter across the
Right.
record.
I mean, but you can take it to the party.
we have,
Because,
and
they did,
it was already.
yeah, Reverend Power,
So with that, I think we're probably ready for a motion, if someone's ready to give.
yes.
I would move that we deny the challenge.
Is there a second?
Second.
Having a motion and a second, is there any further discussion? Hearing none. All those in favor of denying the challenge, signify by saying aye.
Aye.
The ayes have it, the challenge is denied. The election division is directed to include the names of Adnan Dahir on the certified list of candidates. You turn it Next cause, 2022-27. Priest, is it Priest?
Yes, sir.
Versus Marsili. The matter challenges to Town Cena Marsili, candidate for Democratic Party nomination for United States Representative District 8. The election division has provided the information in your binders. Now, you two, please, I hate to do this, we just switch tables real quick.
No.
No, she's the,
I'm a challenger.
This is good.
it's getting late. Yeah.
This is right. I said it wrong.
No, you said it better, right?
I said it wrong. It's the challenge of Peter Priest, candidate for Democratic Party. Right. You correct the record. Cause number 2022-27 in the matter of Peter Priest, for the Democratic Party nomination for United States Representative District. Okay, I recognize, Ms. Marsili.
Thank you so much once again, Thomasina Marsili, THOMASINA, last name Marsili, MARS as in Sam, ILI. Once again, we have a situation, Mr. Priest has an amazing Democratic record. He has voted since well before we could even calculate the votes on ban. He has an amazing record of voting for Democrats. The unfortunate part is, even in the new evidence that I am also presenting, he is literally calling himself a Republican once again. That I have issue with. It's our civic duty as peoples in this body to realize a primary is for the parties. The general election is for all other parties to join in, right? Your independents. We have one candidate our board is voting for. And this is my challenge to that. We can go by primary voting, or we can challenge this in the fact that he is saying that he's a Democrat by voting as a Democrat, but outwardly in public, even to the chairs of the Central Committee, is writing emails stating, I wanted to run as a Republican. And to that, I would also state that at our meeting on Sunday, all of the same evidence was given to our central committee, which is compiled of 21 county chairs. 21 who voted unanimously. It was not my motion. I run the meetings as the chair. It was a motion from Knox County, a second from Clark County, and it was a unanimous consent to endorse Ray McCormick. It was not just me. So with that, you've heard my argument in this, and I will yield to Mr. Priest for his rebuttal.
Mr. Priest, you have 2 minutes of cross-examination for anything Ms. Marcelli has said.
Sure. Did you check the voting record system before you filed it?
Yes.
So you knew beforehand that I passed the test? The voting
Could you be more clear on your question, please?
Did you receive emails and texts from me trying to contact you to discuss my candidacy?
Could you be more specific?
Did you receive any emails from me that said, I'm running for Congress and I'd like to talk?
Yes, 3 days before I filed that.
Okay, so what qualifies you to choose who District 8 can vote for? What wisdom or personal experience makes your judgment good enough to choose which candidates should be on the ballot?
I don't get that. I can't challenge it as a voter though.
Yeah, but you're here as a representative of the party. You are here.
Here as a voter.
No.
That's who files the challenge.
No. You filed on a piece of paper that said on the desk of Thomasini, Democratic chair. Okay, you're not filing as an individual, you're filing as a member of the party, and you're trying to.
Did you have a question, sir?
I'm sorry, you're right, I had to do that, there you go. So, again, what was it that qualifies you to determine that I'm not Democrat enough?
Once again, the information that you also received in your packet, which would be the fact that you are, and writing to my chairs, and to myself, you also emailed me. In paragraph 8, you will find that it says, I wanted to run as a Republican, but I did not qualify. This is a repeat. You call yourself Peter Rhino. Republican in name only.
Okay, so the cross-examination, Mr. Priest, would you like to make some comments?
Yes, I do. I have a written statement. It's in your package. The package also includes screenshots from the website that she has had access and was able to view beforehand. And it also includes on the last page, the only page that probably really ever matters, which is that I have in fact voted 7 times since '92 in a Democratic primary, 0 times as a Republican, in a Republican primary. Okay, on Monday, February 7th, I had an amicable 15-minute phone conversation with Ray McCormick, the first announced Democratic Party candidate for U.S. House of Representatives in Indiana's 8th Congressional District. On Thursday, Marcelli filed a challenge to my candidacy with the election committee without ever speaking to me, without responding to my previous email request for a phone call. Marcelli filed the challenge in her capacity as a political party official on letterhead stating from the desk of Thomas C. Marcelli, 8th Democratic Congressional District Chair, claiming 5 pages of evidence. She's been touring Indiana using Democratic Party resources, endorsing Ray McCormick and Vince Sims without mentioning that Adnan from Shoals and I from Terre Haute are both on the ticket also. I say her challenge is a frivolous, mean-spirited tactic that covers up her unprofessional and possibly fraudulent behavior. She was negligent or incompetent in fact-checking. She failed to exercise due diligence in establishing the Twitter account was related to the candidate. She submitted a bunch of tweets. They're not mine. Right, yeah, she tortured logic to smear a man's reputation, all while undermining both Democratic with a small d and Democratic with a big D ideals. She failed to address the only legal basis for such a challenge, which is the voting record. Her submission didn't mention that. She did not tell you in her original filing that I voted 7 times as a Democrat in the primary. Okay, so I have never tweeted anything. The tweets appear to be those of my father, a retired humanities professor from Rose-Hulman. He was also president and CEO of Trade Frontiers, an international Christian tourism agency. I'd like to call him an ambassador of American culture to Russia, as well as an ambassador of Russian culture to America. He took students over there many, many times and brought Russian travelers over here, and it is in fact part of that how I get my Russian wife out of the others here. Right. In her package, she quotes one of those tweets and tries to claim this is a reason that you can't have me on the ticket here. It says, she implies it's wrong to attend a demonstration against bribery, corruption, backroom deals, and higher taxes. So I guess in a way I'd like to ask, is it the Democratic Party position to support and defend bribery, corruption, backroom deals, and higher taxes? What's her point? This was a blind man asking for a ride to Washington and, asking for help. And again, this is not my tweet, but let me say for the record, I am unequivocally against bribery, corruption, backroom deals, and higher taxes on the overtaxed. I also believe helping the blind is better than making fun of them. Another one of the tweets she puts in there, she condemns a Christian man accuses him of religious xenophobia. Because he has the audacity to tweet, is Islam a peaceful religion? If so, why do all these Mid-Eastern uprisings and ebullitions begin after Friday prayers? So she called that religious xenophobia. She probably meant Islamophobia. But again, what's that got to do with anything? The freedom of religion and religious expression does not mean we must all hold other people's religion to be as good as our own. It means more that we don't interfere with their choice of religious expression. There's nothing wrong with questioning somebody else's religious beliefs, and there's nothing wrong with them questioning yours. Xenophobia, on the other hand, is a dislike or prejudice against people of other countries. In the packet, I have more words in there about all the travel and things my dad has done in living in France, traveling to India. I feel like it was important to bring him up because in a public document, she tries to slam him, and I object to this. One of the other tweets in there was a quote from a tweet where she made sure that she had to spell out Vladimir Lenin's first name, which wasn't listed in the tweet, but just to make sure that anybody that doesn't know who Lenin is, the Russian guy, I don't know if this was just to attack me.
Would you permit me to be rude for just a second? In the interest of time, you've made your case, right?
Well, okay, let me just finish the last few paragraphs then. And that is this. I request a full accounting of all resources already given to the Ray McCormick for Congress campaign or its affiliates by the Indiana Democratic Party, the 8th Dems, its affiliates, Thomasina Marsili, or its associates. I request equal access to all the donor and volunteer data already given to or to be given to Ray McCormick by the same parties. And I furthermore ask that Thomasina Marsili be sanctioned for inappropriate use.
Okay, so you realize we can't do that stuff.
Okay, so you can't take any actions when someone comes here and wastes your time? She knows, she knew I am fully qualified.
I'm all about having time wasted today, but. I just want to make sure you understand, you're here defending a challenge from her as to whether or not you can be on the ballot. All of that My humble opinion is not really germane to that fact, so.
Sure, and my dad's experience in travels isn't germane either. But I wanted to take the time because
I appreciate that.
disgusted with
Would
that
you
sort
like
of
to
behavior.
both yield your rebuttal and cross-examinations? Would you like to both yield your rebuttal and cross-examinations? Say yes. Okay. All right, with that, I'm gonna call the public hearing on cause number 2022-27 to a close. Any discussion or questions? There be a motion.
And we deny the challenge.
There's a motion, is there a second?
Second.
So we have a second. Any discussion, hearing none, all those in favor of denying the challenge, signify by saying aye. Aye. The ayes have it, the challenge is denied, the election is All right. Directed to include the name of Peter Priest on the certified list of candidates to be voted on the ballot. Next case, 2022-21, the matter. Yeah. Oh, we have two, okay, sorry. Kes Vormus?
Yes.
Kes Vormus versus Oak, 2022-21, candidate Republican Party nomination for state representative District 20, as well as Stevens versus Oak, cause 2022-29, matter of Heather Oak, candidate for Republican nomination for candidate. Consent to combine these cases since they are eerily similar. Consent. Got consent.
Consent, sorry.
With that, as with all the other cases, the election division has provided this information in our binders. I will recognize Dave Keswormus.
Yes. For the record, I'll say I'm Dave Keswormus. I'm the Stark County Republican Chairman.
Just spell your name, please. Sorry.
Kesvormas.
As well as Alan Stevens.
Yes, Alan Stevens, LaPorte County Republican Chair, ALLENSTEVENS.
7 minutes for the two of you, please. Make your case. Go ahead.
Section 3 of the candidate 2 Canton form, state form 46439 election division gives two choices for the candidates' two most recent primary elections. Candidate indicated she meets requirements of having two primaries listed with the Republican Party. Review of her voting record, it shows that in 2020 primary, she has a Republican vote, and in 2016, it is listed as unknown. With that statement saying, I'm signing on this last page of the of that same declaration of candidacy, certifying that all the information is true and correct.
So you're certain that you can only verify she voted.
Yeah, and I've not been asked, this is the first time I've seen the candidate, so I've not been asked to sign off as the chairman of the candidacy.
Well, first off, I'd like to thank the commission for their time today. You guys are really earning your $50, so. Again, Alan Stevens, LaPorte County Republican Party Chairman. I think we can hear a lot of different things in this proceeding right now about this, that, or the other thing, but I think the only thing that this commission really has to rule on is IC 3-8-2-7, and that's two primary votes for the party or the chairman's certification, and there are neither in this situation.
Thank you. Would you like to answer cross-examination, anything you discussed?
No, I'll cover it.
Okay.
My name is Heather Oak, O-A-K-E. So according to the 2022 candidate guide on page 11, to seek a nomination in the May 3rd, 2022 primary election, a candidate must belong to the Democratic or Republican Party. One way this is determined is by the political party ballot requested by the candidate at the two most recent primary elections in Indiana the candidate voted. I checked the two primary box when filing for state rep because I did request a Republican ballot in 2020 and 2016. I believe, well, I know the reason why they're contesting me is because of that 2016 unknown, which I have, that's item 1 in there. This is something I have no control over. I lived in Stark County at the time 1 mile from the polling place. I specifically remember voting in the 2016 primary. I was going to vote for Ben Carson, but since he dropped out, I voted for Donald Trump. I even spoke about this to my mom, and she has attested to that discussion. See item number 2, I have her attestation that I did vote, and I told her that I did. I didn't even look at my voter file when I decided to run for state rep because I knew that I voted in 2 Republican primaries. But when I was looking over my walking list for LaPorte County, which I have that attached to, I searched my name and saw this discrepancy on my voter file. I then went to Stark County to get their walking list, and I also inquired about what the U meant on my voter file. The Stark County clerk said it meant unknown, and she printed it for me. I asked why would it be there, and she said she didn't know. The person that inputted the U no longer worked there, which her name is in there, who inputted the U. When I got home, I called a poll worker that I knew from Stark County, Tina Boffman, and she didn't know why unknown would be there either. My campaign manager contacted a poll worker, Vonda Olson, that she knew from Marshall County, and she also didn't know why it would be there, but said that she believed it would have been error due to a distraction on the poll worker's part. My campaign manager also called the county clerk from Marshall County, Deborah Vandermark, and she didn't know why unknown would be listed. So she did a search and found an unknown in Marshall County, but it was someone like myself that transferred in from Marshall County, or from Stark County. I know I voted Republican in 2016 primary, but I have no control over what is put into my voter file. And I would never have thought to check my file to make sure that a U wasn't mistakenly listed, since I would say most voters don't even know that exists. There are 2 options that can be picked when voting in the primary, and that is Republican or Democrat. If a poll worker forgot which one was requested, then this should be corrected by the county instead of entering in a U. This could easily be done by reaching out to the voter. If I am to be penalized for something I have no control over, then how can it be said that my vote counts? I did what I was supposed to do, and I voted in 2 Republican primaries. I requested 2 Republican ballots. I have always voted Republican, so I have no reason to question myself. If we can't rely on accurate information to be entered, then do we need to start taking pictures of our ballots and videotaping our voting experience? Or better yet, signing a form for verification of how we voted? When running for a political seat is determined by information entered into your voter file, that puts a lot of pressure on the poll workers and county staff. What profession has a 100% accuracy rate? I'm a nurse, and I know that even something as serious as medical care does not have a 100% accuracy rate. It turns out that Stark County had 99 unknowns listed in their walking list that we received. That's item 3. If there could be anything listed besides D for Democrat or R for Republican, shouldn't this be transparent to the voters ahead of time? Shouldn't there be a list of all the codes and what they mean and why they would be listed? In conclusion, I voted Republican in 2016 and 2020 primary, and according to Indiana Code 3-8-1-1.1, if a candidate filing error is made by the election division or a circuit court clerk, the error does not invalidate the filing. Shouldn't the same be said for error by poll workers or county clerks? Isn't there potential for them to make errors too? I'm attesting that I voted Republican in 2016. I was at the polls, and that you even attest to that. Otherwise, nothing would be there. If there's any doubt on where my allegiance is, please review items 4 through 9, which show my involvement with the Republican Party. Number 4 is my LaPorte County GOP membership receipts, plus donations for 2021 and 2022. Item number 5 is the LaPorte GOP meeting minutes and newsletters that I received via email. Item number 6 is the emails from the LaPorte County chair when I asked to go to the candidate school and it was full, but then there was a cancellation, he automatically put me in. Item number 7 is the email from the county chair and a list showing that I am appointed by him precinct committee man over Springfield 3. Item number 8 is a sign-in sheet for my state rep announcement party that him and his wife went to and signed on the line. They came to my announcement party. And lastly, item number 9 is emails regarding the GOP Christmas party that I helped out with. Thank you very much. If you have any other questions.
No, I'm just gonna say, I got no doubt Heather's a good one. Okay? But she does not meet the requirements of 3-8-2-7.
She voted. Hey, listen, this is not an open gallery, all right?
I appreciate her and her husband. They've given money to the party. They've been good. They're an appointed precinct person, but they do not meet the requirements of 3-8-2-7. And this is, your job isn't to conclude whether I think she's a good Republican or I don't think she's a Republican. Your job is to act on the law.
Well, so you did just submit for the record that you do think she's a good Republican.
I don't think she's a qualified,
That's not what I asked you. You just said she's a good Republican. Read that back. Was that, to make sure you're comment?
that was,
I guess, would she be considered a Republican in good standing is the question.
I can answer that. According to the new rules that were amended in 9/21 of last year, she is not, by not meeting the two requirements of having two voter primaries.
Well, hold on a second. So first of all, I'm going to close the public hearing matter on this case and we'll move into our discussion. Judge Shannon, go ahead, please.
What, okay, so, well, and actually, this is for staff, because this to me is different from these other ones, you know, which I regret, because we're all getting tired, but anyway, this is different, because I've never seen this unknown ballot type. I mean, it's a primary. It's,
How does
in
that happen?
Indiana, it's R or D, there's no other ballot type. And so we've got Ms. Oak sitting here saying that she requested a Republican ballot. Unknown, I mean, she has to have asked for a Republican or Democratic ballot. She is stating under oath that she asked for a Democrat ballot. Unknown, that she's, I'm sorry. I'm sorry.
She's
just saying that, I'm sorry, I know, sorry, yeah. I know people are correcting me. Anyway, she requested a specific party ballot, which happened to be Republican. I mean, there's no one else here can dispute that. This unknown, I don't see how the record is clear, she voted in the primaries. She has to request a ballot. Unknown isn't the type of ballot. She's saying under oath as Republican. To me, that means she meets the qualifications. I'd like to hear from staff, how does an unknown, I mean, where does this unknown ballot type come from when there is not such a thing in Indiana?
I'm happy to attempt to answer that question first, Mr. Chairman. That's fine. So the unknown, at least what we have in law currently, is Indiana Code 3-10-1-31.3, which generally is a requirement that after, in this case, really after every election, you have to update the voters' vote history in their SVRS record if they voted in that election, including in the primary, which primary ballot they requested and was marked on the poll list. Now, definitely Co-Director Nussmeier and others can state, we've known in the past that especially on a paper poll list, sometimes a mistake is made that is not captured on the poll list for whatever reason. And so thus under subsection A, it provides that, one, it applies to the primary within an election district where there is where more than one political party has nominees, so Democrats, Republicans going at the same time, for instance. It provides in part, a voter whose political party is not recorded on the poll list as required under section 24, that's 3-10-1-24, shall be shown as the voter's registration record as having cast an unknown ballot in that primary. So thus with this particular law right here, the unknown is because there wasn't anything indicating on the poll list which ballot the candidate requested in that particular election. But as it's been noted, matters have been put on the record under oath, attesting to what primary ballot was requested in that election.
Well, certainly it's a gray area. Co-counsel.
Yeah, I would agree with what co-counsel Co-Cheever said, and I would say that we do have cases where at times poll workers just, especially when it was paper poll lists before e-poll books, they just didn't write whether it was Republican or Democrat,
Something
and
got
then,
missed.
yes.
Mr. Chair?
Sure.
So, we've been discussing earlier evidence, and what you've come forward is evidence saying she's listed as an unknown. And you're saying this makes her unqualified. But the rule, the law, says while it says she had to vote Republican in the last two primaries, it doesn't say how that is to be proven. And the unknown either establishes it one way or another, and she has come in with evidence showing that she had requested that ballot. I mean, you have nothing to show that she requested anything but a Republican ballot. with the poll person and that who should have recorded it and everything. So, I think Suzanne is right. This is a very different situation.
It is not consistent with what the majority of cases we've dealt with today, where it's been pretty clear cut. I don't know how to resolve it other than to take a motion.
I would move that, I'm sorry.
Go ahead. You can make a motion.
I would move that the challenge be dismissed.
Challenge be denied. Is there a second?
I would second that.
Okay, there's a second. Any further conversation?
Just to note, I respect your due diligence as county chairs in trying to abide by the law, but I think it's pretty clear that the burden's on you as the challenger to show that she didn't pull two primary Republican voters, and I don't think we have that.
All those in favor signify by saying aye.
Aye.
I say nay, and only because, and I'll say this for the record, the opposite's actually true, right? There's just no proof either way. However, noting that 3-1 motion, I believe, carries. So unfortunately, or fortunately, depending on your view, the challenge is denied. The election division is directed to include the name of Heather Oak on the certified list of candidates to be printed on the ballot.
DeKalb County's election board threw this same thing out.
So the hearing's closed. Next matter, 2022-13, a matter of challenge to Maurice Fuller, candidate for the Democratic Party nomination for state representative, District 25. Is it pronounced?
Yes.
What? Hold on a second. What happened? What? I didn't know about that.
About 3 hours.
No, I mean, you got it. Keeping consistent with today's record, on a previous case, we in the final hours have been given a request to continue. I move that motion to continue be denied. Is there a second? Second. All those in favor signify by saying aye.
Aye.
The ayes have it. Please note for the record that Mr. Fuller is not here. Would you like to make any opening remarks?
Yes. My name is Erica, Ericka, middle name Boatwright, Boatwright. My last name is Pickell, Pickell. I'm here today as the Democratic Chair of Boone County. And honestly, this is just about his address and where he's registered to vote. He's registered to vote in Cass County at 1278 North County Road 900 West in Logansport, Indiana. And I'm just, challenging on the basis of IC 3-8-1-14. That he has not resided in the new House District 25.
Yeah, so the question is that you're supposed to have resided in the district for a certain amount of time before you run, and they drew the new house district, so he's now in a different district and he hasn't resided there for that time.
Correct.
Does that summarize the essence of your argument?
Yes.
Thank you. With that, I'm going to pull the public hearing on cause number 2022-13 to a close. Any discussion or questions from Ms. Pickell? Entertaining a motion?
Move to uphold the challenge.
Is there a second? I'll second it. We have a motion and a second. Hearing no discussion. Motion to uphold. All those in favor signify by saying aye.
Aye.
The ayes have it. The challenge is upheld. The election division is directed not to include Maurice Fuller on the certified list of primary candidates sent to the county election boards and indicate that the name of this candidate cannot be printed on the ballot.
Thank you.
Yes. Okay, I move that we go to a 5-minute recess, coming back at 5:50 PM in this same location. All those in favor, signify by aye. Excuse me. Hey, everybody. Just a quick note, I've been informed that if you leave the building, it's locked, you won't be back in. So just know that if you step outside and have a smoke break or make a phone call, you're out, so.
I have a silly question. Sure. So I'm going to be coming up and I'm going to be sitting right there, but you're not going to be able to see me.
Yeah, I have a pretty good view of everyone that's.
Can you do that?
You're sitting at the.
I'm going to be, they complained against me, I'm running for state representative.
So you'll be in this front seat here?
I'm going to be in this front seat right there. Yeah. So I just, I know I'm going to win. Yeah. It's kind of like a cut and dry, and I want to use it on Facebook.
It's streaming on YouTube, so you can kind of, so this is what it looks like here, so that you can both step over here.
Oh, okay. I mean, I know that sounds tacky.
No, that's fine.
But my husband's like, all right.
So you'll be pretty much in the position where this so as much as you can see her, you'll be able to see yourself there.
Like the, oh, I see. Oh, I see what you're saying. So it gets both sides.
Yeah, but then like usually when someone's testifying, actually then a little bit.
So like I'll be sitting here and you'll be able to
Yeah. And obviously, hopefully no one will be walking through.
No, like, see, like, you're over here, right?
Nope. We're on the other side. Yep. See, over there is where that lady's standing. That's eating right now.
Oh, okay, so pretty good. You're okay. But I just want to use this because it's like, I've never ran before, and it's like, come on, guys.
Yeah.
You know?
Yeah. So, no, that's it.
Thank you.
Yep. Yep, good. Good. Hold on, just a second. I think this mic is hot here. I don't know why channel 2 is on.
When we did exhibits, did we give them to you?
Yeah, I just.
Okay, I knew that process, so that was just curiosity. Okay.
Yeah, I'll come.
Oh, I'm sorry. Sorry about that.
I was just saying, here, you guys both have. Everyone watching this board, I'm gonna get you that point. I know. It's not, it's neat. I'm gonna do this so we can.
Cause number 2022-12. Painter versus Ellington. The matter to challenge Jeff Ellington, candidate for Republican Party nomination for Indiana State Representative. I recognize that Paul Nolan again has entered the appearance for Mr. Ellington. Mr. Painter's designated Mr. Bruce Borders as her representative in the matter. I recognize Mr. Borders. You have 7 minutes.
Thank you. Appreciate that. At the front of the binders that you guys will see a confidential investigator surveillance and research report done by Tina Skirvin of Trace Investigations. Summary basically on page 1. The investigations revealed that the Ellington primary residence is most likely at 680 West That Road in Bloomington. We completed approximately 20 hours of surveillance within a 5-day period of Ellington's 2 properties in Bloomington and Bloomfield. While 1 personal vehicle has occasionally been observed at 760 West Main Street in Bloomfield, a second personal vehicle has remained at the Bloomington address throughout the duration of the investigation. Both vehicles display a state representative license plate. The warehouse at 760 West Main Street in Bloomfield has been observed day and night. During day and nighttime hours, identical lighting remained on both during the day and night. Neither Jeff nor his wife Hope were ever observed inside or outside of the warehouse. No social media reveals that the couple have a dog, yet there was no sign of walking or taking a dog out for any purpose. The only activity witnessed was by 2 men driving a fitting simulation truck. These men were seen on 3 occasions at the Bloomfield warehouse. The men were not seen carrying materials or tools during any of the instances. When asked a general question about demolishing old homes, one of the men quickly replied with, "Jeff lives here now, see the surveillance summary," which we will share that. During one surveillance, Lindsay Ellington, Jeff's daughter, and her fiance, who currently reside in Illinois, visited with the Ellington family at the Bloomington residence. Both personal vehicles that display a state representative license plate were seen at the Bloomington residence during this visit. I'm going to jump on down to the comment about the 2 men with the mini simulation truck. It's down about the middle of page 2. It says, Investigator Skirvin talked with one of the men when asked the general question of, does paint simulation tear down and haul away old houses? The man replied abruptly with, "Jeff lives here now." Returned to 760 Main Street in Bloomfield at approximately 8:30 p.m. on Friday, February the 4th. In addition to the 2 Ellington trucks, there was a white Mercedes GLK 350 SUV. Then down below, it says, this vehicle is registered to Jeffrey and Hope Ellington. Note, however, that the Indiana official registration record reflects that this license plate is registered to a 1977 red Mercedes-Benz, not to the white Mercedes GLK K350. On that, it says surveillance concluded at 11:05 p.m. No movement within or outside of the warehouse was observed. Lights remained on at the time of departure. Then back to the Bloomington property at the bottom of page 2. Arrived at approximately 2:40 p.m. to 680 West That Road in Bloomington, Indiana. The white Mercedes GLK 350 SUV with state representative license plate 30 was present, along with number 2 on page 3 at the top of it, a black Lexus LS 430 4-door sedan with state representative license plate 130 registered to Jeffrey Roger Ellington. Note, however, and we do have certified copies from the B&B, the official registrant record for this license plate is registered to a 1972 black Oldsmobile Cutlass Supreme. And basically the rest of that through page 4 has to do with the times they visited and the fact that the entire time they were there at the property in Bloomfield, they never saw Jeff or Hope Ellington, and they never saw, other than the 2 men who had the Phoenix demolition truck, which was registered to Jeffrey Ellington, but they never did see anyone other than them, and they never saw them carrying the interrupt materials. On page 5 at the bottom of it, summary of research, property records. Ellington owns property located in Monroe County at 680 West That Road in Bloomington. The property address reflects the same as the property owner address, 680 West That Road in Bloomington. And we also have it attached to parcel information / tax bill for that property. All right, and then on just below that on the bottom of page 5, Ellington also owns property located in Greene County at 760 Main Street, Bloomfield. Verification was obtained from Kathy at the Greene County Auditor's Office on February 10th, 2022, that there is not a homestead exemption or any deductions listed for this property. The location address is listed as 760 North Main Street. However, the ownership address is listed as 680 West That Road in Bloomington. We also have a property card for that. Secretary of State filings on page 6 at the top. Of the various businesses Ellington currently owns, or has owned in the past. Only one is registered with the Indiana Secretary of State. Walnut Street Courtyard LLC, West Ellington is the registered agent with an address of 680 That Road, Bloomington, Indiana, 47403. And then J.R. Ellington Tree Experts. You go to their website, and we've got a reference to it. The website for J.R. Ellington Tree Experts does not list Bloomfield as an area that's served. All right, and then if you go, the next section, which we have tabbed out, is an interview with Steve Corbin, the owner of Feed Store Beer Company, which is next door. I entered that as evidence as well. And that down towards the bottom of the page, the third to the last paragraph, it says, Steve openly revealed that he does not feel as if the Ellingtons live in the warehouse full time. Steve and Jeff talk with each other fairly regularly. Steve was surprised when Jeff told him they were going to live in the warehouse. The warehouse is bricked with thousands of single pane windows. He admitted it does not have ideal living conditions. And anyhow, then if you go into the next page, it's the state of Indiana certification of B&B record, registration plate 30, plate type SR, that means state representative, I understand, because I have one of those as well. VIN number, and then this is a certified copy from the state of Indiana. And if you go into the vehicle that plate is registered to, go into the next page, page 2 of that, it's registered to a 1977 Mercedes-Benz 450 SL, and it is red in color, not the 2015 Mercedes-Benz that they're claiming. And then if you go to the next page that says for license and investigative purposes only, it shows that the 2015 Mercedes-Benz is not registered to the Ellingtons, and I have a letter following that from Tina Skirvin of Trace Investigations. And it says the white Mercedes-Benz that holds the state representative license plate of 30 is not registered with the Indiana B&B. I find no registration for a white Mercedes-Benz under Jeff or Hope Ellington. In addition, I find no registration for a black Lexus LS 430. And then if you go to the next page, state of Indiana certification of B&B record, registration plate number 130, plate type SR, which means state representative. It has a VIN number. Go to the next page after that, and it shows that state representative's plate. Sorry, I'm going to grab a drink. I'm talking fast. I'm sorry?
So you're just making use of your time.
Thank you. And it belongs to a 1972 Oldsmobile Honda Supreme Black, and I will read Indiana code. I'm not done. Sorry.
Well, that's the extent of your time. By consent, would you like to offer any further?
Consent.
I'll give you 2 more minutes.
Thank you. Indiana Code Title 9, subsection 9 through 18 .1-4-5 says a vehicle required to be registered under this article may not be used or operated on a highway if the vehicle displays any of the following: a license plate belonging to any other vehicle. And the reason I'm sharing this, I've had people say, what's that got to do with residence? I think it has to do with integrity. All right, my vehicles are titled to my wife and I, and they are on the proper vehicles. And I think this shows basically a behavioral thing. But and then if you go to the cards there, we have the property cards. What's interesting to me as well, if you go onto the payment history on his taxes, the taxes on this quote unquote home that he's so proud of, and I apologize, I'm being a little smarky with it, and I'm sorry for that. But on the taxes were not paid until January the 10th of 2022 on the building in Bloomfield. And my point is, if that's your home and that's the place that you're claiming that you're so proud of, why would you wait until basically the taxes are due, I believe, by November the 10th? And so we're looking at December, January, waiting 2 more months to pay your taxes. All right, and on the vehicles, I have no idea, the investigator said she has never seen anything like that. Then following, I have the Domestic Limited Liability Company, Woman at Street Courtyard LLC, 680 That Road in Bloomington is the principal office address. We have conversations. Here's one from Angie Jacobs. She said, I had a conversation with Hope Ellington on Monday, January 31st, 2022. And in part of this, she says, during the conversation, she brought up redistricting, meaning Hope, and told me that her husband, Jeff, Mr. Ellington, had asked them, I think she said the speaker and or Representative Sturwall, to keep their home in the district with Greene County. I think that's what she said. And if they didn't do so, they would move. Since that wasn't done with redistricting, and they didn't think the new district was winnable for him, she said they had to move within a week of the redistricting. Sorry. Thank you.
2 minutes of cross-examination to the remarks that Mr. Board has made.
Sir, do you know how many vehicles Representative Ellington owns?
I do not.
Sir, do you know how many properties Representative Ellington owns?
I do not.
Do you know how many of Representative Ellington's vehicles are for his businesses as opposed to personal use?
I do not.
Sir, do you know how many of his vehicles are salvaged vehicles not requiring a title?
I do not, and I don't see the, what that means, what that has to do with anything. I have, actually, the vehicle I drove up in is I'm sorry.
And then, sir, am I correct? You're also on the ballot in the newly drawn House District 45?
Actually, yes, but I didn't have to move to be in District 45.
That's all. Thank you. Thank you. My name is Paul Mullen. I'm joined today from my office with Emily Stewart-Fair. I represent Jeff Ellington. Jeff is a candidate for newly drawn House District 45. He is currently the incumbent and the representative in District what is going away 62. The allegations against Representative Jeff Ellington are false, and they're politically motivated by a faction that wants to remove the decision by the voters to be able to select their representative. We ask that the challenge against him fail and that he remain on the ballot and allow the voters to make a decision. I wrote here in my notes because I was anticipating you were going to hear allegations that he doesn't satisfy the residency requirement, but you didn't hear that. Indiana Code 38114 provides the residency requirement for a candidate for office of representative in the General Assembly. It's very straightforward. One is you have to be a U.S. citizen. He is. Two, you have to have resided in the state for at least 2 years and in the House district for at least 1 year before Election Day. And he will have satisfied this, and we'll demonstrate this momentarily. He will have satisfied this by Election Day, November 2022. And the last requirement is be at least 21 years of age by taking office. He is. Indiana Code on the residency requirement, which is what this hearing is about, it does not list anything about auto registration or where businesses are placed. So as I mentioned, he's currently the representative for District 62 and is now a candidate for the newly drawn District 45, House District 45. House District 45 includes Bloomfield. Representative Ellington has resided at 760 West Main Street, Bloomfield, Indiana, for a time period that well exceeds the 1 year requirement, the 1 year residency requirement. And we'll demonstrate this momentarily through testimony and exhibits, and ask that the committee find that the complainant has failed to meet their burden in the case be dismissed. Election Day is November 8th, 2022. So to satisfy his residency requirement, Representative Ellington will have needed to live in the new House District 45, which Bloomfield is in, since November 8th, 2021 or before. That's the dispositive question, not where his autos are registered. With the balance of our time, we'll demonstrate that Representative Ellington does satisfy IC 38114 with exhibits and testimony. And with the committee's permission, I'd like to call Representative Ellington as a witness and ask him questions.
It's part of your 7 minutes.
All right. Sir, what year were you elected?
Excuse me, before you go, were you here early enough to be administered?
Yes, I was.
Okay. State your name.
Jeff Ellington, JEFFELLINGTON.
Representative Ellington, what year were you elected?
I was caucused in 2015 and elected through the election process in 16.
Okay.
And there since.
And do you now reside in the new House District 45?
I do.
And have you, as of Election Day 2022, will you have resided there for over 1 year?
I have.
And is Bloomfield, Indiana, in House District 45?
It is.
And presently, where do you reside?
In a big 4-story commercial building that I purchased in 2018. We've been redoing it ever since. And that's 760 West Main Street.
Bloomfield, Indiana.
Bloomfield, Indiana.
And who do you live there with?
My wife, Hope.
And how long have you owned this property?
I've owned it since 2018, I think around September 2018.
And did the two of you make this your primary residence in early October 2021?
Yes, we started spending the night there October 1st to that weekend of the Apple Festival.
All right, and since October 1st, 2021 through the present, how often, characterizing your own words, have you stayed with Bloomfield property?
I have 3 businesses in Bloomington. So when I'm not working on the inside of the home, I drive there to do estimates, get the crews going, to repair stuff. Also in Bloomington, I have a 24-hour horse stables there that has somebody that lives on site that takes care of the horses. But I also have to go there and help sometimes. And then for the middle of October, we drove back quite often to Bloomington because my wife's father was getting ready to pass away, and he was living there at 680 West That Road. And he passed away October 26th.
Since early October 2021 to the present, would you characterize the amount of time that you've slept at the Bloomfield property as almost nightly?
Almost nightly, yes.
Is 760 West Main Street, Bloomfield, Indiana, your true fixed permanent home and principal establishment?
It is.
And has that been true since at least early October 2021?
It has.
And when you are absent from, like you are now, when you are absent from 760 West Main Street, Bloomfield, Indiana, is it your intention to return there?
It is, and has been.
All right, and I would like to go through exhibits. We've provided exhibits to the committee. They're in front of you. I've made a table of contents. However, some exhibits we collected today, and I've added those as well. And we'll roll through these as quickly as possible. Exhibit A, I'd like to take your attention to. And if I may, I go ahead and I would like to move for an additional 2 minutes.
Granted 2 minutes is a consent.
Thank you. Referring to Exhibit A, at the top is a file October 18th, 2021. Yes.
Yes.
Okay. And is this a notice of change of use of property receiving a homestead exemption?
Yes.
Okay. And at the bottom, does it list your previous address as the Bloomington address?
It does.
And does it also say at the bottom, no longer primary residence?
Yes.
And at the bottom, is that your signature with the date October 18th, 2021?
Yes.
Okay. Referring to Exhibit B, is this your voter registration?
It is.
Okay. And does this demonstrate that your address is 760 West Main Street, Bloomfield, Indiana?
Yes.
And is this your signature dated October 20th, 2021?
Yes.
Looking at Exhibit C, is this a printout from the Secretary of State's website?
Yes.
And does it demonstrate that your address for voting purposes is 760 West Main Street?
Yes.
And is it starting October 2021, is that correct?
Yes.
In Bloomfield, Indiana?
Yes.
Exhibit D, is this a copy of your driver's license?
It is.
All right, and at the bottom, does it say ISS presumably issued October 21st, 2021?
It does.
Okay, and does it list your home address as 760 West Main Street, Bloomfield, Indiana?
It does.
47424?
Yes.
All right, this one's interesting. This is, sir, this is a fire call sheet from Greene County.
It is. Yes.
Okay, and was this created by the Greene County First Responder Sheriff's Department?
Came right through Central Dispatch to the Sheriff's Department.
And they came to your house on November 1st, 2021, correct?
They did, yes.
All right, and then at the bottom it says comments, and this was entered in, am I correct, this was entered in by the fire department?
Yes.
Does it say, with the fire department entered, Jeff Ellington advised he and his wife now live here, and they do have a wood stove?
Yes, it was on a smoke alarm, fire call. They thought the building was on fire.
And that's Exhibit E.
And they met me at the front door.
And then I'd like to refer you to Exhibit F, which is a letter from Julia Bartlow. Who was that?
That's the Greene County Party Chair.
Okay, the letter speaks for itself, but does it include a sentence in here that says, we welcome them being you and your wife as full-time residents from a neighbor perspective at the beginning of October 2021, and Jeff registered to vote as a Greene County resident October 20th, 2021.
Yes.
Okay. And I would, I guess, add the remainder, the balance of our exhibits, their utilities. I'll represent to you that it demonstrates that he pays Duke Utility, natural gas, at the Bloomfield residence, water and sewage, Bloomfield residence, Comcast, Bloomfield residence, repairs, Bloomfield residence. His wife there's a postal service, change of address for the Bloomfield residents, and this is all well before November 1st, 2021, voter registration as well as bank records that he resides there. And that with the evidence coupled with his testimony, we believe demonstrates that his residency is in Bloomfield in the new House district, and he meets the residency requirements as provided in the Indiana Code. And we ask that you find everything.
We have 2 minutes to cross-examine only relative to what's been provided.
Yes, one of the statements that was mentioned earlier, and I could stand slightly corrected, but I believe the attorney for Mr. Ellington commented that District 62 would no longer existed or something along those lines. District 62 absolutely exists. And you know, and did you say that, sir?
The lines changed. The new maps were drawn.
Okay, all right, but it still includes the home on that road, okay? The other thing is, just because somebody, I guess what I'm hearing is a preponderance of statements that just because somebody says, okay, I've changed my voter registration address, I've changed this document, I've changed that document, and yet when you see, for example, the vehicles, I mean, you can see, but I'm sorry, I'm done with the cross-examination. My apologies, sorry.
Do you have any rebuttal?
My only rebuttal is that we entered evidence that supports what the legal requirements are. He's met the legal requirements, both code and case law. And we ask that he remain on the ballot. And then one last comment.
Just like to say that, you know, I'm a little unique from a lot of people. People drive hours to go to work at a nice job. I've got 3 businesses at my business. I get employees that work for me. They drive vehicles. I've got 5 and 6 cars. I got 8 cars at my building in Bloomfield. I've got 5 or 6 big trucks that I use back and forth. My son, my daughter, my future son-in-law, and my workers, they grab my cars and move them and take them. And I do have some salvage vehicles that's still waiting on paperwork from the BMV to get the original titles back.
Yeah.
So, thank you.
2 minutes of rebuttal.
Yeah, I mean, the bottom line is this, you know, quite frankly, I find it amazing that I do a lot of property rehabs myself. In fact, we probably rehabbed about 120 properties. And the bottom line is, and Greene County is my home. That's been my lifetime home. I go through Bloomfield all the time, and we're constantly going over to Lowe's in Bloomington or Menards in Bloomington to buy building materials or ABC supplies. And the bottom line is just, I see no signs of life there. Occasionally we'll see, you know, a truck that basically has his campaign, you know, logo on it. There's typically an Ellington tree trimming truck that's placed out there, but nearly never is there a personal vehicle out. And I know in you know, one day when the Republicans were gathering, we were talking to the State House about the new districts, he was very upset. And what drew my attention to it was whenever he had made a statement, he or his wife or both of them, on a Facebook post that, or one of the posts they were on social media, that, you know, that they
objected the introduction.
I'm sorry?
Continue.
All right, that, you know, the bottom line was they weren't running for District 62 because something about that Monroe County, Brown County firewall will never be breached by a Democrat. I think that's almost exactly the statement on it. And so when I saw that, I thought, wait a minute, this isn't the same state representative that I heard throwing a fit at the State House about his new district and so forth. And I think the bottom line is that at that point, they were looking to just scrambling to find an address that was in the new District 45 that he considered friendly territory. But the bottom line is that the evidence, I think, strongly supports it. If you look at the photos as well, that he does not live there.
With that, I'm going to close the public hearing on cause number 2022-12. Questions, comments? Co-counsel is, what's the law say about your residency? I mean, he's got a driver's license. Those indeed days that establish residency.
I don't see anything about driver's license, but there is a presumption regarding residency in 3556. 355 generally covers residency, but 3556, I'll just read it here. A person can rebut these presumptions by demonstrating intent to reside in another precinct or conduct taken to implement that intent. B, an individual who makes a statement regarding the residence of an individual under the penalties of perjury is presumed to reside at the location specified by the individual as of the date of making the statement. So I point that out as a relevant statute for you to look at. I don't see anything as far as with driver's license. There is statute that says that residents can't be in more than one precinct or in and out of state. That's 3553.
Could getting a driver's license and your voter registration construe intent?
I would say that it could, yes.
Well, Mr. Chairman, members of the commission, I concur with my counsel's analysis of 355.
Co-counsel, co-chief, anything you want to add?
No, I believe my counterpart, co-counsel Valerie has stated very well. 355 is where we all look to for the different presumptions of residency, and also to your question, I also agree that getting a driver's license, changing property records, what have you, all can go towards intent. But I agree with the statements that have been made by staff of the election division here.
I gotta say, you found some things that make this very weird.
I let that happen.
Let me track that. Weird's not the way I want to see it. This is unusual. But I'm inclined to see the evidence is that he has created intent to call that his residence. Has utility bills and driver's license and voter registration that all say he lives there. With that, I guess I will offer a motion.
Can I ask a question
Sure,
of
go
council
ahead.
and the directors? There's just something I was reading here, that presumption that Valerie was talking about. It says section 7 through 17 of the chapter establish presumptions regarding the residency of a person in a precinct. He has not been challenged for living in a precinct, so do these presumptions apply?
Are you asking me?
Yeah, I would take that and I would say yes. 355 is the standards that we use for determining residency for an
Yes.
election district.
Yes, I'm just, I'm sorry.
No, you're good.
But in there, I do agree with Valerie on this. Also, I would just refer you over to the 3-5-5-1, which is the purpose, stating the purpose of the chapter, which in part says, the chapter shall be used to determine the residency of the following to a candidate. And so the different presumptions that are mentioned in here are just different ways that one can either show they reside in a certain location for candidacy purposes or to rebut any statement of residency that has been made.
Yeah, I mean, typically, I would agree with you, except for they didn't have to include the language residency of a person in a precinct. They could have just said challenging residency. And then when they talk about a person holding elected office, that could be a precinct committee person to which challenging a precinct would work. But that's, I mean, I'm just, I don't want to be wrong.
It's too late. Well, license plate thing, while somewhat disturbing, I guess I would make a motion to deny the challenge. Is there a second?
I will second that motion.
Any discussion? Hearing none, all those in favor of denying the challenge signify by saying aye. Aye. The ayes have it. The challenge is denied. The election division is directed to include the name of Jeff Ellington on the certified list of candidates to be printed on the ballot.
Thank you for your time. And again, I'd like to thank everybody at the tables for your service in Indiana.
Should I get something?
Yeah.
Next cause number 2022-22, Holtz v. Rainey, in the matter of the challenge to Amy Rainey, candidate for Republican Party nomination of Indiana State Representative District 49. Please refer to your binders for any information. Recognize the challenger.
My name is Dan Holtz, last name Holtz.
Okay.
I'm the Elkhart County Republican Chairman. I was hoping to greet you all with good afternoon, but I think I have to say good evening. I didn't hire any any private eyes, so I hope this is short.
I'll state for the record that just because you're afforded 7 minutes doesn't mean you have to use it.
Right, well, I'm familiar with the statute. I know that it's new. I understand that it allows 2 methods for someone to qualify. I would simply add that in conversations with Republican office holders in Elkhart County and precinct committeemen in Elkhart County and people that have attended our events for a long time, I've asked them what their feelings are about this rule. And the preponderance is that the requirement under subsection A presents to citizens in this state a 3-inch hurdle race, that they have to jump over the hurdle twice. By that, I don't mean to be flippant, I just mean that the opinion that I received is that it is an easy requirement to meet. And therefore, I have, in this instance, not provided a certificate to exempt requirement in A, and the filer did not meet the requirement under A.
Would you like to cross-examine?
Yes, I am.
No questions, only related to the comments he's just made.
Yes. My name is Amy Rainey, Rainey, and the question I have, on your CAN 1 form in item number 6, can you read for us what you included as part of your challenge?
No, I cannot.
Did you reference the CAN challenge in your opening remarks?
No.
Okay, I can make it part of my statement. Yep.
All right, would you like to move to that?
Yes, I would. I would like to thank the Election Commission for the opportunity to respond to this challenge. On the CAN 1 form submitted by Dan Holtz on February 11th, Mr. Holtz stated, Ms. Rainey has not voted in 2 Republican primaries. When I completed the CAN 2 form to declare my candidacy, I did not claim affiliation with the Republican Party based upon my primary voting history. I claimed affiliation with the Republican Party based upon my 2022 membership in the Elkhart County Republican Party. That certification is attached to my CAN 2 as required. The challenge is invalid and should be denied for the following reason. The only fact leading Mr. Holtz to believe that I am an ineligible candidate is that I had not voted in 2 Republican primaries. First of all, that's factually incorrect. Second of all, the evidence submitted shows that Mr. Holtz was aware that I had voted in 2 primaries. And thirdly, on my CAN 2 form, that is not the box I checked to confirm my affiliation with the Republican
Do
Party.
you have proof that you voted in 2 Republican primaries?
I voted in a Republican primary in South Carolina and in Indiana.
But you don't have any proof of the South Carolina.
I do.
Well, but
Yes.
it's.
Doesn't matter.
Yeah, the statute's Indiana.
So you acknowledge that you have not voted in 2 Indiana Republican
In 2
primaries?
Indiana primaries, yes, which is why when I.
Or do you have an exemption or a certification from the county chair?
Well, I'm literally a card-carrying member of
But
the
you do not
Elkhart
have
County
something
GOP.
from the county chair.
Is there a certain form that's required for the certification?
I don't know how you get that. The county chair has not granted you anything that says you're in good standing as a Republican, you can run the Republican primary, correct?
I'm a card-carrying member of the Elkhart County Republican Party, and I'm also listed on their website as a sponsor. On the official Elkhart County GOP website, I am listed as a sponsor, along with 2 Indiana senators, as well as an elected county councilman.
But you don't have a written certification from the county party chair that certifies you to run as a Republican, right?
I have the evidence that I
Not
presented.
that, not that, you don't have a written, you didn't file a written certification, right?
There's a form, well, she filed this thing saying that she's
I
at
filed the
20.
evidence that I had available.
Okay, so, but it's not a certification form, no. I mean, I don't doubt you're Republican,
What's
but
the
the
statute,
statute,
what specifically does the statute say about that? It's either two Republican primaries or.
last two, last primaries that you voted. Yeah, right?
I'm here, it was gonna be figured, I'm at 327. Okay.
Yeah, I'm asking, I'm not doubting your sense of being a Republican here, because that's not really what's.
All right, here,
Yeah.
you ready?
Yeah.
3827. This is a statement of a candidate's party affiliation for purposes of the subdivision. A candidate is considered to be affiliated with a political party only if any of the two of the following applies. The two most recent primary elections in Indiana in which the candidate voted were primary elections held by the party with which the candidate claims affiliation. If the candidate cast a nonpartisan ballot at an election held at the most recent primary election in which the candidate voted, a certification by the county chairman under Clause B is required. B, the county chairman of the political party with which the candidate claims affiliation and the county in which the candidate resides certifies that the candidate is a member of the political party.
I think the question here is what counts as certified. I'm literally a card-carrying member of the Elkhart County Republican Party. The Elkhart County Chair
Excuse
is,
me, just a second, though. Read that again, certification from the county chair.
Yes.
Is your card signed?
it came with a card that contained the signatures, yes.
His signature, the county chair's signature?
As far as I'm aware.
It says a certification by the county chairman under Clause B, and then I'll just repeat it again, a county chairman of the political party with which the candidate claims affiliation in the county in which the candidate resides certifies that the candidate is a member of the political party.
You did send a note saying thank you for your dues.
No, I didn't.
Oh, you did not?
No. Our secretary signs thank you cards to people. And I think earlier in this hearing, we have all heard people say they wish the legislature was clearer or they don't like what they wrote. I don't necessarily like what they wrote, but that's what they wrote and she does not comply.
Love the gym.
No, I didn't. Go ahead. I'm sorry. I'm
Yeah, so I,
trying to see where.
without the law being clear as far as what I need to provide, I'm just a citizen trying to run for office for the first time. I have read the rules that apply to me. I have tried to comply with the process to the best of my ability. And the forms that I submitted are true and accurate as far as I am aware. I was not aware that his secretary was signing things on his behalf.
Did you want to enter anything in the evidence?
So I do have some evidence for conversations that we have had about my status and affiliation as a Republican during those conversations, and I do actually have one of those conversations taped. He confirmed that he would allow me to run for other seats, just not this particular seat. In the first conversation I had, he said, "You're not my pork chop yet. I'll need you to prove that to me." In other words, if I was going to vote how he wanted to, he would allow me to be on the ballot.
What's the legality of the recorded statement?
Just so an outside person.
I have transcripts of that here as well. There. The transcript of the call is the last item entered. I had tried via email and via text to say what additional information would.
Do you dispute the veracity of this conversation?
I don't know yet. unlike a court of law where you have to tell people you have evidence. She is not.
Mr. Chair, could you please instruct everyone to,
Yeah, there's
quiet?
no.
It's really hard to
Yeah,
follow
man.
this and look at this.
About ready to have you out.
Is that under item F?
Item F, I believe, yeah.
Yes.
And if you look at page 3, you will see that there's a confirmation that if I would run for Elkhart County Clerk, Elkhart County Recorder, or something of that nature, that deference will be given.
Although we'll also note, I guess, on page 2 that he said, without a voting record, I want to make sure that you're.
Yes, and if you go to the 3rd page, he confirms that do send me your South Carolina voting record and your Indiana voting record, and I'll take that into account. And I did provide those to him via email, which is Exhibit B.
I would say although this doesn't really look good for you, Mr. Holtz, it doesn't necessarily constitute, in my opinion, a certification. Just in an effort to be consistent with how we've applied things throughout the day.
Right, I'm looking at her South Carolina.
Dan, hold on, Mr. Holtz. She's still on her time.
Okay, sorry.
Yeah, I think when we're talking about consistency with how things have been applied today, the only challenge issue was based upon my 2 primaries. That is not how I claimed affiliation on my form.
Does that conclude your statement?
Yes.
Would you like cross-examination, Mr. Holtz?
Yeah, I would.
Okay, you have 2 minutes.
Amy, I'm looking at your voting history from South Carolina.
Yes.
Could you point out to me where it says that you had a Republican ballot?
I believe it's on the following page at the top. In the header.
2/17/16?
I believe so, yeah.
Okay, I acknowledge that. I had not seen that before.
Anything else?
I don't believe that I have behaved in any way disrespectful. What I respect are people that have participated in the process.
So this is a cross-examination of what
Okay.
she's, so
I understand.
you don't have any questions for her all based on what she said.
Why did you not tell me that you were recording me?
I was not recording you. Someone else provided me the recording.
Oh,
Well,
that's different. That's a different story. Someone else was recording your conversation that was not a party to the conversation?
They were not a party to the conversation.
Could you tell me how that recording was made then?
I'm gonna give that back.
Yeah,
I mean,
I would move. Can I move to strike this?
Co-counsel.
I will second it.
I don't want to know anything else about it.
I don't either. This is totally illegal. I don't know. I'll give it that.
Move to strike, is there a second?
Yeah, second.
Second, any further conversation? Motion to strike that information, testimony and records. All those in favor signify by saying aye.
Aye.
You guys have it. Comes out. I don't know how you want to do that. All right, I'm going to close the public hearing on cause number 2022-22. Maybe I have a quick question for you. Have you, in the past, ever had to certify someone as a Republican who had to meet this threshold? I guess this law is new, isn't it?
It is new, and that is why I did not want to form an opinion on my own, as I said in my remarks. I discussed it with active Republican office holders and precinct committee.
In any way, shape, or form, what I hear you saying is you deny any attempt or wish to certify her outside of having the 2 prior Republican primary votes.
That's correct.
We will make a motion. Any questions? I mean, I don't know where else there is to go.
Well, there is. Where's
But yes.
I know. Okay, your challenge on the basis of primaries held by the party. She didn't vote in two of them, but that's not the box she checked on her can too. What she checked on her can too is that she says the county chairman has certified her. So what she's saying is that her certification comes in the way of that card or something like that. And, I sympathize with you, but I don't know that card is a certification from the chair that says, yes, we'll support you for running for office.
Yeah, short of anything in the law that tells us what that is, I guess that's up to interpretation, which.
But I would say that the statute does say that it's supposed to be signed, certification, whatever that means, signed by the county chair. And granted, I'm not a handwriting expert, but in looking at his signature on the challenge form, compared to the card, the little note on the card, it's not his signature.
Yeah, I looked at that as
So-
well, and it looks like 3 different types of handwriting even on the can too, so they had a hard time with that.
May I address that briefly?
Well, I want to get something procedurally straight. It's the appellate attorney. So your challenge on the basis she didn't vote the last two primaries as a Republican.
And that I did not.
And she has responded with, well, I was certified by the county chair. So I guess the question is, number one, you have raised that and you've shown that she didn't vote in the last two primaries in Indiana as that way. And you didn't file a written certification from the chair.
Yes, he
regarding
could
his-
have.
He's on the record saying he did not intend to certify her.
So I think it's a sense of her defense to the things you could, if what you're looking for is, her defense to the challenge was that wasn't the basis for her candidacy. This is certification, but the evidence before us, in my mind, does not support the fact that she had certification. So I think that defense fails. In my mind.
Yeah, he could have and should have said that I do not confirm that she's affiliated with the party on his challenge form. But he did not include that.
Which I guess every time I've been in court, if I've done a wrong code site, they just say, you're right, we aren't gonna take that. You said this is fraud, even though you used the wrong code site, it's still going forward as fraud. So that's kind of what I'm seeing here is, yeah, he maybe didn't put the thing that you checked there, but I don't see any evidence that says that we got a certification there either.
Yeah, and then we balance that with it being very difficult to interpret what certification means as just a
He's the
standard citizen.
challenger though, and it's his job to bring the proof.
Yeah.
His proof is that she neither A, has voted in two previous primaries, or B, has what he would constitute as a certification to run.
Right.
With that, I'm going to make a motion to uphold the challenge. Is there a second?
Second.
Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
The ayes have it, the challenge is upheld. The election division is directed not to include Amy Rainey on the certified list of primary candidates sent to the county election board to indicate the name of this candidate not be printed on the ballot.
Thank you.
Thank you.
Cause number 2022-18, Ring versus Hammett. The matter of the challenge to Kurt Hammett, candidate for Republican Party nomination for Indiana State Representative District 52. $50. That's it. Now you take the $50 because I think it's already one.
I was told earlier, we're on the lane o'clock before, so.
Why would you say that?
Why? Because that's where you're headed.
Yeah, you're buying us supper because you just said that.
All right. recognize the challenger for setting the presentation. Again, reminding you that just because you have them doesn't mean you have to use them. Go ahead.
My name is Richard Ring, R-I-N-G. I'm the DeKalb County Republican Chairman. I have been chairman for 2 terms. I am also the District 3 Vice Chair. I am challenging Mr. Hammett based on the fact that he has not voted in the past 2 Republican primaries. This is similar, unfortunately, to something that you did earlier, in that he did vote in the 2016 Republican primary. The 1999, which was the one before that, it was listed as unknown. I did not put in that particular packet this information, but if we go back even further, all but one are listed as unknown, all the way back to 1992. You don't have 92 through 98 there. I will say that the Indiana State voter registration system run by the Secretary of State's office is the official record. And this is what we have to go by. And I had, at the time that these candidacies were filed, I had no protest or no question about that. And my clerk in the elections clerk in the county office, in the county clerk's office, did not call me to let me know that there was not 2. And they did that based on the fact that Mr. Hammond was allowed to sign up down here to run for representative, because he did also sign up to run for delegate. And he was removed on Wednesday by a unanimous vote of our election board, the 2 Republicans and the Democrat, because he did not have the required 2 Republican primaries. That is the information that I have. I have discussed him with my counterparts in District 52, the state representative district, in Steuben County, the Steuben County chair and the Noble County chair, because this district covers small pieces of both of those counties. Neither one of these people have ever heard of Mr. Hammond. I'm not familiar with Mr. Hammond. I did sign a number of certifications over the course of the sign-up period, allowing people to get on the ballot. I refused, but I was never asked. I had no contact with him until we met at the election board on Wednesday.
Was it his that you refused? Was it him?
No, it was not. He has never contacted me. And we have no record of ever having him participate or ever having donated anything to the DeKalb County Republican Party. We also did a search on the national deposit donor list, and we found nothing there. So, I say that he is not does not meet the qualifications. Part of the packet are the Republican Party rules for the primary, and the primary is a party election. As I've brought up in previous things here, everyone will have a chance to run in November if that's what they want to do. If they want to run as an independent, they can do that in November. That's where that constitutional thing comes into play. The primary is a party election, and it should be controlled by the party.
Would you like a cross-examination?
Yes, I would.
Only germane to the things, what he just said.
Excuse me, I'm sorry.
The questions are only relevant to the things that he just provided to us.
Yes. Do you need my sheets first, or? Let's do that.
Part of the cross-examination?
Yes, I'm on a cross-examination. Ms. Green, if you could take these papers here. On page 1, oh, and I have 2 packets here. Yeah. On page 1, for the record, you're challenged to remove me from the ballot because the last 2 primaries in Indiana, which I voted, were not Republican. On page 7, as a copy of my voting record, could you read the 1998 primary ballot type listed here?
The 98, it does show Republican. The 99 shows unknown.
I didn't ask that, I just said 98. On page 8, could you read the 2016 primary election ballot type listed there?
It does show Republican.
Okay. How many Republican primaries is that?
That is 2.
That is 2. Do you have evidence to prove that these 2 primary voting records stating Republican are not Republican?
I am not disputing the one that is listed as 1998. I disputed the one that's listed as 1999, which is unknown.
So when I add,
You did not vote in primaries in 08, 10, 12, 14, 18, and 20. Doesn't show me that you're a very strong Republican.
that is not the issue. That would be part B. Part A is that I voted in 2 primary elections. That is what you put on your challenge, and so that is what you must stick to.
The two most recent being
Hold on.
2000.
Hold on, it's time to.
Yes. Actually, so when I actually voted in Indiana in a partisan primary, my voting record reads that I voted Republican and 2 Republican primaries.
So your 2-minute rebuttal time, cross-examination's over. Would you like to go into your statement?
Yes, I would. Members of the election board, my name is Kurt Hammett, Indiana resident for over 35 years. I'm on the May 2022 Indiana primary ballot running for state representative. There are constitutional party rules set to lawfully declare candidacy for a primary in Indiana. I did do my research before I filed, and I made sure I was qualified. The rules and qualifications set forth by the Constitution and the Indiana Code are not in question here today. Except for Mr. Ring alleging, he claims for a fact that my 2 most recent primaries in Indiana in which I voted were not Republican. On form, and if you take a look at page 2, on form 46439, my declaration of candidacy for the primary nomination of 2022, I checked the first box on number 3 stating the 2 most recent primary elections in Indiana in which I voted were primaries held by the party with which I have claimed affiliation above. If you take a look at page 3, please note that I signed this document verifying the truthfulness of what box I checked. I am also sitting here, I'm not standing, sitting here under oath today to testify to the truthfulness of my declaration. If you take a look at page 5, Indiana Code 3827 reads, a statement of the candidacy party affiliation. For the purpose of this subdivision, a candidate is considered to be affiliated with a political party only if the following applies. 2 most recent primary elections in Indiana, primary elections held by the party or candidate claims affiliate. If you take a look at page 7 and 8, the voting record I have provided for you, the record which we have already looked at, lists my 2 most recent primaries in the state of Indiana, which I actually voted Republican, 1998 and 2016. The challenger himself has already agreed today, and we can all agree that my voting record shows the 2 most recent primaries in Indiana, which I voted, were Republican. If you take a look at page 11, my team and I interviewed or contacted the Jay County Circuit Court clerk, and he testified in this document that this is inform you that your voting record in Jay County says that you voted in the 1998 primary, and it shows you voted Republican. Then in the 1999 primary, this is unknown. The voting records were converted to electronics around this time, and I believe I was not the clerk, or did I work for the clerk's office during the conversion. I'm thinking that the conversion may not have recorded your voting history at the time due to circumstances that are unknown. And that goes along with the rest of those before that. My team also contacted Cassie Hammond of Adams County
election or clerk's office, and you have that there on page 10. And she also did not know what unknown meant. Now, if you take a look at page 9, am I going too fast? I'm speeding on pages real fast. Okay. If you take a look at page 9, you will note that I am registered there in Pennville. Pennville, that was my J County home, Pennville, Indiana. Now, my team and I also contacted Steve Howe, who was the Republican county chair in the 1990s. And he testified, and I do have this on text, but I do not have this in written form because he just gave this to us. That Pennville did not have primary elections. So there was no way for me to even vote primary in Pennville because they did not have primary elections because Pennville is only a village of less than 700. So when I actually voted in a primary, my voting record reads the partisan party I voted. That is Republican. There is nothing more to see here. Mr. Ring's allegations are hearsay at best, and he brought no evidence to prove his challenge. I fully complied with the rules of this candidacy.
I would still contend that the official record
is cross-examined.
I still contend that the official record is the Secretary of State's office, and they're showing a primary election with an unknown for 99. And during that same conversion time that you're claiming, in 1998 is when it shows Republican. So if it worked in 98, why didn't it work in 99?
What does unknown mean?
Means unknown.
It means unknown. It doesn't say
the
that.
record is unknown. There is no proof that it was Republican.
Excuse me?
Any rebuttal?
Yes, I mean, if it's unknown, it could be unknown that I voted Republican. It could be unknown I didn't vote. I mean, I voted Republican in 98, I voted Republican in 16. Why would I not vote Republican in 98 or 99, if that is what Mr. Ring is
And all you have to do is pick up the phone and call. That you
I'm gonna allow that to be your rebuttal. I'm gonna close the hearing on the matter 2022-18. Any questions or discussion?
So no more new evidence at this time can be entered, correct?
That's correct.
All right. You presented evidence that says it's unknown, knowing how he voted. And so there is no proof in the clerk's office on the state system that he voted Republican in the most recent 2 primaries.
That is correct.
Your response is that, well, that unknown doesn't matter because I voted Republican in the year before that one, but that's not what the law says. And so you have presented, so that unknown means that for some reason, but probably because of the conversion, it wasn't entered as to what ballot you drew, the Democrat or Republican. You had the opportunity tonight to come here and present evidence. I didn't even hear you say you voted Republican in that election where it's marked unknown. You didn't come out and say that in your testimony tonight.
I said that I couldn't, it's impossible for me to have voted in 1999.
So in 1999, why would it, because that's the Pennville thing?
Yeah.
So Pennville in Indiana?
Pennville, Indiana.
So they don't have state legislators, they don't have governor, they don't have secretary of
In
state?
1999 is an off-year election.
But you said they don't, but they can still have primaries. I mean, you still have primaries.
Not in small municipalities.
Okay, I'd like the co-director to address that, Mr. Chairman.
Sure, go ahead.
Well, I might actually defer to my colleague because his legislative history back to 99 will probably be better than mine, but it is possible for small towns to have a primary election. I just don't know where the law stood in 1999, if that was permissible or not.
Mr. Chairman, members of the commission, thanks to my counterpart, Co-Director Nussmeier. Yes, the The law in 1999 is essentially unchanged as it stands for law today, in that in towns with a census population of under 3,500, the town has an option to adopt a primary. But generally, in small towns, there are party conventions if there are contests within the same party for a nomination. Yeah, and so there are many municipalities in Indiana in those odd numbered years, 99, et cetera, that did not conduct primaries.
So do you have a statement, notarized under oath type statement from that Enville?
From the Steve Howell?
Did I miss that in here?
He said that he has a text from him affirming that.
Yeah.
Okay, well, but you said you didn't put any evidence.
Well, this seems, remind me, going back to earlier today, this reminds me of the Oak case, where in the Oak case, we had one primary known and one primary unknown.
And she testified that she voted Republican. And he's not said that. And he said he can't say that because he didn't vote in the primary. But he could have gone back to the clerk and gotten a certified statement, some kind of evidence.
It doesn't.
Number 11.
Well,
But
doesn't.
it doesn't address Penville, does it?
Well, wait, but doesn't unknown, this is for staff. If the voter record says anything, so like when it, I mean, so does that mean, so since it says unknown for the 1999 primary election, does that mean that the voter showed up and took a ballot at a primary election?
Which would contradict whether they had a primary.
Well, that's why I'm raising that.
I said.
Because it looks to me like not, well, I guess I don't.
So.
I think you're looking for me to give you that code site again of 310.131.3. A record of voter whose political party is not reported on a poll list. And then I'll just read you the
No,
highlights.
that's not actually, no, that's not what I'm asking. What I'm asking is, let me ask it this way. I guess I'm doing my cross-examination staff. So voter record, like if we pull up my voter record, is it gonna show every single election in the state, regardless of whether I voted?
No.
Okay, that's fine. So if an election is reflected here, that means, or on anyone's voter record, that means the voter showed up at that election and requested a ballot. Okay, so that means for 1999, since it says so the fact that it says 1999 primary election means that he showed up somewhere, I guess somewhere in Jay County, and got a ballot during that primary. This is what this record means.
I believe that to be correct.
Okay. You guys agree with that?
I
Sorry.
would, but I would add that the statute that Co-Chief Warhawk mentioned actually was not, it looks like it was introduced in 2013. I don't know if there was similar language in statute, but I would note that the statewide voter registration system did not exist prior to 2004. Is that correct?
Mr. Chairman, December of 2005, and that you're correct that prior to the 2013 legislation that was cited, Indiana law was silent with regard to the impact of an unknown vote.
Right, but that's still not my question. Like, so if I did not vote last year, for the record I did, but if I hadn't voted last year, I'm already getting lost. We didn't have to vote last year, thank goodness. 2020, if I hadn't voted in 2020, my record wouldn't have a 2020 on here.
Correct.
Okay.
Correct.
Right, okay.
So I think the vice chair to be asking, in my opinion, is if it showed up in 1999 as an unknown, it means there was an election in which he requested a ballot. They simply don't know what the outcome of that ballot was, whether it was Republican or Democrat.
Correct.
Okay.
I mean, we are seeing it goes from 99 to 2008, and we know there was an election in there.
Right, well,
And so you didn't pull a ballot, I'm guessing.
I still think this goes back to very similar to the York case.
Well, I guess my point then was that, so my point was that she had.
He stated that there wasn't an election.
Right.
You're saying, how did you go about if there wasn't an election?
Right, and she testified affirmatively that she did vote and that she voted Republican, and Mr. Hammond did not say that. He's disputing whether there was an election. He hasn't said, but so I think that is, in my mind, that's a distinction.
I didn't say there wasn't a
The
vote.
public hearing on matters closed, you can't offer anyone testimony on it. All right. Whether his memory is correct or not about 1999, it's still the same as the York case in that you have non-consecutive, right? So he's stating there wasn't a primary. This record's only stating that there likely was a primary. It didn't record whether he voted Democrat or Republican. The next eligible date in his voting record, and the one prior to that, was Republican.
I mean, I do agree with Suzanne that there's a distinction here between this and the Oaks case, but I also, looking at the 98, I mean, it's at least a little persuasive that it could have potentially been a Republican ballot.
You want to make a motion?
I would move to deny the challenge.
We have a motion to deny the challenge. Is there a second? I'll second it. All those in favor signify by saying aye.
Aye.
Nay. So the motion fails. The challenge is upheld. Sorry.
When one motion fails, another member can offer another motion. You need to have an exhaustion of administrative remedies.
So the motion to uphold the challenge fails.
Or no, I said deny.
Sorry. Motion to deny failed.
So I would move to uphold the challenge.
Okay, so we have, there's a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye. Nay.
3-1, the ayes have it. The challenge is upheld. The election division is directed not to include Kurt Hammett on the certified list of primary candidates sent to the county election boards and indicate that the name of this candidate not to be heard on. Thank you. Cause number 2020-17, Leonard versus Carver, in the matter of the challenge to Megan Carver, candidate for Republican Party nomination to U.S. State Representative District 53. Information is in your binders.
Thank you.
Okay. Commission recognizes Beverly Guard, challenger, for the presentation. Please state your name and spell it for the court reporter.
Beverly, B-E-R-L-Y, Guard, G-A-R-D.
Go ahead.
And thank you, Mr. Chairman, members of the commission. I can sympathize with the one for this. I chaired a number of commissions myself over the years. And I'm back this long. This should be relatively quick, I hope. Mr. Leonard is seriously ill and his doctor did not want him to appear.
Yeah, let me note for the record that Mr. Leonard had filed to have Back to you.
Yes. So I'm representing Mr. Leonard today, and Mr. Leonard met with Ms. Carver in October, and she said she wanted to run for state representative District 53, but she understood that she did not meet the qualifications. And she had a letter that she asked him to sign supporting her candidacy. Mr. Leonard felt that he needed to do some research and they decided to meet again in November. Mr. Leonard found out that Ms. Carver had registered to vote in Hancock County in 2004. She had voted in one Republican primary, which was in 2016. So that was one primary out of 9 general elections that she had voted Republican, the rest she had not voted at all. Also, there were 4 municipal elections that had occurred, and she had not voted in any of those as well. So when Mr. Leonard met with Ms. Carver again in November, he told her that they had searched the state portal. Apparently, she had been registered to vote, or in Hendricks County, they checked that. They even checked Marion County and found no record for her having voted another Republican primary. He indicated to her if she had produced another Republican primary that was valid, he would have been glad to sign the letter, but she didn't.
Okay, thank you. Would you like 2 minutes of cross-examination?
Yes.
Limited only to her statements.
Okay. Hi, I've not met you before. So you're saying that Mr. Leonard has been able to locate my vote history clear back to 1988 in Indiana?
No, he, to 2004.
Okay, okay. So he does
And
not
and
have,
actually, that's the vote history you gave him.
okay, so he has not been able to locate my vote history back to 1988 and prove that I do not have 2 Republican primaries?
It showed that you had not voted in any Republican primary.
What didn't?
The state portal and the investigation.
So he did find my vote history? Because I would love to have my vote history. Do you need a copy of the exhibit?
You gave him the vote
Yes,
history.
Hancock County back to
starting in
2004. I'm asking before that. Did he find my vote history before that?
He indicated that they had talked with Hendricks County, Marion County, and searched the state portal and found no record of you having voted in another Republican primary. He did not say that he had not, that there was no vote history. He didn't say either way. He just said they found no record of you having voted in a Republican primary.
But then also no record of me not having voted in Republican primaries.
Well, I don't
Because
think we're
there's
trying to
no-
vote. I don't think we're trying to prove the negative.
According to the rule of law, you have the burden of proof. So that's why I'm asking, if he has my vote history that proves that I have not voted in 2 Republican primaries, I would like to see it.
So your 2-minute cross-examination.
Okay.
Proceed with your opening statement.
Okay. All right, thank you. Good evening. I appreciate your endurance in still being here. So yes, Megan Carver, MEGHANCARVER. There is nothing in the law or on the form requiring that I submit proof of my 2 primaries. My attestation is all that is required. According to the rule of law, the challenger or the petitioner has the burden of proof. So the county chair is bringing the challenge that I did not vote in 2 Republican primaries
the burden of proving that is on him. I have been a registered voter in Indiana since approximately 1988. Because he has not provided any proof to substantiate his allegation, then his challenge should be dismissed. When I learned of the new two-primary rule, I did not even know that a voter could get a copy of their vote history. Historically, votes have been anonymous and the actual vote not tied to the voter. There is no mechanism by which a private citizen can maintain evidence of their voting. But out of good faith, I investigated. I was curious. So last October, I did go to the Hancock County Election Office for a copy of my vote history. I was shocked that they had anything at all, just because I thought the voting was completely private. It did go back to 2004, which is when we moved into Hancock County at the very end of 2002. So 2004 probably would have been my first election there. But I thought it was incomplete. I'm a mother, and mothers tend to remember things, remember events in time based on the age of their children. And I remember specifically carrying a baby in an infant carrier in to vote, placing that infant carrier on the floor in order to complete the ballot. That would have been a primary because all of my children that have been born in Hancock County have been born in late fall or winter. The baby in the carrier was heavy, and I was glad to put the carrier down for that few minutes of voting. Also in October, I emailed the Marion County Board of Voter Registration, where I was registered to vote between approximately 1988 and 1997. Michelle Cash, Chief Deputy, emailed. Unfortunately, the state's digital records do not go back that far. The records you have received from Hancock County are the extent of your registration records in Indiana. So that indicated to me approximately 16 years of my vote history has either been destroyed or lost. I didn't want to give up there. I didn't think that the record keeping could be that incomplete. So I drove over to Hendricks County, where I was registered to vote between approximately 1997 and 2004. My husband and I lived 2 blocks from my parents during that time. My mom and dad always encouraged voting in primaries because that determines your candidates for the fall election. Also in the mid to late 90s, during that time, neither my parents nor my husband and I had internet in our homes. And so it wasn't always easy to research candidates. They did not have websites. My mother would call a family friend there in Brownsburg. He's the man who built their condominium as well as the house we were living in Brownsburg, and he had become a friend of my parents. He was a Republican, much more involved in local politics than we were, and so she would ask him who to vote for. Anyway, in November, just this past November, I drove back to Hendricks County to locate my vote history. Jen Greider in the voter registration office took down my details. She went to the basement to search boxes, but only found my voter registration card. So she emailed me on November 9. I have exhausted all of my resources by looking through boxes of registrations and surveying registrations one by one, thinking that maybe there was a possibility of a misfiling, and I am still unable to locate a registration with a vote history. She also checked under my maiden name, even though I had already been married by the time I moved to Hendricks County. I asked her if there was anything more I could do or provide. I offered to come help her look. Of course, they're not going to let a private citizen in to look at the records, but I was willing. She replied on November 15th, the old system was flawed and unfortunately had more room for human error. Hendricks County did find my husband's vote history during that time, and it shows for him a Republican primary in 2000. And I bring that up because I am the more political of the two of us, and I was always the one to make sure that he got out and voted. So it's inconceivable that he would have voted in a primary in 2000, and I did not. Finally, yesterday, in a challenge hearing for my candidacy as state delegate, the same basis, the two Indiana primary rule, the Hancock County Election Board, made up of 2 lawyers, they were the Republican and the Democrat, and the clerk recognized that the county chair has the burden of proof. They decided unanimously that the county chair had not met his burden of proof and upheld my candidacy. They asked me under oath if I had ever voted in any election other than Republican. I thought it was interesting that the Democrat was particularly interested in that. And my answer was no, I have always voted Republican. Not even, what was that, Operation Chaos, Republicans vote for the Democrats in primary, or the Tea Party in 2010. I have always firmly believed that Republicans need to stay unified, and I have not voted in any other than a Republican primary. So based on the challenger's lack of evidence that I have not voted in 2 Republican primaries, I respectfully ask that you dismiss the challenge. And I'm sorry, I completely forgot. I have copies of the emails, my husband's vote history, the things I referenced. If you want them, I have 5 for commissioners.
Okay. You have 2 minutes of cross-examination limited to her testimony.
Or primarily just to make a couple of points. Private citizens can search voter records. I've been registered to vote in Hancock County for more than 50 years. And I can go back there, and I have done it, and look at my vote history, all of those years. Your vote history is not confidential, whether you ask for a Republican ballot or a Democrat ballot. It's public record. It's not confidential.
I'm glad you have yours. I wish I had mine. Was there a question there?
No, other than Mr. Leonard had said that he would be glad to sign your form if you could prove that you have voted into Republican primaries. But the fact that you have been registered to vote in Hancock County for 18 years and have only voted in 1 primary is a concern.
Okay, I don't recall Mr. Leonard being willing to sign the form at all. I met with him because he wanted to meet. And I thought if I'm going to meet with him, I'll ask him to sign the certification and that can just end all of this. And at that point in time, he was hung up on whether or not I was a Republican in good standing. He wanted to change the definition of in good standing, which I'm not sure is really relevant here because the challenge is based on the two primaries.
I would like to make a comment about the Hancock County Election Board meeting, which was yesterday, that Ms. Carver referenced.
You're in the 2 minutes of your cross-examination, so you can ask her about it if you'd like.
Okay. It's my understanding from talking to people that were involved yesterday with the hearing and observed it, that the election board really hadn't done their homework on this. They had never been presented with this question before. The unit was 1, primary was simple. It's not so simple when it's 2 primaries. And there was just a great deal of confusion.
Okay, so your time is up. You have 1 minute to vote.
Okay, the form, the 2 most recent primary elections in Indiana in which I voted were the primaries held by the party with which I claim affiliation above. And I certify that the information in this declaration of candidacy is true and complete, and that I meet the specific requirements of this office. Mr. Leonard has not proven that that is not true, and since he brings the challenge, he has the burden of proof.
So you do see 1 primary vote. The records go back to 2004, nothing before that. So which election prior to that have you?
Well, I believe I voted in either the 2004, 2006, possibly both primaries. That was based on carrying
baby in the infant carrier, a child who was born at the end of November in 2003. So that would have been the 2004 primary.
Should be on time. I asked you a
Okay.
question, so it doesn't.
I'm sorry, I thought I was answering it, but.
You were.
Okay.
Tomorrow.
I also had a child born on Christmas Day, 2005, so that would have been the 2006 primary. I'm sorry, what was the other part of your question?
Well,
Which
you
primaries?
show the last primary voted in was 2016. There's nothing that shows it in 6, 4, or 5 in the voting records. You're saying
Right, and-
under oath that you did vote in those primaries.
I believe
and-
so, and then also
You
in
believe so,
Hendricks
or you-
County, which they don't have any of my records. So, I mean, I'm not responsible for maintaining the vote history.
Okay.
I know what I remember, and if they go down to the basement and search and can't find it,
Right.
Could staff kind of inform us as to, because it does seem odd, this is, because the other histories we've seen tonight go back further, and I don't know, I mean, is there, if someone has a voting history before 2004, is there a reason that it wouldn't?
Well,
be
so
reflected?
I'll close the
Sorry.
public hearing part of this
Sorry.
first,
Okay.
yeah, for 2022-17, and yes, please.
Well, any one of us can answer that.
No, go ahead.
No? Oh, okay. I'm only just really jump in to answer this here because I looked it up during the last hearing. So while I'm searching for that, so under the statewide voter registration law, so 3.726.3 established certain requirements when the system was set up. That included one, entering in every registered voter in a particular county at that time, and also including uploading the vote history that that county would have had going back 10 years from the time they began entering in that information. So in this particular case, wherever the candidate was registered to vote, the requirement would have only been placed on that county to enter in that information. I cannot speak to if back in the 90s, early 2000s, before SVRS, different counties used to make copies and send over old voter registration information when a candidate moved. I don't ever recall that, but I defer to others who were practicing election law and administration at that time. Brad King. And so that's why it is possible when you look at her record in SVRS, you only have most likely information that was entered in by the Hancock County Circuit Court Clerk, who's the voter registration official, because that's who had the requirement to enter in that information. Every other county, it would have been on paper, of which by this time most likely must have been destroyed under our retention laws. So that's generally what I have on that from me specifically.
Yes, I agree with Matthew.
Mr. Chairman, members of the commission, I can add that, prior to the implementation of the statewide voter registration system, there was no linkage between any of the counties. It was, in fact, entirely on paper and not even on computer in some counties until the mid to late 1990s. And so it is entirely possible that whatever paper record might establish vote history from prior to 2004 was destroyed in accordance with the record retention statutes 310-131 that have been referenced by Mr. Cochever.
And if I may just add to the comments, I agree with our colleagues. The retention schedule is 22 months. So a county would keep the poll lists. So if you vote in a primary election, right, you're asked which party do you want to vote in, Democratic or Republican. Those poll lists are then maintained for a period of 22 months. And at that point, the counties are able to destroy them. So it's very plausible that Hancock County would not have those poll lists or other information because 2004 was 18 years ago, which is far in excess of the 22-month retention schedule found in federal and state law.
Comments. Okay, I guess we've had unknowns here for 2 other cases that were like, we're not sure, this could be somebody's error or this could be on you. I find this one distinguishable because there are 2 things that I'm not sure about. I'm not sure if you voted and I'm not sure if you pulled a Republican ballot. At least in those last 2 cases, I know that there was a vote there. So I guess that's why I would find it distinguishable between my votes in the other 2 cases.
I agree with Whitney. However, I also recognize what Ms. Carver is saying, and that is the burden is on the challenger. And they have presented, I'm sorry, no proof of anything regarding her voting history. She's the one who brought forward something that raises the questions that we're looking at. But you didn't establish the prima facie case to be rebutted, I don't believe. So, and I think that is a problem. You know, Mr. Leonard, maybe he looked at the records or something, but.
And she actually gave us the records from Hancock County.
And, but what records are those?
Yeah, so she did provide us.
She had the opportunity to vote.
So we do have this.
In 9, she had the opportunity to vote in 9 primaries and she only voted in 1.
So I would say, I'll kind of amend, Karen, what you said to say they have provided evidence.
Yep. Yes, they have.
Ms. Carver is suggesting that it's incomplete.
Who has provided what evidence?
They have provided the evidence. Have you seen this? Would you like to take a look at it? Which I think is the same information that's on the record you provided.
Right,
Only
right, this is Hancock County.
Yeah. So they did present evidence that you did not, there's only a record of you voting in 1 Republican primary, and there's no evidence, you think you voted in 2005 or 2000, or 2006, was it?
2004.
2004, 2006. Well, 2006 doesn't show anything, nor does 2004. It just shows that you voted in general. So, it doesn't show that you voted in the primary, nor does 2006 show you voted in the primary.
Right, but I am not the record keeper. That's up to the county.
Right, but.
There are messed up records all over the state. I'm not the first person to say today my record is incomplete, and I know I won't be the last.
Right. But you don't, I mean, you have testified that, you think you voted 1 of those 2 years because you put your baby down, rest your arm. And, I mean, I could see them missing out on 1, but they usually don't miss out on 2. I mean, especially in 2006, the new system had been implemented, right? Yes.
I also testified that in 2000, back in Hendricks County, who no longer has my records.
But that was.
Voting in a primary.
Right, so, but that, the most recent ones that we don't have any evidence that you voted in a primary. That's the problem, other than the one in 2016.
So she's provided.
I'm not the one who keeps the.
She's provided evidence that says you do not meet the standard.
What evidence?
That voting record.
Where is my voting record?
You just looked at it.
That's only Hancock County. I've been registered to vote since 1988.
Well, since 2006, it's statewide.
Right. Okay, so if I had a primary in 2000, then that would be the other primary.
But a few minutes ago, I'm sorry, I mean, I guess we don't.
Yeah.
This could go back and forth forever,
Yeah,
but I mean, the thing is, up until now, your testimony was that you thought it was either the 2004 or the 2006 primary, and the system, I mean, I understand your older record seems to have disappeared, but from your own testimony, it seems like those if you did in fact vote in primaries in 04 and 06, that should be reflected here. And quite frankly, it just causes me to, looking at this, I kind of question how often you vote in primaries, so it's hard to, so you've offered your testimony that you think you have voted in prior primaries. And we have to weigh that.
So I find this distinguishable from the other two. There are unknowns, so I'm going to move to uphold the challenge.
There's a motion. Is there a second? I'll second it. All those in favor to uphold the challenge signify by saying aye. Aye. The ayes have it. Motion carries.
May I ask a question?
The election division is directed not to include Megan Carver on the certified list of primary candidates sent to the county election boards and indicate the name of this candidate is not to be printed on the ballot. Sorry.
So you're penalizing me for the state not having my record?
We've already voted on the matter.
Okay, but that's the conclusion then.
The next case caused. Okay. Cause 2022-23, Hyday versus Carey. I've been told that Mr. Hyday is not here. Given that there's no challenger, for simply rule on the matter.
It's dismissed. I don't know how any of this works. I'm very sorry, but I completely new
You don't have
politics.
to respond to anything. They didn't indicate on their challenge form the reason for their claim to challenge you.
Yeah, honestly, I had no idea why I was
State your
even.
name to the record.
I'm sorry. My name is Heather Carey. It's spelled Heather. My last name is Carie. I honestly am not completely sure why I'm here. I never received any official notification. I found out on social media.
Mr. Chairman, I do have the documentation from UPS that the notice was delivered.
Do you know what day that was? Because I've been
Yeah,
checking the mail every day.
There's nothing for you to really respond to at this point.
Yeah. Okay, so it's dismissed.
I would move.
So we'll close the hearing on cause number 222-23. Consider a motion.
To deny the challenge.
Second.
Second, hearing no conversation, the challenge is upheld.
Does that mean I get to
Sorry,
run it?
denied. The election division is directed to include the name of Heather Carey on the certified list of candidates to be printed on the
I just want to say, because I've heard a lot of other people saying this today, I actually have proof from the Madison County voter registration that a decade of my voter records are missing.
Thank you.
Thank you very much.
Thank you for
Sorry
your
for a
patience.
very long day.
You too. The next cause number is 2022-03, Lowry versus Kinzer. In the matter of the challenge to Myra Kinzer, candidate for Republican Party nomination for Indiana State Representative District 62. Recognize the challenger. Ms. Lowry, please state your name and spell it.
Amanda Lowry, AMANDALOWERY.
Go ahead.
Thank you guys for your time today to consider this challenge. My name is Amanda Lowry. I'm the Jackson County Republican Party Chairman, and I also serve as the 9th Congressional District Vice Chair. I have filed a candidate challenge against Myra Kinzer, Republican candidate for State Representative District 62. IC 3-8-1-14 provides that a candidate for the office of representative in the General Assembly must, number 1, be a United States citizen, 2, have resided in the state for at least 2 years and in the House District for at least 1 year before the election, and 3, be at least 21 years of age upon taking office, as provided in Article 4, Section 7 of the Constitution of the State of Indiana. Myra Kinzer Pfaff and her husband James Jim Pfaff lived in Woodland Park, Colorado from May 26, 2019 until at least April 16, 2021. During this time, they owned and operated a business in Woodland Park called Fit Nutrition Depot. Myra lived in Colorado during this time, running the day-to-day operations at Fit Nutrition Depot. Myra and her husband Jim lived in a camper at the Bristlecone Lodge in Woodland Park, Colorado. Jim ran for and was elected to a Woodland Park City Council seat on April 7th, 2020. Myra worked at Fit Nutrition Depot until it closed in February of 2021. Jim Paff resigned from Woodland Park City Council on April 16th, 2021, amidst a recall effort against him. On April 15th, 2021, Myra attended his final council meeting at Woodland Park and staunchly defended her husband and her residency in Woodland Park. I have provided a transcript of Myra's statement from that meeting with the candidate challenge provided to you. You ready? Yes. I also have a video of Myra making these statements for you to view today.
Okay.
Good evening. Myra Paff, and I live at 510 North Highway 67 in Newland Park. And
yeah, I'm gonna call it right now. I think I found this product.
Sorry, it's an ad. I can't do anything about that. I don't have a YouTube subscription.
I will really try to refrain by taking this past 5 minutes, but this is not the most favorite thing that I like to do is to come in front of city council and talk about my husband. So that I do want to address some things that have been flying around and just put some clarity to some things that's been talked about with Jim Paff. So I'm a little nervous, but I'll get this out. First of all, the Heritage Foundation did not send Jim Paff here as a plant, okay? He's not a plant from the Heritage Foundation, so I just want to clear that. That's the first thing. We did go to the Heritage Foundation, and we were part of the Heritage Foundation as other things, as far as dinner parties and things like that, when we lived in DC some time ago. But other than that, Jim is not a plant from the Heritage Foundation, so mark that off your list, okay? The second thing is, we still reside here in Woodland Park. And our plans have always been to purchase a home. We brought our RV from Indiana, which is my hometown, born and raised, where all my family is. And we were staying in our RV until we found the perfect house. And there's nothing against the law with having 2 houses in 2 different states. And by the way, we love Colorado. And it was hard to pull me away from Indiana because I love Indiana. But I love Colorado so much that I wanted a second home here. So I want to make that clear too. The third thing is, we do own a home in Indiana. Now this home that's just been kind of put out there has been my family homestead since 1940, okay? This has been passed down from generation to generation. And all my family live and reside in Bloomington, Indiana. But I moved out here to Woodland Park because Jim and I used to drive through here, and I loved this little town. And I thought it was a beautiful town with Pikes Peak, and we would often stop when Starbucks was up there on the corner, and we'd get a Starbucks, you know, where that one coffee shop is now. I can't remember the name of it because I'm nervous. But anyways, at any rate, I just want to make it clear that that home has been in my family since 1940. Number 4, we closed down Fit Nutrition because of COVID. If COVID didn't hit this community, I would say that we would have been doing pretty good. When I first arrived in this community, one of the first things that I did was go to Parks and Recreation, because my background from Indiana University is recreation. It's physical education, it's gymnastics, it's all that. I love nutrition, I love all that stuff. And so I went in to Parks and Recreation, and I was willing to teach classes for Parks and Recreation, to teach Pilates or anything they wanted in the park when COVID hit. So we had every full intention of making sure that this business was going to be a vital business in this community. We have been fortunate. We've had one person kind enough. We did close Fit Nutrition down, unfortunately, but it is due to COVID, so I want to make that clear. But we have had a business owner that loves us and loves the fact that we're in this community, who has approached us and said, we really want you to stay. We really want you to be a part of this community, and we want to make sure you have Fit Nutrition here, because they saw the value in Jim and I's participation in this community. Number 5, like many in Woodland Park, residing in Woodland Park, from many destinations, you hear them standing up at this podium. They chose to live here because they love Woodland Park. That's why Jim and I chose to live here, because we love Woodland Park, okay? So, and then I witnessed firsthand when Jim and I first moved here, and we were starting to get involved in Woodland Park, and we've been in Colorado for quite a few years, so I want to also make that clear. We didn't just arrive in Woodland Park and start living here. We've been in Colorado. I witnessed firsthand many people asking Jim, because Jim has spent his life as a public servant. He has served our nation. He has served our state. He has served our local community here. He is an honorable man. And I wanted to put that out there too, because he cares about Woodland Park. He cares about the state of Colorado, and he cared about our capital, about Washington, D.C. So, and he's done that for 30 years. And I don't want that to be misunderstood. I witnessed firsthand many asking him locally here to run for city council because of the 30 years of federal, state, and local government experience that he had. Jim is a public servant. His heart was in the right place. So I think just to kind of wrap it up a little bit and just kind of, let you know just a little bit more about me is I come from a world-renowned racing family. And I was going to get my family to come out here. They know everybody, all NASCAR, everybody. My cousin is a 22 world champion with sprint car racing. I was hoping we could get a little Pikes Peak fun going. Maybe we could get Jay Gordon out here. These are the kind of things that I was thinking about. And not only that, I created a maternity home in Bloomington, Indiana to house 12 pregnant girls. I took the president of Indiana University's home that was built in 1895 on College Avenue, and I turned it into a home for 12 pregnant girls. And I built a 4,000 square foot pregnancy center and raised millions of dollars to make sure that young women and families and all these people that are out there and struggling in life have a place to lay their head. And I wanted to be involved in this community in that way too. I wanted to be involved with recreation. I wanted to be involved with choices, whatever, however we can serve. And so there's many things that I felt like that Jim and I could offer to this community. And we didn't really get a chance because there was so much rancor. And so I just wanted to come tonight and just kind of share.
Mr. Chairman, I must tell you that I probably let that go an extra minute or two because I forgot to hit the timer when I was messing with the audio.
Is there anything more on there that?
I apologize.
Not really on the video, but if I can have a few more minutes to finish up.
You could have cut the video short.
Sorry.
Quick.
Sorry.
We'll give you one more minute.
Okay.
Consent.
I see 3-5-5-9 states, if a person is physically present within another state with the intention of remaining in the other state for an indefinite time as a place of residence, the person loses residency in Indiana, even if the person intends to return at some time. Myra Kinzer's timeline in Colorado is clear. There are 24 pages of documents submitted with this challenge. Newspaper articles, social media posts, and transcripts from footage of Woodland Park Council meetings clearly demonstrate that Jim and Myra Pfaff lived and worked in Colorado from 2019 to 2021. We heard from the candidate in her own words that they lived in Colorado. They chose Woodland Park, Colorado as their home. They were not inhabitants of Indiana 2 years next preceding the 2022 general election. Myra Kinzer was physically present in Colorado, living, working, and defending her residency there from May 2019 until just 10 months ago. Based on her statements, her actions, and the evidence I have presented to the commission today, I believe that Myra Kinzer lost her residency in Indiana pursuant to IC 3-5-5-9 and fails to meet the requirements to be a state representative.
You have 2 minutes to cross-examine based on the testimony.
Okay. So I just want to ask you, I am a native of Bloomington, and how would I have never voted in Colorado. Have you checked on my voting record? Have you checked in who owned the business in Colorado?
I have.
Have you done all your homework on that?
I have checked your voter registration record in Colorado, and I have checked your business registration in Colorado, yes.
Okay. I have never, ever, my name is not on Fit Nutrition intentionally, okay? I've never voted anywhere. Washington, D.C., where my husband was the chief of staff, I never voted there. I never voted anywhere else except Indiana. I am a lifelong native of Bloomington, Indiana. I am town, I am gown, and wild horses could not have dragged me away from being a native and a resident of Indiana. That is my home. I own a home. And for you to come back and say that I am not a resident of Indiana is very offensive to me. I know that I made some pretty bold statements, but you would too, if your husband, who actually was a resident of Colorado at one point in time, and by the way, did you know that Jim and I got married in 2014?
I did know that,
Okay.
yes.
So that was the first time I had gotten married. I dedicated my life to the Hannah House Maternity Home in Bloomington, Indiana. In 1895, William O'Brien created that house on College Avenue.
Is there a question you're cross-examining?
Well, I'm just saying, did you understand my history of Bloomington?
Yes,
Do you understand what
I'm
kind of
familiar with your
area I am?
history in Bloomington, yes.
Okay. There is no way on God's green earth that I would ever be a resident of Colorado. I absolutely had the intent of spending time with my husband, and I'm going to leave it at that. Okay. Well, thank you very much. I know it's been a really long day, and I want to go home too. So I'm going to try to make this really super short. But I think there's been quite a bit that came out on the video. I didn't expect the video tonight, but that's fine. I think this is a good process, and I appreciate everyone just hanging in there with me. But so as I was said in the video, I'll just actually going to read it just because I'm really tired. I've been here all day. My name is Myra Kinzer, a lifelong resident of Monroe County, located in Bloomington, Indiana. I grew up in a small lake town in Smithville, if you're familiar with it. Smithville, Indiana, 8 miles south of Bloomington. Monroe County has been my resident my entire life. I am a native of Monroe County and a graduate of Indiana University. I have lived, voted, done business, and maintained my residency there my entire life. I purchased my family homestead, which you heard in the video was a part of our family since 1940, in 1998, which is located at 3600 East Cleve Butcher Road in Bloomington, Indiana. So I gave you some attached materials here this evening. There are some exhibits that I'm going to have you take a look at. I always went home, always got my driver's license at home. Never once in any other state in this country have I ever gone outside the state of Indiana, and I want to make that very clear. I have always had my residence here, and I have a lot of family in Monroe County. My last name, Kinzer Pike, is named after my family, and I take a lot of pride in my family. And yes, I love my husband, and at one point he was a resident of Colorado, and he also is a native of Bloomington, or of Indiana. He was born in Greenwood, but anyways, I just want to say that emphatically, that yes, I went out there, I was participating, but I went back and forth, and my intent was to always return home, and I did return home often. So for your review, I've attached my driver's license, my car registration, my homestead property deduction, and my voting record. It's my entire voting record from the time I first started voting in the 90s. So you have that in your possession. I also have a statement, I don't know that we'll get to it, but it's from my husband. We got it notarized. He talked about the situation. So I guess I'll just leave it at that. And I also have employment in the state of Indiana here too. So, you know, if you want to see my W-2 from last year, you're welcome. But I just didn't want to throw everything at you. But that's all I have to say right now.
Any cross-examination based on the testimony she just presented?
I do not.
No, there's not any rebuttal.
I'll bring the public hearing on the matter, cause number 2022-03 to a close, discussion.
Well, my observation is that, Ms. Lowry, in your testimony indicated that Ms. Kinzer had returned to Indiana 10 months ago.
Correct, approximately.
So the requirement, it's not that she lived in Indiana for the 2 years immediately preceding the election, or people correct me if I'm wrong, the requirement is that she had lived in Indiana a total of 2 years, one of those years being the year immediately preceding the election. So by your own testimony, it would seem to me that as long as Ms. Kinzer remains in the state of Indiana through the election, that she'll satisfy the requirement of the 1 year prior to the election. And I don't hear you disputing her testimony that she has spent at least another year in the state of Indiana. So in my mind, it seems like there's, unless I am misunderstanding the law, it doesn't seem like there's a.
So 38114 is where it discusses representative in the General Assembly. A candidate for the office of representative in the General Assembly must, 1, be a United States citizen at the time of election, 2, have resided in the state for at least 2 years and in the House district for at least 1 year before the election, and 3, be at least 21 years old upon taking office as provided in Article 4, Section 7 of the Constitution of the State of Indiana.
Right.
So, are you saying that she's, are you agreeing that she returned a year before the election? Or are you saying she's never returned?
I would agree that she will meet the 1 year requirement, but I do not believe that she meets the 2 year requirement. In the Indiana Constitution, it states that it must be the 1 year next preceding and 2 years next preceding the election.
So she had to come back 2 years before the election?
I believe so.
Oh, is it, so it is consecutive?
Yeah, before the election is the.
Okay. Sorry.
Oh, sorry.
The Constitution is a little bit more clear.
Before the election is defined in 3811.7. As used in this chapter, before the election refers to a general, municipal, or special election.
So 2 years before.
Okay, so it's gotta be 2 years, so she has to have been in the state, been residing in the state for 2 years immediately preceding the election. In the House district for 1 year.
Can I talk?
Wait.
Oh, wait.
Okay.
That is how I understand the statute.
So what day,
May I talk?
so what day would she have had to be the latest?
So that'd be 2020, November of 2020.
2022 to this day.
Okay.
And she was in Colorado, clearly saying that she lived there. That test, that
Term reside.
reside 4/15 of April 15th of last year was when that meeting.
I called it home because it was my temporary home. My real home is Indiana. That's what, okay.
This is one of those joyous situations. where she has presented documentation that she has attested to under penalties of perjury, that we are supposed to draw a presumption that that's where she lives, her driver's license and that type of thing.
Although I will note that her driver's license was issued November 16th of 21.
But she's
which
got
isn't a
2
full-
copies.
Which, that's not a full year.
I put both copies.
She's run
Where's the
received
issue
right
date on
before
it?
that.
Okay.
Yeah.
I understand.
And then we have this tape where she says that. What year did your husband run for city council in Woodland?
I think it was, I don't recall. It's like 2020 or 2019 or something like that.
Did you vote for him?
No, I've never voted anywhere else. I've only voted in Indiana, and I would come back and forth to Indiana. I did not stay out there, although I said that in that video. I was back and forth. I have a huge family in Bloomington, and I have a home that is mine and Jim's
So
now.
are you misleading to the folks in Colorado, or are you misleading to us right now?
No, I don't think I was misleading to either one.
You
I
just
mean,
said you stated what you did.
yeah, I did. I mean, I did stay there, but I came home often. I maintained my home everybody in Woodland Park knew that I had a home in Indiana and that I loved it. I didn't make that.
Well, I've closed the public hearing on this. I think it's your end.
Isn't there another presumption that when your immediate family?
What is what?
Presumption about where your immediate family resides and that's your residence.
So your husband was a Colorado resident, correct?
At one point, yeah.
Do you want the statute on immediate family? It's 35511. Location of immediate family as residence. The place where a person's immediate family resides is the person's residence unless the family residence is a temporary location for the person's immediate family or for transient purposes.
Yeah, immediate family from your husband.
Is an RV a temporary residence?
Well, not according to court, typically family.
Mr. Chairman, if I might too, just for your decision-making, just to piggyback on co-counsel's comments, 3-5-5-0.5 defines immediate family for purposes of this chapter, which says an individual's immediate family includes the spouse, children, stepchildren, parents, or grandparents of the individual. If that's helpful to you. I don't know that it is. There you go.
Well.
So where do you file your income taxes?
In Indiana.
Where's your husband file his?
Well, he's a resident here now too. We're completely back here. But he's filing in Colorado at times, but I'm here in
So you don't
Indiana.
file joint
No, we have it at times, yeah.
at times, but when he filed in Colorado, you did not file joint. Is that what you're testifying to? here?
Well, I'd have to refer to him about it. I really honestly, I just got married in 2014. I've just kind of been enjoying life with my new husband. So I don't know
In
how.
8 years, he's not new anymore.
Well, he's not new anymore, but it's been really wonderful. We just took our RV out there and I live life and I just want to come home and run for state rep. To serve my state.
Challengers offered some evidence that she would not meet the timeline. And I'm not necessarily hearing that refuted.
Well, I think though she has said, she said because she said what, she had to be back here by what? November 1st or after that of 2020? She had to be back here by then?
Colorado was April of 2021.
But that's November.
My presumption is when you provided testimony in Colorado, you were sworn.
Oh, 2021. Yeah.
I make a motion that the challenge is upheld. Is there a second?
Second.
Any further discussion? Hearing none, all those in favor signify by saying aye.
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 No.
The ayes have it, the challenge is upheld. The election division is directed not to include Myra Kinzer on the certified list of primary candidates sent to the county election boards, indicating the name of this candidate is not to be printed on the ballot. Thank you. Next case, Waddell V. McClure, cause number 2022-07, the matter to challenge James R. McClure Jr., candidate for Republican Party nomination for Indiana State Representative District 71. McClure here. McClure, going once, twice, 3 times. The record will reflect that Mr. McClure is not present. Given that, would you like to use your time, or?
I'll just very briefly state your name. Is Josh Waddell, Waddell. This is a very direct challenge, and as someone that's also been here since 1 o'clock, I appreciate the virtue of brevity. I have the voter profile from the Clark County Clerk of Courts for Mr. McClure, indicating that he's voted in every Democratic primary since 1992 and has not voted in any Republican primary, has not received a county challenge.
Thank you. I'm going to close the public hearing on the cause. Case number 2022-07. Is there any discussion? I have a motion to uphold the challenge. I'll second it. Any discussion? Hearing none. All those in favor signify by saying aye.
Aye.
The ayes have it. The challenge is upheld. The election division is directed to not include James R. McClure Jr. on the certified list of primary candidates sent to the county election boards and indicate the name of this candidate is not to be printed on the ballot.
Thank you.
Cause 2022-28, Duckworth v. Whitley, and 2022-25, Beck v. Whitley, in the matter challenge to.
This is our last one, right?
Yes, yes. Oh, wow.
To challenge Whitley for what offices? State Representative District 77. Consent to combine these, given that they're on substantially identical grounds. Consent. We have Ally Bartlett and Joseph Beck.
Mike Duckworth.
Duckworth. All right, state your name.
My name is Michael Duckworth, MICHAELDUCKWORTH. I am currently the chairman of the Vanderbilt County Republican Central Committee. I'm here today because I want to exercise, excuse me, the fact that Mr. Whitley has not met the requirements for candidacy for state legislature District 77 in accordance with IC 3-8-2-7. We have a record here that's been obtained from the Vanderbilt County Election Office that shows that there's only been one primary voted by Mr. Whitley, and he has not received a waiver from us. So he has not met the requirements of that state statute. Therefore, I would ask you to refuse his appearance to run for that office.
Okay, thank you. Do you have anything to add, Ms. Bartlett?
Apologies, I'm just here as counsel.
You have 2 minutes of cross-examination related to the statement's testimony made.
Okay.
You like it?
Yes, I would like to do that.
What's your questions?
Do I get to speak?
After you're done with your cross-examination?
Do you want to leave your cross and just go to your?
Yeah, it's been a long day. There's no, let's keep it short and simple.
Okay, go ahead.
Well, I thought she was asking, do I want to skip this skip this cross-examination?
She did.
Yeah.
Yeah.
Skip the class and go up to your.
Statement? Yeah. Okay, good. Okay, awesome. My bad. Okay. My name is Gabe Whitley from Evansville, and I'm here to represent myself being challenged in today's hearing. It has been brought to my attention that the Vanderbilt County Republican Chairman Mike Duckworth for the Vanderbilt County has challenged me due to Indiana's new unconstitutional state code, IC 38-27-7-4, states that must have voted in 2 previous primaries. I ask that you, as you know, our board, dismiss these challenges for the following reasons. First, in the Indiana Constitution, Article 4, Section 7 supersedes Indiana Code 38-2-7-4, have voted in 2 previous primaries to run for state rep. Indiana Constitution Article 4, Section 7 says no person shall be a senator or a representative at the time of his election is not a citizen of the United States, nor who has not been for 2 years next preceding his election, inhabitant of this state, and for 1 year next preceding his election. Inhabitant of the district whence he may be chosen, senators shall be at least 25, and representatives at least 21 years of age. I meet the constitutional requirements to run for office that is necessary. If the Vanderbilt County Republican Party and the Indiana Republican Party and the Democrats want their Indiana Code 8-27-7-4 to be official and not violate the Indiana Constitution, it needs to be approved in 2 separate General Assembly elections and then approved by the voters for it to be constitution. Currently, this violates our Indiana Constitution, and the General Assembly established this law illegally without the due process, like I have said above. And
I'm gonna.
Go ahead.
I don't mean to be rude.
Oh, you're okay. It's been a long day.
But you're making a similar argument that's been made a few times before, why there might be some level of empathy or sympathy for your case. We're not here to change Indiana statute. And that's really what I hear you asking us to do.
What I'm hearing from you guys, what I have accumulated since 1:30 p.m., that you guys have previously and continuously violated the Indiana Constitution, Article 4,
Then I would
Section
suggest that
7.
your remedy is in a court of law.
Okay, then we will take it to court. And then what will happen after after we were denied, everybody that was denied candidacy, when we take it to court, what would happen then? Who would be held accountable? What would happen then?
So I guess we'd have to wait to see.
So would the election board be at fault for then, when we take it to court and when it's find out that it's?
Court will decide.
Okay.
Do you have anything further you'd like to offer?
No, I'm okay with that. Yeah, I'm okay with that.
I just.
No, I get it. It's been a long day.
Yeah, you're gonna make an argument that you've heard half a dozen times today.
Yeah.
We're gonna be consistent.
Oh, yeah, I assume
You may not
that
have
you
proven a
guys.
lot today other than that.
No, I get you. I assume your guys' job is to uphold your donors and your guys' the unlawful constitutional. No, I'm right. And that's why you guys are going to protect that Indiana
Okay,
code.
Mr. Chair, now you tell me, as a lawyer who practices constitutional law, why what he's saying is wrong. We don't have a choice because there is a law that says this is what you have to do. We have no authority to make a constitutional determination as to whether it infringes upon any of your constitutional
And
rights.
I understand that.
And so what he is saying to you, our chairman is saying to you, is that if you want to make that challenge, you need to take it to court and get an order from a court, a declaration that that statute is unconstitutional. But don't sit there and tell me or these people, after we've been spending all day working on this and trying to be fair, that we're sitting here protecting somebody's interest and money, because we are not.
Public opinion would display differently, and the court records
Why
as
don't you
well.
stop while you're ahead?
Okay, you got it.
I just respectfully request that the commission rule him ineligible for this
It's already clear. I'm going to close the public hearing on the matter. Is there a motion?
I would move to uphold the challenge.
Can I ask a question?
No. Is there a second?
Actually, help
Second.
end up for an oath of what you testified with it. So I have a question.
You're not a part of these proceedings?
Why am I?
Because you're not.
Are you a candidate? Are you a challenger?
I'm a candidate.
In this cause?
No.
No, he's not, no.
Then no. I have a challenge to uphold a motion to uphold the challenge. I have a second by myself. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
The ayes have it, the challenge is upheld. The election division is directed to not include a Whitley on the certified list of primary candidates sent to the county election boards and indicate that the name of this candidate not be printed on the ballot. With that concludes the business of the election commission for today. Is there a motion to adjourn?
So moved.
Second, all those in favor signify by saying aye. Aye. We're adjourned.
Thank you.
Thank you all.